hearing of the Parliamentary Joint Committee on Corporations and Financial Services into the Financial Services Regulatory Framework in relation to financial abuse. I begin today by acknowledging the traditional custodians of the land on which we meet and pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing in person and via teleconference. These are public proceedings being audio streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they're protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. The Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. A copy of the order is available from the Secretariat. I remind any committee members and witnesses who are appearing via teleconference and who are not speaking to mute their microphones. I now welcome representatives from the Customer-Owned Banking Association. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Michael Lawrence, Chief Executive Officer of the Customer-Owned Banking Association.
Darlene Matisky-Wood, Director of the Customer-Owned Banking Association Board.
Thank you very much for being here. I now invite you to make a short opening statement, and at the conclusion of remarks, I'll ask committee members to come forth with questions. I'm sure there are plenty. Do we have a copy of your opening statement at all?
I believe so.
Great.
I believe it's been sent through.
Okay, if we could get hard copies of that, that would be helpful. Thank you very much. Over to you, Mr. Lawrence.
Thank you, Chair. And thank you for inviting the Customer-Owned Banking Association to provide input to this inquiry. As the Chief Executive Officer of COBA, I'm here representing 55 customer-owned banks serving communities across the country. I'm joined by Darlene Matisky-Wood, appearing in her capacity as a Director of the COBA Board. Darlene is also the CEO of Australian Military Bank, a COBA member bank that has provided services to the Australian Defence personnel and their families for 65 years. COBA members are mutual banks, credit unions, building societies. Collectively, our banks serve 1 in 5 Australians. Half of our members are headquartered outside of metropolitan Australia. The customer-owned banks punch above their weight when it comes to branches and face-to-face banking. Our banks operate 18% of all branches, while only holding 5% of the mortgage lending market. While some of our members are sizable in their own right, there is a substantial difference in the resources available to the major banks compared to our members, with our largest members being less than 3% the size of the largest bank. Our members are brought together by their ownership model. As our name suggests, the customer is the owner and the centre of everything our customer bank does. The mutual model puts customers at its core. Customer-owned banks are committed to protecting customers experiencing vulnerability. Our commitment is through the Customer-Owned Banking Code of Practice that clearly and transparently outlines what customers can expect when dealing with the code subscriber. The Code of Practice establishes higher standards than the law requires and reflects our sector's commitments to its customers. It includes explicit commitments to adapt customer service standards when aware that a customer is experiencing vulnerable circumstances. These include age-related impairment, elder abuse, domestic violence or financial abuse. Code subscribers also commit to training staff on how to identify customers experiencing vulnerability and how to adapt customer service in a sensitive and helpful way. Training includes awareness of vulnerable circumstances due to domestic violence and elder abuse. Banks play an important role in identifying, preventing and responding to financial abuse. We note, however, that this is a sensitive and complex issue, and it is crucial that all stakeholders that play a role, including banks, government agencies and community organisations, and that we work collectively or collaboratively to tackle it. Our members identify customers experiencing vulnerability by looking for triggers that may indicate financial abuse. Some of our members can refer customers to specialist vulnerability teams within their bank, and our members commit to training their staff to identify customers experiencing vulnerability and to adapt their actions accordingly. Our banks are taking steps to protect customers and stop their products from being misused by perpetrators. The shift to online banking environment has created additional challenges for banks. Generally, there's been a rise in abusive transaction descriptions and family members transacting on a victim's online banking account. There is also less opportunity for bank representatives to use traditional face-to-face channels to pick up on financial abuse indicators. Our recommendations are detailed in our submission and include our support for regulatory guidance that clearly sets out the role of banks and empowers banks to better identify, prevent and respond to financial abuse. We support an overhaul of the state-based legal framework for authorities for documents such as powers of attorney, and we encourage the implementation of nationally prescribed documents and national searchable register. In banking, we often speak of ecosystems, recognising that banks are part of a solution in collaboration with other parties. We support ecosystem collaboration across the banking and payment system to address technology-facilitated abuse, such as the weaponisation of transaction descriptions to send abusive messages to victims. Darlene and I appreciate the opportunity to contribute to this parliamentary inquiry, and we welcome your questions.
Well, thank you very much for the opening statement there, Mr. Lawrence, and can I thank you for your very comprehensive submission as well, submission number 115. And for those who are listening in across the country, that'll give you a bit of an indication of how much interest there is. I want to particularly acknowledge that this committee has adopted this inquiry unanimously, but the conceiver of its timeliness is my colleague who's sitting here with me, Ms Zanetta Mascarenas from Western Australia. I'm Senator Deborah O'Neill, a senator for the Labor Party from New South Wales. We are very keen to hear further from what you say, from what you've put on the record this morning. Can I go to one of the first issues that you raised, which is the changing technological reality of the time, which has led to incredible efficiencies in banking, but also exposed a front for deep and very disturbing forms of abuse for individuals in their own home. There are well over 115 submissions, and amongst them is a series of submissions from reference groups, community advocacy groups who describe in horrifying detail tens and tens of cases of coercive behaviour, with women in particular being forced to sign documents in the privacy and what you would hope would be the safety of their own home, which are then enabling of the coercive behaviours that we know are causing such damage. What is the solution to the imbalance that is now manifestly there with regard to digital banking, advantages versus disadvantages, and actually people getting to a branch and being observed and jointly having to sign in physical and real time major documents or even withdrawals for joint accounts? Mr. Lawrence.
Yeah, there is no doubt that as we move into frictionless banking, such as online, it has certainly exposed weaknesses and in the area of financial abuse and other areas more broadly. The days of people having to walk into a branch and have those face-to-face conversations where you can pick up on some of these triggers disappears when you're dealing with online, and the ability of people to access products and services via an online system without ever needing to engage physically branch staff or banking staff. So we've then also seen, as a result of online banking, the incidence of transaction descriptions which are abusive in nature. So, how do banks then flag that and shut that down? And then there's people...
Lawrence, before you jump off those two things,
Yep.
That's a description of the problem. I know that in some banks, the process of... So for people who are listening and don't understand, like when you transfer money from one account to another, you write a little description in there. Some people who might transfer, say, $150 payment for child support, no longer in touch with the victim, survivor that they were abusing in any other way other than through this bank transaction, could put 150 transactions of $1 through and write all sorts of horrendous descriptors and attack lines. Is that still able to happen in your COBA suite of financial service providers, or have you ceased that?
It can happen, but they're monitoring it and blocking it. And so they are taking action to shut that down.
And can you guarantee that nothing's getting through, or is it still a faulty system?
Look, I can't guarantee that it's not happening across 55 customer-owned banks when we've got some that are very, very small and may not have the investment in some of the technology, but the advantage that they've got is they've got very small customer bases and they know their customers quite intimately. So that is an advantage to them, but I couldn't categorically say it never happens. Yeah. But I know that our banks are doing everything they can to shut that down, to put systems in place that monitor transactions, monitor descriptions. They put red flags up. There is obviously compliance training that happens across the entire network for all members. There's large transaction monitoring. There's a whole series of things that they are doing to prevent this financial abuse.
And I can add to that, also contacting the perpetrator and threatening to block the account as well. So each of the banks have their own individual systems, which is why actually having something uniform isn't exactly easy. From a regulatory perspective, all of the banks are required to implement regulatory frameworks, so anything that is mandated certainly is then implemented as essential.
Is the problem that we've just described, is the fix for that mandated currently, or is that optional?
It's not mandated, no. And so the other aspect is that many of the banks actually have the capacity to, even though there's the digital move to digital, the opportunity to actually implement virtual meetings. And so, for example, if there is a concern that a member or a customer is at risk, insisting that you actually meet with the member. It's much easier in the smaller mutual banks because they have a number of branches in those regional areas, and yes, they do foster customer service and relationship building, so they do know their members, and they also don't always push for everything to be digital. Part of a point of difference in the mutual banks is that relationship building, so they want to actually get to know their members and customers. There have been instances of staff offering to go out to the home or to meet with them somewhere near the home so that they actually get that face-to-face meeting so that they can determine whether or not there's a risk, or offer for a digital face-to-face, so that they can actually engage with customers and members. And importantly, that aspect of the face-to-face, in a lot of the mutual banks, they actually say, we need to have your spouse or your partner or whoever, we need to have them come in to do the signing. So not everything is straight through processing where it can automatically be done, where you don't see anyone. And that takes away, as soon as that happens, it does take away that relationship. There is an additional cost to being a mutual organisation where you foster relationships and you foster customer service as a point of difference. And it does mean that our staff do have a lot more understanding of whether or not there's an issue that needs to be flagged and addressed.
So, you know, I understand the uniqueness of the relationship, and the model that you're operating is quite different from the banks. I mean, there's advantages and disadvantages, I think, for people who are likely to be subject to abuse in both of those systems. One of the things that I've read overnight in the Commonwealth Bank submission is an AI tool. Clearly, AI can be a force for good or bad, but when it is observing transactions and able to identify particular sorts of behaviours that are red flags, you've indicated you put red flags, the observation of AI across a lot of data is a faster, potentially very productive way to identify where those issues are. Have you had any conversations with the Commonwealth Bank to use that technology in your system?
Not necessarily Commonwealth banks, but we certainly do have a range of AI happening across the mutual sector as well in terms of their banking system. So,
AI specifically driven to identify financial abuse?
Yes.
Okay, so that's quite interesting. Are there any sort of research? Is there any research that you know of that's comparing the effectiveness of different models?
Not that I'm aware of.
Okay, so there's a bit of data poverty and a little bit of blindness. I'm going to ask one final question, then I'm going to go to my colleague, Ms Mascarenas, for a series of questions. There's so much that I want to ask. But if I can go to the fundamental issue for me is the difference between what happens when there's a scam and when there's fraud identified, and how that triggers a criminal investigation, a style of criminal investigation. And that triggers a certain set of behaviours from the bank. And it interacts with privacy and reporting in a way that seems to me quite different from what happens when economic abuse happens inside a relationship between a partnership, partners, spouse, families, where they might have multiple investments together. That kind of has got this secret carve out, and it seems that people are taken as responsible for what happens to them when they are literally assaulted financially by somebody in their cohort, in their family, or in their intimate partnership group. My concern is that is akin to what we used to do with physical domestic violence. That, it's just all in the family, just leave it there. What are you doing in terms of prevention and product creation and practical engagement with people to really change that dynamic from blaming the victim and, you know, getting the ambulance to the victim at the bottom of the cliff, which is better than nothing? What's happening at the top of the cliff is what I really want to know.
Yeah, so there's things that we are doing within our control, such as looking at the terms and conditions, and our members are changing the terms and conditions to be quite explicit around abusive behaviour.
So does it say things like financial abuse is, you know, how you have all these descriptors of you know, financial abuse is this. If you use financial abuse, you will. What consequences follow? Is it that clear?
Yes, and look, it varies from member to member in terms of what they have in their terms and conditions. There's no standard that is applied across all of them, but some of them are quite prescriptive in terms of what it means and the action that the bank will take.
So do you
as a
think
result of it.
I understand how those things can grow up independently and different. Do you think it's good enough to have all those different variations? consider, like, abuse is abuse, really, isn't it? Like,
Well, I think this is where we're calling for better guidance around.
from ASIC, APRA?
Around what are the bank's role in financial abuse?
And who would provide that to you, Mr. Lawrence? With
Well, I
authority?
think it comes from the regulators. I mean, ASIC play a key role here, so I think ASIC needs to. I mean, there are, as you would see in our submission, there are things that we can do and are doing, but there are also things where our hands are tied because of legal restrictions,
Yep.
because of regulation.
So privacy is one of the
Private
issues.
privacy is an
The
issue.
interaction with the family law system seems to be something that we
Correct.
hear
Yes.
quite a lot about. Debt collectors going
Correct.
and finding a woman particularly in incredible financial distress who agrees to become bankrupt, and that really significantly disadvantages that person then in terms of assets, holding on. All of this is going on. It's happening everywhere. What needs to happen, Mr. Lawrence, to interrupt this, to prevent it?
Well, we always in banking talk about the ecosystem, and the ecosystem includes other stakeholders than just banks, and in this case, government,
Yep.
regulators, as
Yep.
I've said. So we need to look at responsible lending standards, obligations. We need to be able to look at the Privacy Act, to be able to talk to third parties. As I said, when it's within our control, we will act, but we are also need to act within the law, and so changes need to be made. We haven't spoken about powers of attorney at this stage,
Yes.
but
there's no national register. It's
There is
very
no
from
national
state to state.
register.
You don't know what's going on from one place to another.
and it creates complexity
Yeah.
as well when you're dealing with state by state rules and regulations and laws.
Which are
And
quite differentiated from state to territory, is that correct?
it does differentiate, and so it becomes complex. So, we are calling for a national registry.
But also recognising financial abuse as a crime across all states. It's been recognised in New South Wales in July, and I think Tasmania is the other state. Actually having financial abuse or economic abuse as a crime
Yes.
then actually starts to change and give more powers to report crimes. At the moment, privacy rules make it very, very difficult, and also being able to, where there is recognised financial abuse, take someone off of a lending product. So, for example, most financial institutions, not all, but most of them, where you have your name on a mortgage product, it's deemed that you're responsible for the whole debt. So the two parties independently are responsible. Actually changing the legislation so that you can take someone off of that when there's obvious financial abuse would support and stop that that horrendous debt that they might be left with.
So there's a couple of things there. Originally, you could actually have it so that people, and especially if you're putting in a large sum of money, that 80% of it belongs to you, and that, you'd have to have joint signatures all of the time. That's one way of thinking about it. But the other way is to do exactly what you've said, and when it becomes clear that a perpetrator is responsible for malign action in and around the accounts, that the debt falls to them, and then the capacity to refinance for the victim survivor becomes a possibility.
Yes. So they actually are taken off that, and then they don't end up with a bad debt scenario and a huge debt to pay. They're in a situation where that person that actually incurred that debt is responsible for that, and that will require actually some changes in regulations to make that happen. That would support also making sure that economic abuse or financial abuse is a recognised crime in every state. That's, I think, quite critical to this, because it does then
Does it
give
need a
additional
register
powers.
so that people who are found to be financial abusers are known wherever they might go, whether it's one of your small regional COBA partners or...
Well, if it's a recognised crime, then they're automatically, if someone is actually found guilty of financial abuse because it's a crime, they're all automatically on a register. That then might facilitate actually being able to check before that person goes and actually tries to take out another loan. They've actually been found guilty of financial abuse. So setting that up. Then, of course, you mentioned previously the court system. I know that a lot of people stay in situations like this because when they go to leave is when it becomes most dangerous. So financial coercion and financial control is one step, but there's such a long bow. So it starts off as caring and taking care of all of the financial accounts in a care capacity, in a spousal situation. And so an individual the victim might be saying, well, that's lovely that they're good at that, I'll let them do that. So they actually, before they even know it, they've been boiled like a frog, and they get to the point where it becomes incredibly violent and coercive. That's when they start to become endangered and start to realise they're in a trap. Then the thought of leaving and the attempt to leave or to change that is where they're at most at risk from physical harm. And then they actually try to instigate legal and court support. That process itself is so long, truncated, and so hard for them. The delays in that environment are horrendous.
Yeah. So it's completely at odds with the speed at which the sector moves, the finance sector moves, by comparison to the legal sector. And the intersectionality is critical. So there need to be some early responses to respond to the financial reality that don't have a long tail impact on the longer process of
Yes.
Yeah.
Yeah.
Okay, thank you. I'll go to Ms Mascarenas for a series of questions. Thank you.
So the number of member organisations you have, was that around 55?
55.
Yeah. Have you guys gone through a benchmarking exercise of your member organisations on their, I guess, activities around financial abuse?
We haven't done benchmarking.
Yeah.
What I can say, though, is 37 of them have received requests for submissions, so that will form a good basis for some benchmarking because we'll be able to, certainly as an association, get under the covers around what is happening more broadly across the sector.
And to some extent, one of the things that I think is the advantage of COBA is having that kind of wide-eye lens of what's happening, and it's good to hear some of the case studies and examples of what's happening. And the thing that I recognise is that people are on a different stage of their journey of how they're helping customers with financial abuse. It's probably something that I'd love to see more of. I think it's great that from your code of practice, that looking at vulnerable clients is something that's at the heart of your code of practice. I also understand that the ABA has got guidelines and responding to financial abuse. Do you have a sense of how many of your clients are following the ABA's guidance around financial abuse?
You go first.
I don't have the exact number, other than I know that many of them are following. This is the great thing about working in the financial services sector, where things are publicly available. So we do leverage the ABA's guidelines.
Yeah.
So yes, we could go and write our own. They'd be probably exactly the same as what the ABA has done. So those guidelines are out there for all of our members to use. The exact number I couldn't tell you.
Yeah, no, that's good.
I also note that that you are doing some work with Catherine Fitzpatrick following the publication of the Design to Disrupt report. Did you want to expand on that a little bit, on some of the work that you guys are doing in that space?
Yes, so we've promoted the safety by design principles out to our entire member base, and that's the work that has been done through the Centre of Women's Economic Safety paper that Catherine obviously is involved in, and it's that design to disrupt. So we've worked in with her on that, and also COBA sits on the board of the Financial Industry Council of Australia, which is the heads of the associations for financial services, be it the ABA, the Insurance Council, etc. And we've jointly, with the assistance of Catherine Fitzpatrick, signed up to or put some principles out there.
This is going to be another numbers question. So with your members, do your members maybe report numbers of people or customers that have experienced financial abuse to COBA?
Not to COBA, but
Yeah.
they have the numbers within their own organisation.
Yeah.
But they're not required to report anyway.
They're not required to report to COBA
Or
with the
anywhere.
numbers.
No one
Not
asked
that I'm aware of.
So
No
let's call that
one
a
asked for
blind
them.
spot,
Yeah. Yeah.
No one asked for them, but they do record it.
And this is following on from something that Senator O'Neill was talking about in relation to frauds, scams, and then financial abuse. And so a part of Catherine Fitzpatrick's research gave an indication of the dollar spend associated with frauds and scams, and I think it was in the order of $2 to $3 billion for frauds, and then $2 to $3 billion for scams. But for financial abuse, I think the number was around $5.7 billion. Do you have a sense of how much money COBA banks have tried to recover from perpetrators to victims? And I'll let you see if you've got a sense of that number.
No, I
For
don't.
fraud and scams?
Fraud and scams we do, but not.
Yeah.
Well, sorry, we don't even have it specific to the sector.
Yeah.
And we're digressing, but
Yeah.
I sit on the board of the National Anti-Scam Centre Advisory Board,
Yeah.
and we collect the data more broadly, and we know that in the past 12 months, 3.1 billion was lost to scams. We got those numbers from Catherine. To your specific question,
Yeah.
What's
that mean for our sector? I don't have that number.
Sometimes there's an overlap as well with the fraud. So, for example, if a perpetrator has actually attempted to forge a signature or something like that, it might actually fall into the category of fraud,
Yeah.
but it's actually not just fraud, it's actually financial abuse as well.
Yeah.
So there is an overlap there with those things.
From my perspective, I have and it's good to understand that intersectionality between instances where there is that overlap. What I'd say from a high level perspective, there is a concern that the bigger end of how much money people are losing, it's bigger in the financial abuse space, but it doesn't seem like there's I'm unsure of what the barriers are to actually claim that money, but it's a significant amount of money across the Australian economy. What do you think the barriers are to help banks? And I don't know if the banks are the right place to recover that money, but what tools do we need to recover?
Yeah,
Well,
legislation.
but also there's IDR, EDR, so it applies equally to financial abuse as it would to scams. There are internal dispute resolution systems and external, being the IDR, EDR.
You just want to put those acronyms in full on
yeah,
record? IDR?
Yep, which is internal dispute resolution.
And?
EDR is external dispute, which is AFCA.
Yeah.
Plenty of acronyms, but I think everyone knows who AFCA is. So there are processes that are no different that they can go through.
You also talk about reverse mortgages and talking about inheritance impatience. Do you have a sense of whether power of attorney relationships are a weakness, particularly in the context of elder abuse?
I think there is no doubt that there are clear examples of abuse through powers of attorney and elder abuse, and some of those examples that will be coming out through those submissions that you have been receiving from our members. So it's clearly a weakness.
I'm unsure if Senator Pratt wants to ask some questions. So
Senator Pratt, you're online. Do you have any questions for Mr. Lawrence or Mrs. Matiski-Wood?
If not, I'll keep on asking
Please.
questions. So one of the things that I'm curious about is the roles that you think that the banks can have from a public awareness campaign perspective. And I know that from a website perspective, there's information on staying safe online, and that's referring to scams. And I think that do you think that there's more public awareness that I guess anyone can be doing in this space?
Yeah, well, there's never enough public awareness that you could do in this area. In terms of what our banks are doing, as I said, there is compliance training. It's part of our code that they complete that training. There's internal fact sheets that they have in the branches. There's customer brochures that are provided. So there is a lot happening within the banks themselves, but it's a broader societal issue, and therefore I think that we need greater awareness. Interestingly, I've just come back from a scams delegation to Singapore, and it's also about how do you get awareness out there. And interestingly, they're trying to get into schools, into homes, and they get into homes by the example they used was you buy a carton of milk and it's on the carton of milk. So I think there are, and that's scams. Yeah. But why couldn't you apply that equally to financial abuse? And so I think, and that is being done in Singapore by the police. It's been done by the government, and it's done by the banks. Everyone's contributing to that awareness. So I think there are lots of things that we can do here across multiple stakeholders, but I think there's also good learnings abroad, not just in the financial abuse side, but areas that might be tangent to it that we could learn from.
Can I just add to that? In terms of broader awareness, and I think even starting before the financial abuse, I mean, women over 55 is the fastest growing group of homeless. There is a huge void of information around financial empowerment for women. And often what happens is that they actually don't recognise that they're being financially abused at the outset when, things might not be quite so bad. But that financial empowerment is what's really, really important, that it's taught at a very young age. If we can actually impart the importance of superannuation and the importance of actually having an understanding of what's happening in your own finances in a relationship and why that's critical, and actually being able to have responsibility for your finances, would actually support women when they're in that situation. They're not going to want to let that complete control be taken away from them. We teach children in schools about being fit and healthy, Kickstart and all sorts of things happen in the school environment, but we're actually not teaching women the importance of their own financial circumstances. And this superannuation and this fastest growing group of homelessness is also often connected to financial abuse and domestic violence. And these are women that are just being, that they think that they're okay. They think that they won't be in this situation.
Yep.
We've got to give them more education when they're really young.
Yep. Can I say to you as a teacher, I absolutely believe in, the democratic project of education and what it does. But when you rely on education, let's just go back to when you were at school. Everything you were taught, do you remember it all? Right? It's not a solution.
Yeah.
Right? It's part of a solution, but it is not going to be it. I want to ask about the interrupting of the behaviours. So what processes, if I can jump in now, what processes have you got in place if you see a spouse's superannuation land into their spouse's account? So, female withdraws her superannuation, gives it to the partner. Have you got any trigger that registers that?
So, well, that would come through as a large transaction.
Yep.
That the bank would monitor. So they.
But there's currently nothing that would say, okay, this is a very serious indicator of financial abuse. Raiding your wife's super is not going to happen. It simply is not allowed to happen if it's transferred to the husband or the partner. We've got no way of interrupting that, have we?
How do they raid the superannuation? I mean,
Well, they get somebody to sign under coercion.
I know examples of women that have gone through the settlement situation, and they are fighting to get their share of the superannuation months and months and months later. So I don't know how they raid the superannuation and then plug it in their account like that so easily.
But the people
I haven't
who
seen
do it
examples
know how to
of
do
it.
it, and it's happening, right? It's in evidence.
I haven't even seen examples of that.
Yeah, it's in evidence we've received. So clearly it is happening. We also have people who have been basically hounded to the point where they just have no hope, you know, and they ultimately, you know, die by suicide, and the person who's hounded them ends up with the superannuation because that's the arrangement, right? These are significant problems. But can I just go to the intersection with AFCA, right? People are in a world of pain, as you said, by the time they become aware of this. And I'm not going to exclusively say it's women, but predominantly it is women, right? So we've got a case study of a, not the correct name, person called Kiara in this example, pressures her to take out 2 loans. And you think, how does that happen, right? Could it happen while somebody's doing a virtual meeting? Absolutely, it could still happen, right? You haven't got them in 2 separate rooms telling you the truth about what's going on. You're not eyeballing them like a real person. At the moment, just by signature, it's happening, right? So electronic signatures, big problem. We need some response to that. Take out 2 loans with the same bank in the space of 3 days, totaling $40,000. Then immediately took the funds for his own benefit. She's 19 years old, low-paying trainee. She seeks assistance from Community Legal Centre going, well, this can't be right. Lawyer makes a responsible lending complaint to the bank on the basis that the loans were unsuitable for her under the NCCPA. Complaint was not resolved through internal dispute resolution. They don't think it's their responsibility. She signed the documents. And it was escalated to AFCA then. So the bank continues to ask for evidence of Kiara's current financial hardship throughout the whole process. So she's constantly having to talk about her financial hardship. The perpetrator of the abuse is home and host, scot-free, already spent the money. And despite the fact that the complaint was based on the alleged breaches of the bank's responsible lending obligations, and Kiara's financial position wasn't relevant, it just keeps on, this process. Kiara's lawyer provides the requested evidence of her financial hardship, but inquires about the maladministration investigation that the bank informed that they'd commenced. But ultimately, nothing happens with the maladministration. The bank offers to waive the outstanding debt based on her current hardship. She goes, I can't do any more than this, accepts it and walks away. The lawyer who doesn't have to do this is at some cost to the lawyer, which would be part of the $5.2 billion that this abusive behaviour is costing the Australian economy. The lawyer continues to press for the outcome of the maladministration investigation, never provided. Even a lawyer who's not under financial pressure and duress can't get the system to work, and that is the point at which the bank would be held accountable, or the customer-owned banking entity. So whoever lent this money to Kiara gets off scot-free. All they've done is seek to recover the funds for themselves, and then it looks good on a report that they've waived this debt. But the perpetrator isn't anywhere in the ecosystem.
I don't know how the loan would get approved in the first place, but again...
But this is the problem, isn't it, Miss
Yes.
Matisky-Wood, right? That people of goodwill and good intent don't look at these products for how they can use and abuse them, right? You look at a knife and you think it's for cutting things, you know? People with malign intent look at a knife and they think it's for hurting people. We've got products there that are weapons. that are weapons being used against one another, by perpetrators against victim survivors, that are physical, psychological and financial. And I hope that you're up for the change that I think is necessary, because you certainly indicated a lot of areas of change in your report. But this whole psyche of the malign actor doesn't seem to come into the product design. Is that a fair comment?
No, I don't think it is fair, because as we've put in our paper, we are looking at the terms and conditions. I mean, you use the example of the knife, and even the example of products and services being weaponised. Absolutely agree. Solution is not to remove them. It's how do you mitigate the risk. So how do you mitigate the risk with the knife, where most people spread their butter and cut their vegetables with it, yep, versus this, where we actually can take some action, and we are, through the terms and conditions as it relates to the products and services that we provide.
But that's really differentiated across the sector. Some are doing it, some are perhaps not, some are doing it well, some are doing it poorly.
Well, I think there is a level of maturity that does differ, but we need to also realise that in our sector, the size of some of our members, which may not even employ even 10 people, and they're being run as an authorised deposit-taking institution with all the costs of regulation and compliance, on top of your scams, you're finding, I'm not making excuses, but there is a capacity issue. It's not that they're not up to the challenge, but these things do take time. They don't have the AI technology, but as I said, they can mitigate a lot of it because they know their customers. So there is not a perfect one-size-fits-all for this when you've got organisations right across the country in terms of different sizes and models.
They also don't have electronic signatures, so they do actually bring their members directly into the branch, and it is a practice that they'll separate the two if they think that there is a risk, and they're trained to do that.
So do you think a recommendation that would require financial institutions to report on the proportion of complaints alleging financial abuse which are resolved on the basis of financial hardship alone, compared to the proportion of complaints which are resolved on the basis of misconduct, maladministration or other fault of the financial institution, should be the new standard for reporting?
So long as we can do that under privacy,
yeah,
and there's it's mandated, absolutely, because there'd have to be some changes for it to be able to do that.
Yeah. Okay. Thank you. How aware are you of outright fraud and identity theft, where victim survivors' details have been used online for, and created a fake electronic signature? What's the scale of that problem, and are you able to give us a sense of it?
You can talk about the scale, but we certainly have a lot of systems in place.
Forgery without knowledge and consent.
I don't have the details of the scale across the entire sector.
But certainly we are required under regulations to have our systems in place to detect and respond to that. We have active teams that are consistently working through that, and our systems are set up to detect and respond. It's ongoing, moving feast of continuing to actually update systems and move with the regulations and detect and respond.
Does it concern you that fraudulent actors can move much more quickly than the systems that we're seeking to
yes,
prevent them with? Yeah. So one of the things that we see is, I think there's even movies about it, where you get people in to try and hack into the system, like, hackers who were the baddies come over to the good side in the movies, right? And they save the country by getting in and doing the, advanced attack, hack, find out where the weaknesses are. Are there any testing of the weaknesses in your system? Who have you got employed to do that?
So internally, Yeah, also you can talk about Leanne and the fraud team and support. So internally, all banks have their own teams internally and also work with external parties. Banks have different systems.
When you're talking about external parties, are you talking about consultancies?
Consultancies, audit firms.
Yes, I have some major concerns about the quality of what the consultants that they send out to do these jobs.
And it does depend on also having an understanding of, so for your core banking system, who do they actually use to protect? So where the system is developed and what they have in place as well is critical, having that understanding of those third parties. But also, do you want to talk about COBRA's support around fraud and financial crime as well?
Test and detect capacity, yeah.
Yeah, and there's a lot of pen testing goes on where your systems, they look to penetrate your systems, look for weaknesses. So all organisations do that through third parties who are qualified in that area. We also have within the association a fraud and financial crimes team that supports our members, acknowledging that our members are relatively small. Yep. So we have that unit.
So the fraud and financial crimes unit, how much of their work is financial abuse? How much of it is other kinds of financial crime?
I couldn't give you the number.
Do you keep that data?
I would take that on notice.
Because, Mr. Lawrence, what I put to you and what I fear is that the types of financial crime that is investigated would be triggered immediately by loss to the bank. That'd be the first layer. The second layer would be what we're required to do about scams and fraud, because the law has moved in that direction. But what we're required to do about financial abuse would be a low order.
Well, it's an overlap, isn't there?
Well, that would be lucky for some individuals if there was an overlap, but where it's not fraud, but it is coercion, that would be a problem. I think we're out of time. Can I just put a couple on notice? Amongst the submissions that we've received is one that talks to a model of how to respond to domestic and family violence. The first model is called cold referrals, which is here's a service that will help you. The second one is warm referrals, make appointment, provide client, situation, detail. Model 3, co-location and outreach, where you start to wrap services around. Model 4, integrated, highly coordinated and collaborative. And Model 5, accounts. Could I ask you to take on notice how differentiated your support is? Like I've called it at the bottom of the cliff type support for the most part. Much of it is cold from report, but it certainly doesn't represent best practice in terms of domestic violence response. Where there is a whole body of work that's done with physical domestic violence. It's quite different, it seems to me, from what's happening around, hardship response. You're in a point of pain and trouble. We're going to kind of interact with you, but it seems like it's a much, much more sophisticated level of understanding of the types of need. And can I put it to you that in one of these case studies, I couldn't put my hand on immediately. It was so complex. It took 24 different entities to unscramble the type of abuse that a particular woman was subject to by a very sophisticated partner in life, right? So we are talking about, small amounts to like multi-decadal impacts of losing a house, kids having to move schools because of malicious action and failure to interrupt and detect early. So if I can, you're the first witnesses from the entities. I hope others have listened to this. I think we've got a massive problem that we're really only starting to culturally become aware of. And once again, I give kudos to my colleague, Ms. Mascarenas, for really bringing this to our attention. Did you want to put anything on notice? Okay. All right. Well, can I thank the witnesses from COBRA for being here today? And offer you encouragement to all of your members to even more heartily engage with this than they already are. Committee obviously will be making a number of recommendations. If I could indicate that there are already a couple of questions I noticed, and there may be more. Could you provide responses by the 5th of August? Thank you very much. I now welcome representatives from the Financial Counselling Australia and National Debt Helpline.
I need to solve this question.
That still was showing us online, but now she's stepped away from it.
Welcome. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to the Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Dominique Mayrick, co-CEO of Financial Counselling Australia.
And Peter Gartland, the other co-CEO of Financial Counselling Australia.
Thank you very much. I now invite you to make a short opening statement, and the conclusion of that, I'm sure we will have questions. And thank you for providing a physical copy for us as well.
Thank you.
Dr. Mayrick.
Thank you for the opportunity to appear before this parliamentary inquiry. We are here today to speak as the co-CEOs of Financial Counselling Australia, which is the national peak body of the financial counselling sector. There are approximately 1,100 or 200 financial counsellors providing one-on-one, free, independent support and advice to people experiencing financial difficulty across our nation. Financial counsellors operate in diverse settings, whether it be on the National Debt Helpline, answering phones or answering chats, or face-to-face in remote, rural, regional and metropolitan Australia. Despite these varied contexts, they report a common thread. Financial abuse is a significant factor in their casework. Financial counsellors often see clients who are burdened with multiple debts owed to different creditors. And the inconsistency in responses to financial abuse increase the workload of financial counsellors, but more importantly, significantly increase the distress experienced by clients. Although recent changes in banking, family law, social security are positive steps, they're just the beginning. Financial counsellors tell us that there's still much progress to be made, and our submission highlights that an effective response to financial abuse requires an attitudinal shift in two directions. The first is the recognition that financial abuse exists and understandings of the significant harm that it causes. And the second is the understanding that everyone in our community, including those from in the financial services system, has a role to play in preventing and addressing it. We'd like to see a number of things. First, better cooperation and consistency across the responses to financial abuse. Also, organisations need to establish specific and public family violence provisions that address financial abuse and make reference to financial abuse, and also a stronger emphasis on preventing the misuse of financial products and services to perpetrate financial abuse. And then both prevention and responses embedded in the design of products and services. Our sector sees the consequences of a deep-seated assumption that an intimate partner are a single financial unit rather than two autonomous human beings. These assumptions can underpin our approaches to taxation and to government services, to social security, and frequently they disadvantage the most vulnerable party. Financial counsellors tell us that these systems, and particularly when children are involved, are not functioning effectively for the people that they are intended to serve. Financial counsellors, the people working in our sector, understand better than most how debilitating it can be to be in financial difficulty. Financial struggles limit freedom. They curtail or put obstacles in the way of options. They cause enormous emotional stress, and they often are accompanied by feelings of shame and humiliation. For perpetrators of family violence, harnessing these outcomes, using financial abuse, can be a very effective weapon of choice, and unfortunately, it too often is. We welcome this inquiry as a significant step in addressing what is a wicked problem. Thank you for your attention.
Thank you very much, Dr. Merrick, and I'll go straight to Ms Mascarenhas for the first lot of questions.
I note that we're in the middle of a cost of living crisis, and I feel like there's these big trends that are happening across the nation. Thank you for your detailed information on indicative stats on financial abuse, and I recognise that it's kind of indicative. Do you see this as something that's increasing in prevalence?
Well, we know that all forms of stress, particularly financial stress, tend to exacerbate family and domestic violence more generally. We're seeing increased demand for our services, so proportionately you're going to see more financial abuse. So, I mean, I have no hard data on that, as I've noted in our submission. But yes, we would see an increase. In fact, we had a meeting of the managers of the National Debt Helpline last week. So each of the services managers come together, and the Northern Territory specifically called out an increase of seeing domestic and family violence and financial abuse on their helpline.
I should add that so there's three kind of arms to financial counselling. One is the face-to-face services that are in community centres. The other is the National Debt Helpline, which is the national service, and then there's a small business debt helpline as well. So across all three areas we see definitely has been an uptick in from what financial counsellors are saying, particularly with women that are impacted by family violence and economic abuse. There's absolutely no doubt about that. A couple of stats that might be relevant. There's on average, we have a web page as part of our National Debt Helpline website, and at the moment there's 1,000 hits on that web page every month.
Right. Okay.
We estimate we've received about 71,000 calls this year to date. Again, the financial counsellors on the phone lines would estimate that approximately 10% of those would be presenting, and be aware that of course that the financial counsellors on the phone are quite careful in terms of what they ask, so there's definitely an underrepresentation. But probably importantly, the face-to-face services that pick it up a lot quicker definitely is saying that at the very least 30% of all their cases are involving some level of financial abuse. So we can't quite compare to your question, you know, a couple of years ago, say to now, and the cost of living increased. But we do know just generally that across the board, and I think it was reported in The Age this morning, that across the board we're seeing to date, I think about 70,000 calls, which puts us back to 2020 levels. So the cost of living increase is definitely impacting requests for support.
I commend the work that financial counsellors do. They play a really important role in our community. One of the centres that I went and visited when the 7:30 report did an interview, we went in at the beginning, and before we went in, there was someone seeking food assistance. By the time we came up, there was a lady sitting there, black and blue, waiting for the assistance that she was going to get. And so I recognise that there is so much that you see. One of the things that's one of the terms of reference for this committee is around the funding and operation of relevant advisory and advocacy bodies. Are you guys adequately funded to be able to service the number of people that are seeking your assistance?
Well, I'll start, and Dominic can add. There's been some important increases in funding in recent years, both in the state government here in Victoria as well as federally, and there's recently been an announcement where the very bodies that are part of, you know, whether it's industry bodies such as banks, finance companies, etc., they are also now contributing through an independent fund, just starting now, to increase the numbers of financial counsellors and The Department of Social Service and Minister Rishworth has been quite important in basically garnishing that together. There'll never be enough dollars out there to support people, and in particular states, I would suggest that there does need to be more, in particular Queensland, New South Wales and South Australia. I think states that could do with extra support from their respective state governments. But look, at the moment, we're hoping that with this industry fund, that's going to create another 80 to 90 positions permanently across the country. So that will add to the 1,100, 1,200 that we currently have. So I think that's a positive step. But where it comes to the particular reference to this inquiry, increasingly what we do need is specialists working in areas where women are presenting with economic abuse, and we need to be strategic about where those particular areas are, and look at having specialist financial counsellors working in that space.
Can I just ask a clarifying question? With all the insights and opportunities that you have to see what's happening, how close is the loop with the banks and the financial services providers? How connected into that are you in providing them with examples of how their product has been abused?
So definitely there's been great improvements by certainly the main four banks in recent times, and that's been as a result of some work that's been done over the years, but in recent times, Flequity in particular,
yep,
and Centre for Economic Women's Support have done a lot of really good work there, and that's where banks are at least acknowledging that they don't want their products to be weaponised as forms of financial abuse. But in terms of financial counselling support, in terms of financial counselling engagement with banks, we have an excellent relationship with what they call bank hardship teams, where financial counsellors, particularly supporting women impacted by economic abuse, are able to directly contact a bank and hopefully get the kind of support that's needed. And by support, I mean, number one, listening, understanding the issues, and then responding appropriately. And we find, in particular, the main four banks have definitely improved in that area, and other sectors could actually learn from them.
Mm-hmm. If I could just add to that, I think we have quite a good feedback loop with many different organisations across the financial ecosystem. I've mentioned in the report, we have every 2 years we run a Rank the Bank survey that we feed that back. We've given us the statistics of who went well and not so well. Yes, right, that's right. So we have that, and there's usually a pretty high appetite to hear about that. We also have in recent months started a little bit more of a dynamic tool where we're hearing and feeding out quite quickly. Peter and I meet quite often with different organisations, but what I will say is that the levels of engagement are patchy. So as Peter mentioned, we have very high levels of engagement with the major banks and some of the non-major banks, but it's not across the board. There are some organisations that we don't have ongoing conversations with, although I will say the recent Rank the Banks has led to quite a few conversations for the first time, which is quite a positive sign, particularly in the non-bank lending space. So that's a positive. But there are various things. We're working really hard to increase our capacity to quickly and dynamically feedback what we're seeing to people for whom it matters, and we would like to see an increase in that conversation across the board with players in all sorts of different places.
So one of the discussions that we were having in our last inquiry in Canberra was Catherine Fitzpatrick, who had done a schematic of fraud, scams and financial abuse, and the order of magnitude was 2 to 3 billion for frauds, 2 to 3 billion for scams, but then for financial abuse, $5.7 billion. The question that we've been asking the banks is, do you know how much money you've been able to recover? It's not a stat that has been readily available, but I know that from a financial counsellor perspective that you're actively trying to help victims, survivors obtain that money. Would that be numbers that you guys would have at your fingertips, or probably?
No, we wouldn't. We'd love to have that kind of level of detail, and we'd love to hear that back, actually. That would be really, those kinds of things are very, very helpful for us in kind of targeting responses and making sure that the workforce are adequately equipped to respond to respond. And it's a very interesting point that Catherine makes around the scams and fraud relationship here. I suspect that underneath that may be some of the thinking that I was talking about in the opening statement around we don't understand, we sometimes so think of a couple as a financial unit that we don't think about it as fraud. We think about it as something. I think it's a really interesting area to look into, and we'd certainly love to see more information on that.
Probably in our sector, the best organised financial counsellors that are working specifically in financial abuse areas would be in Victoria, and so we could take that question on notice and just see if they have any data available that we could feed back to you.
Just a question on the practical action that occurs when somebody's a woman with a couple of children, because we know that this happens most prominently in women's childbearing years. Woman with a couple of children, servicing a mortgage, she thinks, alongside a husband, finds out it's all not going so well. What happens with the pursuit of assets from the perpetrator? How often are you engaged in that kind of pursuit, and how easy is it to pursue the perpetrator? Like, proceeds of crime is something that we talk about, right? That for a long time people could live high on the hog, and if they got away with it, they got away with it. Now, if they're caught, then they can't explain how they've got these things, or if it's proven that they got them by illegal means, then those proceeds of crime are captured. Cars are sold, houses are sold. There's restitution, whether that's directly to the financial entity or to the individual to restore them into housing, for example. What do you see? What's happening there? Is any of that going on?
I have not heard, and we will take that one on notice too. I'll ask some further questions, but I have not heard of that as an avenue. Really, where these issues tend to be addressed is in a kind of a hardship space, to be honest, where you're kind of trying to stop gap and create remove as many barriers as possible through those mechanisms
For survival, not thriving.
Exactly. Right? To try and sort of say, look, in the immediate sense, we can see that this is a substantial obstacle, or there's a kind of injustice in it, or it's very obviously unfair, you shouldn't have to pay that or waive it or whatever. But that kind of deeper understanding of it as
Does he say crime?
Yeah, that understanding, I think that's something that may be the next stage in the thinking, because we don't. So have you seen that? I haven't seen that.
No.
So no one's gone out and said, that $60,000 car that you're driving around, that you got in your wife's name, that you've got to sell that now, and she needs the money. None of that's going on.
When you say none of it's going on, it happens all the time. But I think if your question's around what work do we do in terms of pursuing that from, say, the perpetrator, we don't do that. What we do is trying to essentially protect and save.
So who would pursue the perpetrator? Who would?
The police.
Police, if it's a criminal charge.
Yeah.
If it's not criminal,
where would we go? Where would we go?
Maybe the bank might.
Well, where the debt has been transferred across, that's where we come into play, obviously. But pursuing the originator to restitute either the bank or the former partner is not something that we spend time doing, simply because we focus on.
So to be clear, these slimy people who do this are costing the Australian economy $5.2 million. 5.7 the scale, billion, 5.2 billion. So all of this work's going on because super greedy, revolting people are abusing the people they're supposed to care about. And kids are paying the cost. Businesses are paying the cost. Banks are paying the cost of slimy fraudsters in private relationships, to the tune of $5.2 billion per annum.
Finance is often the easiest weapon of abuse, Senator.
It is.
It's astounding, and I think it goes on to something that you were saying earlier, which is that these products are being used for malaligned purposes to hurt people. And like and it follows on from one of the principles that you talk about, which is safety by design, and making sure that we get that right from the outfit. And I think one of the cases over in WA was around a student assistance payment, and all that was needed was the student ID number, and the assumption was that payment would go to benefit the child, but it ended up being withheld by the perpetrator, and it didn't actually go to its intended purpose. And so I'm wondering if you've got suggestions on how we can stop that from happening. And
Well, I think that graver consequences for this kind of action from a perpetrator carrying out these things is probably a good thing. If you're talking about harnessing the existing products and services for harm, I think that financial institutions have a big role to play in doing that in design, in the way that they design, and in the way that they respond, and also in the kind of various means of sending a very strong message, like the Terms and Conditions project, for example, that Flequity are working on at the moment, where it's a very explicit from the outset, this is unacceptable. That's not done. I think when it comes to things like taxation or Centrelink, or there really does need to be a good hard look, I think, at breaking down that assumption that funds will necessarily flow to the good of the family unit, and also really the thinking that renders a couple or a family unit as one rather than as human beings together in a situation. I think really, unless we can do those deep pulling apart of things, I think we'll struggle to prevent harm.
Just on that, I think the recent announcements by the government in terms of the national plan, the escaping violence payment, the funding of our services, etc. I mean, these are important initiatives that cannot be underestimated, because it shows that the government at least is elevating these issues to the national stage. But just following on from what Dominic has just been saying, I do think that certain government departments need to really think and act carefully and more strategically in this space, and understand the nuance of what's going on. So, for example, the ATO, the Australian Taxation Office, financial counsellors are reporting a lot of difficulties with the ATO, which in part is because the ATO does not have a vulnerability framework, which includes a decent family violence hardship program. And one of the ways of weaponising through the ATO is obviously directorships, where the female is a director in name but not in kind. And then when you sign directors' guarantees for debts, etc., then these are the issues where you need the ATO has a responsibility to collect tax, of course, but doesn't really have a policy framework to address these kinds of issues in a just and fair way. To that end, at least, we've met recently with the Commissioner of Taxation, Mr. Heffernan, and he has at least acknowledged that they need to work on a vulnerability framework, and we'll be talking with him about that fairly soon. So I think that's one area where there needs to be more work done. Child support's probably another area, particularly in terms of the child support system that is private, where Centrelink assume that if there is an agreement through the private system, through a private arrangement, that they then adjust what's called the family tax benefit payment. And again, where there is financial abuse involved when payments don't come through, our experience is that people don't report back, women don't report back to the child support agency due to fear. So there are things, I think, within government departments and systems that we would say need to be looked at in a bit more of a strategic way in light of this inquiry.
Can I ask how critical it is for a non-negotiable individual account to be permanently maintained and only operated by the individual for such payments?
For these child support payments? Oh, it's once you make a private agreement, Senator, it's very, very difficult for at least at the moment the government department responsible to monitor that payment. They just assume that the money is being paid every month. And when it doesn't get paid, which is the experience of what financial counsellors are seeing working in this space, then we've got a problem. And the problem is that the financial counsellors' clients in that position don't want to report back.
Because they fear physical violence in addition to the financial abuse that is already going on. So you
Yes.
make a submission, in your submission you make quite a number of recommendations. This one, removing the assumption that one partner's or ex-partner's income will necessarily flow to the family unit from government services, deals with the family payments system. But you've added in this additional layer in that response to me, Mr. Gartland, around the private arrangements.
I think the private arrangements need to be looked at, Senator.
Registered somewhere.
Well, yes, maybe that's the solution. I'm not qualified enough to comment on what the actual solution is, but certainly by defining the problem, I hope that smarter people than me can come up with those kinds of solutions. But certainly a registration system might help.
Can I go to your submission, your statement that safety and flexibility being built into joint loans and credit cards with joint facilities is a requirement? What, in your experience, would it need to look like to stop these, malign actors from gaming the structures that are there? How do you build a fortress of a particular set of bank practices and account management practices that stop at the top of the cliff the ease with which people's life savings and their ongoing money is just being taken from them?
Yeah. Oh, look, I think there are a number of things that you could do at a high level. One of the initial things would be, first of all, thinking about where it is appropriate and not appropriate to have joint loans. I know that some financial institutions won't do joint personal loans, for example, as opposed to it. So sometimes it's just saying, look, it's not an appropriate product. Sometimes, if you think about taking on a mortgage, you think, I'm not sure exactly the sticks, but we're looking at sort of somewhere between 40 and 60% of relationships breaking down. You're taking on a mortgage. There must be a conversation at point of sale that says, what if you do break up? You may be in the 50% that do, and if you do, this is what would happen. This is what your rights would be. You'd still be jointly liable for this. All of that stuff really...
Unless you choose this product that we're going to give you, which acknowledges that you're putting in 70% of the money and this person's putting in 30% of the money, and you are separately responsible for these amounts.
Yes.
Until such time as the mortgage is paid. Would that act in a protective way?
It may. I think with this stuff, the delicate balance between power and control and safety and access is tricky. So I wouldn't want to say off the cuff exactly what needs to be done. But what I would say is that building in that first attitudinal shift, financial abuse happens and it causes great harm, into that all the parts of the design of a joint loan, and having conversations at point of sale, people understanding the risks that they're taking, both parties understanding the expectation that with a joint thing comes a shared responsibility that you can't just tap out. All of that stuff really needs to happen. And then when things do fall apart, if they fall apart, there needs to be easier ways of untethering from each other. And also the assumption that it would be safe for someone to just say, oh, well, I'm just going to separate out from you in a family and domestic violence case is just not a helpful assumption, because sometimes people are staying entwined because that is for them and their children the safest way of going forward. You can't just say, oh, well, why don't you just cut it off or something? It's like a high risk, high stakes chess game with somebody who means you harm, who has access to all of your most intimate details and knows how to push all the buttons, and yeah.
Is there, we heard the possibility that there might be some necessary intersection with the legal fraternity around the type of structures under which mortgages are attained. So that if it was sort of early in a relationship and people went into joint debt, the risk might be very high, and that it might be better if they owned basically shares in the building. I don't think that's the term. I think it might be
tenants in common.
Tenants in common is the term. So that would be some form of protection where the financial services would be aided and abetted in protection by the legal services, and that might make that disentanglement a little easier. Do you have a view about that? Would that work in some of the cases that you've observed in terms of? I
think that's worth definitely looking at. In terms of the percentage, I note that Consumer Action Law Centre are going to be speaking this morning. It might be a question better posed to them, but certainly on face value, that would seem to me to be something that's really worth considering, Senator. I think it's because at that point there, should there be some form of formal separation, then we can get to at least that's divisible in law. But again, I'll leave that to to Financial Rights Legal Centre.
Thank you. We're just going to check and see if Senator Pratt is online to ask a question.
Thank you, Chair. Good morning. Can you hear me?
If not, expect that there will be questions on notice. But could I just ask you both?
Sorry, Chair. I was trying to unmute myself. I must have failed.
Okay. We can barely hear you. Do you want to speak again? Senator Pratt, are you there?
Yes. Thank you, Chair. Can I ask, please, in relation to the design of products, how I know safety by design is a principle that you have put forward. Last time they spoke to the banks about these issues, it seemed to be an imposition on people's free will of what they wanted to do with their money in relation to designing products that are more safe. So I want to ask, firstly, how you think banking products could change, and secondly, in particular, mitigation around drug and alcohol risks and banking. So, for example, we saw over many years the cashless debit card as a banking product, I guess, essentially provided by government, but the kind of innovations in that, such as merchant blocking, not widely available in banking products. But now we're slowly starting to see, for example, gambling blocks on banking products. What more could we be doing in relation to banking products, for example, that might limit cash withdrawals for people with decision-making disabilities, but still give them some financial independence, and limits on deductions for, cash, alcohol, etc. Particularly noting in the dynamics, for example, elder abuse, people might actually be reluctant to remove their children, adult children, from their household.
Mr. Garland.
Thank you.
Senator Pratt, I am aware that the Australian Banking Association, in their submission to this inquiry, highlighted one of the gaps in the Privacy Act where as I understand it, where the bank does have substantial concern about an individual's economic well-being, that the Privacy Act currently prevents the ability to collect or disclose personal information that's not relevant to that particular person, but where there is clearly evidence of financial abuse, this is a gap that needs to be addressed. And as I understand it, that the banking sector, which I'm not going to speak for, of course, but they've made that issue known to this inquiry, and I imagine that will be part of this inquiry's deliberations. But it would seem to me that one area that could help would be a broadening of the Privacy Act to be able to address that particular issue. In terms of other banking products, I was quite struck recently when I was speaking to representatives of Southeast Community Links, which is a community agency in the southeastern suburbs of Melbourne that employ 12 financial counsellors. They were running a financial literacy day with women from one particular country that's newly arrived, and the question was asked of the 24 women, how many of you have a bank account? And 16 out of 24 did not know whether or not they had a bank account or not. 16 out of 24 did not know. So I think part of the response to the ecosystem here has to involve really targeted, specific information with all people, whether they're newly arrived through to people that might be suspect to elder abuse, and the thinking behind that, which Dominique was talking about earlier, I think needs to drive it.
One of the submissions that we have talks about dowry abuse as a particular cultural practice of one part of the, fantastic diversity of diaspora that come to Australia, but intersections with the home country from which they've originated is actually a critical part of this equation. So one of the things with financial services is we always think about them getting to the edge of our physical boundaries as a nation, but there's actually an international dimension to do with this that needs some address. And the other thing is how much of the critical information going forward is available in languages that are accessible to culturally and linguistic diverse communities.
Yes, I'm also aware that Southeast Community Links have been advocating with the Australian Banking Association, the ABA, to increase the number of interpreters that are available for people where English is not second or third language. So there are, I think, really good opportunities where that could be increased from the banking sector. It's as if there's a two-step approach here, Senator, in which we have a lot of us that use online systems quite comfortably, and there's a whole other section of people that don't. So I suppose my point is that the inquiry needs to also think about that sector and maybe some practical suggestions that could assist people in becoming better aware.
Well, one of the submissions talks about people being able to go to Australia Post in their local community, but there's limitations there in terms of security, also about access, about knowledge, representatives of a product rather than the owner of the product, different levels of... The whole ecosystem seems to be one in which, sadly, those who would hurt the people they love financially have all the power. And that is very disturbing. That is very disturbing to me. Dr. Merrick, did you want to give a response to Senator Pratt's question?
Just to continue on from what Peter was saying around, it's very complex, that balance between an individual's right to choose and to have some flexibility in the products that they use, but
and efficiency and the productivity of being able to do things in a timely way. There's certainly good dimensions to this. Yeah,
absolutely. However, when there is evidence of systemic and continued harm that is preventable, the measures that can be taken should be taken, really. And the kinds of things that Peter's talking about, again, there are all sorts of things that can be done in terms of the provision of information in ways that are in languages that can be understood, but also meeting people where they are, so culturally sensitive and culturally appropriate. There are a whole, if the lens about this is, if the lens that we put on it is that there is preventable harm being caused, there are all sorts of things which, and one of the things that we think is absolutely integral to addressing this problem is pulling together So a cohesive and cooperative approach where people who have levels of expertise in all sorts of different areas can come together to agree to work towards avoiding these preventable harms.
In Australia, everyone has to have certain ID, right?
Yeah.
Have we reached a point where every individual has to have their own bank account and has to be able to be observed to be able to move their money through their own account?
Well, yes, in short, it would seem quite logical that that would be one way to at least maximise the opportunity, I suppose, for people to have a better control over their funds and somewhat lessen the chance of abuse. But I go back to that example that I gave a minute ago, where 16 out of 24 women did not know if they had a bank account or not. It kind of just shows that in certain ways we've got a long way to go. In other ways, as we've talked about this morning, there are important measures that are shining a bit of a beacon in terms of where to go, but there does seem to be quite a gap in between. And our sector, as I said, you know, our sector's has really been quite, well, what's the word? Overwhelmed really with the amount of demands with the cost of living crisis this year. That these are reasons why, you know, we think it needs a lot more attention.
The ABS Partner Violence 2021-22 as the source generated a partner economic abuse behaviour classification system. I might just ask you on notice to have a look at that. It describes 3 different levels. The first one contains some of the things we've just been talking about: economic restriction behaviours. First indicator, you know, control, to try to control them from knowing about, having access to, or making decisions about household money. Prevented them from opening or having a banking account. Yeah, that's just 2 of 5 that are indicated there. The next layer up, economic exploitation behaviours. Manipulate or force them to cash in or sell or sign over financial assets that they own. And then up to the economic sabotage behaviours. Damaged, destroyed or stole their behaviour, any property, deliberately delayed property settlement after the relationship ended. And that's the family law dimension, and the intersection with bankruptcy that I think we kind of, and people being advised to become bankrupt, women in particular, to quickly resolve an issue for financial satisfaction of the financial service provider, and inadvertently, it seems, signing their own end to a possibility to keep their home and own their home. That is a critical failure that seems to be manifestly obvious in the data that we've received or the submissions. Is that something you see? And this is the last question from me.
Absolutely. It's something that financial counsellors that are working with family violence victims and survivors see on a regular basis. To the extent that that it gets to a point where bankruptcy, whether it's forced bankruptcy, like a creditor's bankruptcy, or whether or not the woman needs to actually bankrupt due to the fact that debts are unrecoverable, even though they didn't result. You know, we try and avoid that by going directly to the financial institution.
But that's if they can
involved.
get to you.
That's if they can get to us.
Before the time shuts down and there's a sheriff or a debt collector at the door saying, you know, sign this or you become bankrupt or we're going to keep coming here.
A typical case would be fines as well, where the person's taken, where the fella's taken the car, has racked up fines due to tolls. The car's in the name of the former partner, and she's the one that receives fines. So, depending on the state that you're in Victoria, because in various around the country, depends really on what recourse the woman has to actually try and resolve that, where debts are in her name but weren't actually incurred by her. In 1 or 2 states there are courts where you can go to present your case, but again it's as you said earlier, it's clogging. These are issues that are clogging up the systems, and there's no quick and easy route. And if you don't go and see a financial counsellor or community lawyer, for that matter, chances are that you're not aware of these kinds of options that are available. And it is inconsistent. It goes back to the theme that Dominique said earlier, that there is an inconsistent approach to how we address, as part of the ecosystem, all of these issues.
Senator Pratt asked a question about drug and alcohol abuse, and also about perhaps mental illness and capacity issues that are embedded in both of those profiles of people. Could you take on notice an indication of how much drug and alcohol is impacting what's going on? I mean, we've moved to a harm minimisation model, and of course we want to help people when they're at their worst, but there's sort of prevention in the public place. And the idea that, you know, drug and alcohol abuse is a victimless crime, I'm sure that that's not the case, and I'm starting to fear that the most impact of drug and alcohol abuse might well be in the partnership relationship or inside the family, even more so than the trauma that we see induces on the streets. So, yeah.
I think Senator Pratt had a question on notice.
And do you want to put it up on notice, Senator Pratt?
Thank you, Chair. I just wanted to ask about fixing someone's credit record after an experience of financial abuse, and whether there are legal or regulatory things that we are able to do, to look at in order to assist that, and whether there are ways in which I guess that someone could end up on the right person's credit record rather than the victim.
Senator Pratt, could I make a practical suggestion? I think Julia Davis is going to be speaking quite soon, and she is an expert in this particular area, and I don't know if she's behind me or not, but
she's
but
if I that lovely Australian cringe look, head down, or don't look at me, don't call me an expert. I might be a tall poppy.
It's actually a lovely American look. You'll hear her accent, but she is an expert in that area, so I'd probably defer to her to give an answer to that.
So we'll kick off with that question in just a moment, Senator Pratt, because we're about to change witnesses. Can I thank you very much for your evidence here today, your very solid submission, and the work that you and the people in your sector do for people who find themselves at a point I'm sure they never imagined would come to them in their life. If you could respond to your questions on notice by the 5th of August, that would certainly assist the committee. Thank you very much. And the Secretary will be in touch with you to make sure that process goes smoothly. Thank you. Thank you. And now,
I was going to say, it's great to see co-CEOs. We need to have more of that.
So long as you keep separate bank accounts, we'll be fine. Thank you. Could I welcome representatives from the National Economic Abuse Reference Group, please? Yes. Grab an exam paper and take your spot. It feels a bit like that, doesn't it? But we're just sort of normal people like you who care about this issue, so don't be too frightened. And you know, I guess you're here to lay your wisdom on us from your experience, and we acknowledge what you do. So thank you very much for joining us. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you please state your full names and the capacity in which you appear today? We'll start with you, Ms. Abella.
Darcia Abella, Program Manager at West Justice and member of the Economic Abuse Reference Group.
Jasmine Optum, Senior Policy and Advocacy Officer at Redfern Legal Centre's Financial Abuse Service, New South Wales, and Coordinator of the Economic Abuse Reference Group.
Julia Davis, I'm the Senior Policy and Communications Officer at the Financial Rights Legal Centre, and we are also a member of the Economic Abuse Reference Group.
Laura Bianchi, Managing Solicitor of the Redfern Legal Centre Financial Abuse Service, New South Wales, and Coordinator of the Economic Abuse Reference Group.
Thank you very much. And do we have an opening statement from anyone?
We do, thank you.
Ms. Bianchi.
I'd like to acknowledge that today we're meeting on the land of the Wiradjuri Oi Wurrung people of the Kulin Nation and pay my respect to elders past and present. The Economic Abuse Reference Group is a group of 59 Australian community organisations that include domestic and family violence services, community legal services and financial counselling services. Redfern Legal Centre's Financial Abuse Service New South Wales coordinates the national network, and we are joined today by two of our members from West Justice and Financial Rights Legal Centre. Our members have front row seats to the most appalling examples of financial abuse. Australia's financial products, services and systems are being used to trap victims in a web that is expensive and traumatic to untangle. Their problems cut across consumer credit, insurance, tax, company directorships, superannuation, bankruptcy, family law, social security and beyond. Rachel's story is just one example of the cascading impacts of financial abuse. Before Rachel met her partner, she was on track to pay off her mortgage within a few years. Instead, in that time, Rachel was financially abused to the point that she and her 3 children were facing eviction. Rachel's partner coerced her to increase her mortgage by $350,000 so that he could purchase an investment property that turned out to be almost worthless. The mortgage was in Rachel's name alone and secured by the property she owned well before the relationship, but her name was not on the title of the investment property. When Rachel fell into arrears, the lender commenced legal action against her to repossess the home. Rachel had lost her licence because her partner had driven her car and accrued over $10,000 in fines and unpaid fines and demerit points. Without her licence, her job was at risk. She was also under significant financial pressure because her partner did not contribute to their expenses. Her debts were spiralling out of control. She had thousands of dollars owing on water and energy bills, and she was a few years behind in her council rates. When they separated, Rachel was overwhelmed with ongoing family law property proceedings, and they were being dragged out by her partner. She also had a lapsing protection order. Stories like Rachel's are shockingly common in our work. They illustrate how financial abuse can have long-lasting adverse impacts on and traverse multiple areas of a person's personal and financial safety. In Rachel's case, she was left on the brink of homelessness. She lost her freedom of movement and her ability to get to work. She was also at risk of having her electricity and water disconnected. Even well into the future, Rachel will struggle to buy another home because of the financial abuse and what that's done to her credit report. We see these harms happening repeatedly under the nose of financial institutions who have the power to prevent and respond to it. We believe our submissions to this inquiry and our evidence today will give the committee insight into the ways that financial services regulatory framework fails victim survivors. This is by not requiring financial service providers to actively prevent harm through their products being weaponised for abuse, by treating financial abuse as a series of individual cases rather than a systemic problem which could be prevented, by leaving business obligations to address financial abuse as voluntary guidelines and aspirational self-regulation, by having inconsistent rules across different sectors that require a dispute to be raised with each business, forcing victims to retell their story of abuse again and again, and by failing to consider the fine line between cultural obligations and financial abuse. Financial institutions and government must be held accountable for the risks of their products and services being used to perpetrate financial abuse. Institutions need to actively identify and remedy cases of financial abuse. This will not happen consistently without regulation and enforcement. The regulatory environments are complicated and intersecting. It is for this reason we ask the inquiry to recommend the establishment of a cross-departmental task force to implement the recommendations of this committee. Many perpetrators of financial abuse are sophisticated operators, and it's critical that the federal government, as much as possible, close all opportunities for abuse. We thank the committee for the opportunity to provide evidence today. Among us, we have expert knowledge on how financial abuse interacts across almost all areas of Australia's financial services framework. We're now happy to take questions.
Thank you. I think we might go to you first, Senator Pratt, because these are the people to answer your question.
Thank you, Chair. I'll speed things up. Did you hear the questions I asked the previous witnesses?
I think so. One part of it was about putting credit reporting information on a perpetrator's report, and the other was what law reform is necessary. to help expunge victim survivor reports? Sure. So to the first, no worries. To the first point, we would not support putting information that does not belong to a perpetrator, like he doesn't own the loan, on his credit report, mostly because it goes against the purpose of the credit reporting frameworks, which is to indicate a person's credit worthiness, and it should really track whether or not they have repaid loans that were in their name. And the other issue is really a safety risk. We know from our casework experience that victim survivors will not like the idea of their credit reporting information getting transferred to a perpetrator's credit report as sort of a penalizing exercise. We know this for a fact because there is a fines nomination framework here in Victoria where basically a victim survivor can nominate for their fines to go to a perpetrator. And in the 18 months it's been live, what did you say?
Yeah, so in Victoria, there's something called the Family Violence Scheme, which is a system designed so that victim survivors of family violence who have incurred infringement fines in the context of family violence can have those fines either withdrawn or they can opt to nominate the person responsible for the fines. Since 2018, this scheme has been up and running. Not a single one of our clients has opted to transfer a fine to their perpetrator.
And what do they say is the reason for that?
Safety risks. So safety is absolutely the number one priority for our clients. And most of them just want to move on with their lives and have it done with.
Yeah. So that being said about credit reporting, I am 100% supportive of, in a joint loan scenario, having negative credit reporting information completely expunged from a victim survivor's report and having it all stay on the perpetrator's report, because that is a reflection of the perpetrator's creditworthiness. It is a fair and normal use of the credit reporting framework, and absolutely should stay on his credit report. But there needs to be better mechanisms in the law for account splitting, where the victim survivor's report can be cleaned and expunged, even in a joint account situation. And this is currently a difficult thing to do under the law. Most lenders will say that this, credit reporting is account-based, not customer-based, and we can't just split joint accounts. I question whether that's true. I have seen examples of account splitting, so I'm not really sure if it's a genuine legal barrier or just a reluctance because it's a systems expense. But we would absolutely support expunging all that information. And to the second point of your question of what law reform is necessary, all lenders need flexibility to be able to remove credit reporting information in all of its forms, whether it's mispayment information or defaults or an entire account information. All the evidence of a loan that was taken out as a result of financial abuse should be expunged, right? And any lender should be able to do that quickly and efficiently and without having to get all kinds of inappropriate evidence like police reports. And right now, and I've put that forward to the Attorney General's Department, there's a review of credit reporting happening. That is a really critical reform. We need more flexibility for that. And, there's a few other things. We think that lenders should be required to inform victim survivors of all the options to clean up their credit report when they indicate there's family violence involved. We think that the credit ban period needs to be much longer. Currently, if you say you're at risk of fraud, you get a 21-day ban. That's over in a blink, right? Before you've even really sorted out any of your troubles, 21 days is over. So that obviously needs to get changed in the law. And really, it's just the idea that lenders need to get on board that information about missed payments and defaults during a period of abuse does not reflect a victim survivor's creditworthiness. It does not reflect her ability in a safe, free environment to repay loans, right? All it does is reflect this terrible period of abuse. And it shouldn't affect her ability to get a home loan in the future. And lenders really need to get on board with that perspective that all this information should just get expunged from her credit report so she can move on with her life once she's free of that abusive situation.
Do you have another question, Senator Pratt?
What do you see going on in people's bank accounts when financial abuse is occurring? How easy should it be to identify in how lending products or bank accounts or credit products are being used?
I mean, one point I'll make is that as advocates, we don't really know what information is available to banks. You know, they really hold that data close to the chest. They think of it as commercial in confidence, and we wouldn't have a clue really how much data they have or how their own internal AI systems can identify trends and spending patterns. You know, so it's hard for us to say, use this data to fix the problem, because we don't really know what data they have. Cool. Any more questions, Senator Pratt?
Yes, just one more. People will quite routinely give out PIN numbers and credit cards within their own families from the point of view of convenience, and abuse, you know, in most cases probably won't be occurring, but where it is occurring, the presumption that someone is using your card with authority, how much of a problem is that in the banking system?
Is that a First Nations question?
I think there's an assumption here that our friends at FCA spoke about at length that underpins, I would say, our entire financial system, which is the assumption that conduct happening within an intimate partner relationship or within a family unit is consensual, and conduct happening outside of that partnership or family unit is non-consensual. And in much of our casework, the behaviours that we're seeing and the transactions we're seeing and the perpetration of financial abuse fits the exact bill of fraudulent activity or scams, and would be labelled so if it occurred outside an intimate partner relationship. So I think that's an attitudinal shift that really needs to occur. And we see victim survivors being turned away from financial institutions, from police, from government agencies with their stories, because there is an assumption that because the perpetrator of this fraud or this identity theft is someone who they were in an intimate partner relationship with at some point, immediately negates their story and turns it into, in the eyes of the police often, a family law matter or a civil law matter, and closes off avenues of recourse for them. I think the assumption around sharing of accounts and finances within a family does need to change. I think we can no longer rest on a financial system that assumes equal sharing of finances within a household, that assumes consensual sharing of credit cards or debit cards within a household, when we know the rates of financial abuse, we know the rates of breakdown of relationships, and yet our financial system, and in many ways our government systems that involve payments, so child support, Centrelink, the tax system, company directorships, for example, are all working off a very outdated assumption about how relationships operate and how families operate.
Yeah, and I would just add.
Technology should lead us to be able to fix some of these issues, surely. So, for example, if you've got an offset account for a home loan, you should still be able to keep two separate accounts offsetting that, rather than them all be joint accounts, for example.
Absolutely, and I am aware of, I think, at least one bank that offers that. I can't say conclusively across all products, but I do.
So what is the bank?
I believe it's AMP that offers the option to have two offset accounts, but I can't. Yeah, but I haven't done an assessment across all lenders, but I've heard that is an option, and I think that is something that is a good example of where we could look at product design and apply exactly what Jasmine said in relation to the rethinking of how relationships work, and that goes to what the committee's heard a lot about, which is safety by design, and embedding that.
And how do we make those standard rather than and picked up in the first instance, because if you're likely to be a victim of financial abuse, you may not initially get the choice of what kind of bank accounts you get. Surely you should have a reason to opt into accounts where you essentially could be put in a position where you have no control. It should not be the default of any banking situation.
Absolutely. I think it's about availability of those products being offered across the board, and also information about what products are available and how, exactly what was said in the previous session around this idea that people need to be aware of what products are available to them so they can make better informed choices about what the future of a relationship, would be if they were to separate, and how would that impact the products that they're choosing from the outset. And then also, where it's possible, having remedies available to them to make it easier and more flexible to separate those products out if they didn't choose that option in the first place.
And I think that also goes to the
Ms. Optum.
I think that also goes to the necessity of standardisation, because we often see in our casework situations where, had one of our clients been a customer of a particular bank or financial institution, we know the remedy they would be able to achieve. But unfortunately, they happen to choose a different financial product provided by a different financial institution, which limits the remedies available to them. And
so a mortgage isn't a mortgage, isn't a mortgage. They're all very, very different products.
Exactly. A personal loan, a car loan is not just a personal or car loan. And many of these victim survivors that we work with have gone into relationship, and no one goes into a relationship expecting to be financially abused or expecting the relationship to break down. But many of our clients have gone into financial products not understanding the authority levels on the account, not understanding the terms, not understanding that there might be other products available that are more suitable for them.
Yeah.
And what we need to do is lift the benchmark so that the onus is not on the victim survivor to choose well. There should be a lowest common denominator that is safe and that is appropriate for all customers, regardless of whether their relationship ends, regardless of whether they experience financial abuse, so that we're not continuously putting the burden on victim survivors to protect themselves, to resolve their financial problems, to advocate for change. This should not be on them to fix.
And I would just add, this extends also to brokers who are offering these products to couples. I think it's beyond just financial institutions.
So the responsibility of brokers in the midst of this, where do they sit in terms of liability?
Well, we know right now that over 70% of home loans are going through mortgage brokers, right? So they play an incredibly huge role in how loans are getting set up in this current environment. And it's been well over 60% for quite a few years. So they are the ones initiating the vast majority of home loans in Australia, and they would be the ones recommending what products their customers should take up and what structures they should set up and what lenders they should be going with. So they play a huge role in being able to inform their clients about what are the risks, what are their options, what do certain products look like if the couple separates. I mean, I would say they are absolutely not acting in the best interest if they are not giving couples some information about what happens if you separate.
But they're not required to currently, are they?
Well, there is a best interest duty, but I haven't heard of any enforcement around this specific issue. Best interest tends to look at, did you get them the best deal? Was it a suitable loan? I think these issues need to be front and center for mortgage brokers as much as they are for banks.
And they're driven by commissions.
Mm-hmm. And I think extending that best interests duty to all brokers, because we're not just talking about brokers being involved in mortgages, we're talking about brokers being involved in car finance, which can be an insidious form of finance for many of our clients.
Yeah.
Wonderful. Thank you, Senator Pratt. I'm going to go to Ms. Mascarenhas.
well done on your submission.
Yeah, it's wonderful.
I think that I haven't read all the submissions yet, but it's probably the most comprehensive, and I love the nitty-gritty detail that you've gone into. The talking about detail, so one of your recommendations was around the Privacy Act and having circumstances such as family violence and homelessness that constitutes a serious threat to life, health and safety of an individual. Can you expand on that a little bit more and how you would see that happening? And I think that particularly this year, domestic violence has been sparked a national conversation, and if there's mechanisms that we could put in place to try and prevent that.
I'm happy to talk to that one. And I think just to acknowledge overall the Privacy Act should be working to protect a victim survivor, but there is some nuance that would be required. And one of those particular instances would be for non-account holders. So we often see this playing out in the mortgage space where one person is named on the mortgage and the victim survivor is not, and therefore they have no access to any information around what's happening around that mortgage, despite them living there and that being their family home and their primary place of residence. So in the West Justice submission, we give the case study of our client Abuti, who is a single mother and has experienced significant violence. She's not listed on the mortgage or the title of the property, despite her financial contributions. And after she separated, she remained living in the family home with her children. Unfortunately, in that case, the perpetrator stopped making repayments to the mortgage, and he told her directly that he wanted them to be evicted from the property. Obviously, that places her in a great deal of stress. She's worried every day about the imminent threat of eviction. And this was a case where West Justice tried to contact the bank to find out information about the possible for the eviction to be carried out and enforcement action being carried out. However, the bank would not provide us with any of that information, despite us simply asking that the enforcement of that just be put on hold until they sort out their family law property settlement. Sadly, unfortunately, most banks would have this exact same response where they would say that the non-account holder has no relationship with the bank because they are not the named account holder, they're not the mortgage holder. So that it would be a breach of privacy if they were to share any information.
Even if they are making a financial contribution on a regular basis.
That's right.
That does not entitle them to any information.
That's right.
So that's a perverse outcome.
Yeah, absolutely. And essentially we see people just like sitting ducks waiting any day for their property to be repossessed, any day for their belongings to be thrown out, which is an absolutely awful situation for anyone to be in, let alone when you've got children living under your roof. Yeah, so I guess in a way the Privacy Act is being used as a bit of a shield in these situations. There are some provisions in the Privacy Act that do allow information to be disclosed, and as you mentioned, those are in circumstances where there's a serious threat to life, health and safety of an individual. I would say family violence or risk of homelessness would be a very clear threat to someone's life, health or safety. But unfortunately, the interpretation by banks tends to be that of a 000 type emergency situation that might warrant that disclosure of information.
Do you think that is willful blindness by the banks?
I couldn't comment. Possibly it's willful blindness, possibly it's fear of retribution of what might happen. They might be punished for breaching the privacy principles or the Privacy Act. But that's why we would say the easiest thing to do here would be to just use the existing framework, but make a note or make an amendment that family violence or homelessness would constitute one of those scenarios where information should be allowed to be disclosed. And we're not talking about information pertaining to the individual themselves. We're only talking about information that would be relevant to prevent homelessness, to maintain a victim survivor's safety.
In my mind, that it is clear that there is a direct correlation between family and domestic violence and death, like we have the case in the news of 3 children, right? But in some ways, I don't think that someone's going to test the Privacy Act for that link. But in my mind, that link is very clear, but it is something that needs to be more explicit to give the banks the tools to be able to go, right, this is what the direct link is. And, you know, I think from this year, I think we're at, like the number of women that have died this year is above the average that it has been in the past. And so, you know, I do have this question: is it willful blindness? You also talk about the great work that CBA has done at identifying financial abuse transactions, and you know, I do see a need for that to be rolled out consistently. How's the uptake been from banking institutions on adopting that? Have you guys had pushback? And I don't necessarily see you guys as the force for rolling that out.
Have you heard about it?
We have, yes, and we were involved in the initial consultation in developing the response to that. So my understanding is that Commonwealth Bank have shared that knowledge with other banks, and that there has been uptake by other major banks. I don't have current information as to exactly which banks and to what extent they're assisting customers, but our understanding is they all certainly have the data and the technology to be able to do it, and that they should be uptaking, because it is, I think, a really good example of where there has been no ownership, taken by CBA in relation to this initiative, and that they've actually shared that program and that idea with other banks, and there could be more of that creativity.
So I'm wondering what the outcome of it is, right? So it's really good to look like you're doing things. But what's the outcome of that? What's the benefit to you of that? How has it effectively assisted you in any way with any of the cases that you're aware of?
If I can speak to that, and not to take away from the initiative at all and the impact that it has on victim survivors' safety and well-being, obviously, in being able to limit and restrict, their bank account being used as a forum, I suppose, or as a line of communication to abuse them. But
so embedded in your answer there is the matter of the descriptors of money coming in. Is that the only thing you're aware of that the AI is doing?
So that leads to one of our recommendations in the submission, which is that the work that CBA and other banks have done in firstly identifying the problem of abuse in transaction descriptions, and then developing the AI models to run across all of the volume of their transactions and then prevent this from occurring, is just an example of the power that financial institutions have in both their resources and their data. And as I said, not to take away from the impact that this has in protecting victim survivors in some way, it's not protecting them financially. It's protecting their well-being and perhaps their safety. But that work is not being done to prevent financially abusive transactions occurring. It's being done to prevent verbally abusive transactions occurring. So that's
the only AI impact that you're aware of? Because I'm kind of in the world of thinking, okay, they've got so much data. Like, we've taken evidence in years ago that loans were being refused because the data that was so rich, people were able to say, no, you go out for steak too many times during the week, so your costs don't actually match up with what you really put on the form, so we're going to deny you the loan. I mean, that's the level, where you ate the steak and how much you paid on each occasion. That's the level of data access that they have. So I'm thinking about the woman that you were talking about who had no name on the mortgage, but has actually got money going into the mortgage. Absolutely, that would be observed. And my question, in a common sense way, is, well, at the very least, surely every dollar that she's put in there is money that should be going back to her if there's a sale of this mortgage. But clearly that's not how it works, right? So are you aware of the impact of these AI tools, in plural, other than doing the identification of abusive text in the descriptors?
Just firstly on the question around Darcia's case study and that woman being recognised for her financial contributions to the mortgage despite not being on the title, that is a battle that she will need to fight in the the Federal Circuit and Family Court for potentially 3 years to reach a final hearing.
That could be done in 3 seconds in terms of analysis. We have the technology to find that information out and have it verified by a third party, the bank.
And yet that will involve potentially months of, if she's lucky enough to have a family lawyer representing her through legal aid or through a community legal centre, that will involve likely months of back and forth to try to get financial disclosure from the other party.
And how many children are missing out on things that they need, essentials in their life, stability and a roof over their head, because some game's being played about information that should be available in 3 seconds. We can transfer money and literally in a second it's in somebody else's account. The information's there, the technology's there. So I have some questions for all of the banks on notice about what it is exactly that the AI is doing and what it is giving you in terms of critical identifiers of criminal action, in my view, that is not yet criminalised, but is action to defraud intimate partners of their financial freedom.
If I can pick up on your question around the information available to banks, and you gave examples of transactions and spending patterns, we still see in the consumer credit space loan applications or credit card applications being made to banks where a perpetrator of financial abuse has listed inaccurate information on the application. So they've understated expenses, they've overstated income, they've pretended the family home is actually an investment property and is earning a rental income. They've submitted that information to a financial institution, and the financial institution has approved the loan, despite, as you say, having access to an enormous wealth of data and information about actual spending patterns and whether there is or isn't rental income coming through. And in some cases, we've seen a financial institution approve a third or fourth credit card limit increase or personal loan, and the application form hasn't listed an existing loan with the same financial institution, and the financial institution has approved that on the basis that that earlier loan doesn't exist, but it's with the same financial institution, and this is still happening.
And what's almost worse is when advocates get involved to try and clean up the mess years later, banks, all lenders really, will inevitably say this is a hardship issue, we're going to waive the debt on compassionate grounds. They take no accountability for their own, really responsibility in approving those loans, in putting that person in hardship to begin with, because they kept giving credit increases based on made up information from a perpetrator when they had the data in their own system all along. And that's exactly that one-page chart that you got from Mrs. Fitzpatrick that shows that all of these abuse situations go down the hardship line. A lot of those, and we have it on the record at every AFCA case we've ever run, this is a responsible lending issue. This was an unsuitable loan. You should have seen red flags when you approved the loan, but it doesn't matter. They offer to waive it, and of course, in the best interest of our clients, you would of course take a waiver so she can move on with her life. But it means, once again, it's another instance where the lender doesn't have to take accountability of their responsibility in approving that loan, in taking the perpetrator's word for the expenses and income without verifying any of it. And then that we lose all access to that data. How many of these loans were unsuitably lent in an abusive situation? We don't know. It's all completely covered up by this idea of this is just hardship, these are just compassionate waivers.
And they have...
Rather, these are products you created that are now being weaponised. But we're not responsible for that.
And enabled by your poor lending practices.
And AFCA is a place where this can be pursued, but we saw, I read into evidence, one of the case studies about AFCA not really engaging with finding that the bank was at fault. Is that the most common way these things proceed?
Yes, they'll proceed through a fast track of reaching a commercial resolution, which generally involves the financial institution and AFCA wanting to see the victim survivor's current financial position so that they can sit back and say, oh, you're in financial hardship currently, so it's appropriate for us to reach a compassionate resolution and offer you some charity. But what about the victim survivor who might not be currently in financial hardship? Should they still bear liability for a $10,000, $50,000, $100,000 debt that was actually incurred by a perpetrator in circumstances of abuse?
And they may also be therefore entitled to compensation if they were to make a finding on the basis of responsible lending obligations not being complied with. So they could actually walk away with some financial compensation, but they're not, because they're being offered a waiver. And in a lot of cases, because someone's life is being completely turned upside down, they're going to take that waiver because it resolves the matter. They don't. They're already dealing with lots of other systems.
Another form of abuse, isn't it?
Exactly. Yeah. And the other impact that we touched on is that we're not getting data on at an IDR, internal dispute resolution level, or an external dispute resolution level of how many cases are being argued on the basis of financial abuse and a breach of responsible lending obligations or a maladministration on behalf of the financial institution. So, these are all...
Should that be reported?
Absolutely, and that's
quarterly,
in our submission.
Half-yearly, annually? To whom? The shareholders in a public document?
Would love that. Yeah.
Sounds
We'd
great.
love that data because we know... Yeah.
All of the above.
Anecdotally, we know that that's the case because that is how our casework is resolving. But I think what's being lost here is that is then benefiting the financial institutions because it's allowing them to have a really good PR, moment where they can say, we've waived this many, debts for people who've experienced financial abuse, but it's not really addressing the prevention element there.
Yeah, but their culpability.
Yeah.
That's right. And I think this is also a good time to also bring in the conversation about enhancing our responsible lending obligations so that victim survivors are more protected. So our responsible lending obligations currently as they stand require banks to verify that the loan is affordable and that the person's requirements and objectives are met. If done correctly and they verify someone's requirements and objectives, that should be the start of a protection for a victim survivor, because obviously if they're not going to benefit from the loan or they're it's fraudulent or they're being coerced into it, that couldn't be said that would meet their requirements and objectives. But what we're seeing is just really lacklustre responses to complying with these, particularly with the requirements and objectives limb of responsible lending. And then you take it to AFCA and that sort of doesn't get a lot of focus because they opt to resolve it on a financial hardship basis. So I think that the responsible lending framework that exists is good, but it could do with some enhancements and strengthening to help victim survivors. One way that could be done is by requiring lenders to be satisfied that a borrower is not experiencing financial abuse, so introducing that positive obligation to assess that. And then the other thing that's really important...
And are there any tools to enable them to do that, right? Because these are great ideas. But the pushback is going to be over-regulation, red tape that's unnecessary, because happily, I think this is still happening to a minority rather than a majority of people, right? And we have productivity benefits from the new streamlined systems. So for people who are in authentic relationships where there is trust, this is good. So if you could take this on, what would the fundamental triggers of a separate track which triggers more onerous, more expensive, and more deliberate interactions with the potential purchasers of a product? What would it look like?
If I can address that, I don't think what we're talking about here is significant change, but I think it, again, is a question of an attitudinal shift where all we need is to introduce, in many cases, the bare minimum of friction to an application process. We see this all the time in the buy now, pay later space, where it's a almost completely frictionless process and is rife for abuse by perpetrators. What we're talking about is introducing the bare minimum of friction so that there are opportunities to identify where financial abuse is occurring. At a bare minimum, perhaps speaking to both co-borrowers, we've seen matters even in the last few years where a lending application for a mortgage had notes written by the lender, by the financial institution, that said, assessed this application, Male was primary breadwinner, no need to speak to female, full stop, move on. That financial institution ended up having to pay a significant sum of money to that victim survivor in compensation. That is a bare minimum requirement you would expect before providing credit to someone. We're not talking about needing to slow down the system and introduce unnecessary red tape. It's a question of knowing that this is occurring, knowing that these products are being used to perpetrate financial abuse, and making sure that there are touch points where that can be picked up and where appropriate action can be taken before we're at the bottom of the cliff with a trampoline.
I mean, even the most basic example being that we've seen loan applications where the loan is in the victim survivor's name, but the email address, the phone number, the details it's very clearly their partner who is not on the loan. And that is basic. That should be triggering a question around, why am I emailing and communicating with somebody who is not named on this loan? We're not talking about really, high-end things here. We're talking about that's really simple.
That's very helpful evidence, right? Because that is the resistance constantly, and we need to design to make sure that things are productive as well as protective.
Absolutely.
Yeah.
And I think if we're taking a harm minimisation approach, the question is, what is the risk of harm to the minority of victim survivors experiencing financial abuse if these credit products have zero friction in the process?
5.7 billion, I think, is the answer, isn't it?
Exactly. That's the answer. And what is the harm to the rest of the population if they have to wait an extra, in some cases, 60 seconds, 5 minutes for a loan to be approved? We have retailers using the point of sale exemption in the National Consumer Credit Protection Regulations to provide finance on the spot at a car dealership, at an electronics store, where you speak to a shop assistant who might be 18 years old, have no training in identifying coercion or financial abuse, pop a loan application in the victim survivor's name, and it's approved by someone clicking a button at a financial institution online within 60 seconds. Do we need to be providing credit within the space of 60 seconds if it means that we're putting a large segment of the population at considerable financial harm and costing victim survivors and our entire national economy over $10 billion a year? What's the balance?
We're going to run out of time. Have you got another question? And then I've got a couple too.
Should I do questions on notice? Is that better at this time, or at so one of my
last one.
Okay.
Ask your last one, and then put some more on notice.
Yeah.
We've got so many questions.
So one of the things that I'm interested in is seeing ways that we can keep women and children in their homes for longer, and the thing that I think is sometimes interesting when you have got the relationship breakdown is that a woman's facing homelessness or going into a rental market where the rental payments are higher than the mortgage payments.
Yes.
And in my mind, what the goal is from the banks is to have someone that's going to pay the loan. Do you have recommendations to try and help women and children fleeing domestic violence to stay in homes longer?
I'm happy to take this one. Thank you for raising this really important issue. Obviously, we know that family violence is a leading cause of homelessness amongst women over 55. So the link between housing and financial abuse is a really important one. There is an approach called Safe at Home at the moment, which has just been announced for a trial in Victoria. Essentially, the whole concept of Safe at Home is around how do we assist victim survivors if they choose to remain living safely in their home rather than placing the onus on them to be the ones who are always fleeing from that property, having to leave their communities, their networks, their children's schools, possibly their workplaces, which is going to put them into more financial stress, health providers, all of that. So the Safe at Home approach looks at what does the service system need to do to wrap around that person to be able to keep them staying in that property safely, and that includes not just physically safe, but also financially safe. So the economic security of someone obviously is so directly interlinked with housing. It's a no-brainer. I mean, if someone is in a lot of debt and they are being pursued by debt collectors, etc., they've got all of these huge bills owing, then they're probably not going to be in a position to be able to afford their mortgage or their rent. If they linked in with services like West Justice or Redfern, who provide financial counselling and legal support and targeted assistance to people experiencing financial abuse, and that person is then freed up from all of those liabilities, then they're much more likely to be able to afford rent or a mortgage, and they're way less likely to end up in the homelessness service sector. So they're not going to go down the path of needing to enter crisis accommodation, or
which is a huge cost on the taxpayer.
That's right.
Some dodgy persons rip them off.
That's right. So even from a government perspective, on a cost benefit analysis, like, it makes sense to keep victim survivors and their children living safely in their home. So the pilot is going to be run or coordinated through Macaulay Community Services for Women. The Victorian State Government has just funded the first pilot. Obviously, it hasn't started, so we don't have any outcomes.
So how many banks have come on as partners in this endeavour?
No banks at the moment. It's community services, government.
That's interesting, seeing as the banks are the provider of the mortgages.
Yeah, speaking of banks and partnerships, I think there could be a lot of innovation, and where there's a will, there's a way, between banks and insurance companies to think of bespoke products that can protect victim survivors. And, you could put together a gigantic, bespoke product, much like there are products already in the market, insurance products that protect homeowners when a partner dies or something. You could put it in place for every mortgage. The premiums across your mortgage portfolio wouldn't be that high if you set it up as a giant group policy. And how often would it need to be triggered? This isn't happening every single day. But when there is an instance of financial abuse or family violence, and you're trying to keep someone safe in the home, the insurance product could be triggered. It could be something that's included in a home loan package, or it could be something that a person could opt into if they felt like there was some sort of concern their relationship was going to break down.
Then the insurance company would be responsible for getting the recovery of the funds.
Yeah, yes, they could subrogate and go after the perpetrator, but it would be a shared partnership between lenders who would probably pay the premiums through the mortgage and insurance companies. So there is a lot of innovation that could happen in this place where the risk is shared across the industry, and not just
brokers could provide that product option.
100%.
If they were to have it.
Yeah, you could add, the same way banks never miss an opportunity to add their own lender's mortgage insurance to a mortgage. They could, in fact, create a product that protects the homeowner instead.
Insurance.
And I think the point here is that it should be industry and government collaborating to devise these solutions.
Yeah.
The burden is continually being put on victim survivors and very under-resourced community organisations.
And now governments are coming on board, but we need the banks to come on board with a bit more than AI that says, I see you being abusive to your wife in texts.
Exactly. And to offer...
I'm actually going to be able to see you being abusive to your wife or your partner in your financial behaviours. I can see that, and I'm not going to allow that to continue, because there is financial risk to us as the bank, and there's severe social damage to the women and children who are in a lifelong relationship with us as the financial providers. So there's kind of a duty of care and a social licence to operate and provide product that is embedded in a shift.
Exactly. And we know that these issues transcend so many different government departments and industries and financial institutions, but again and again it's the victim survivors or their advocates that are forced to navigate these. And we have a case study in the Economic Abuse Reference Group submission, page 33, which details the story of a victim survivor whose partner had listed her as the director of his companies. And she left that relationship with $9 million worth of personal liability, and it took her 2 years and assistance from 46 individuals across multiple creditors, government departments, including the Australian Tax Office, including ASIC, lawyers, support services, financial counsellors, pro bono law firms to resolve this issue so that she could avoid bankruptcy and keep her home. And this, I would say, is a gold standard of what is achievable in probably 1% of cases. This client had the enormous fortune of finding a very experienced small business financial counsellor in a service that only operates in one state in Australia, and had the fortune of having someone going into bat for her and finding pro bono legal assistance from 4 different firms and testing pathways with the ATO with ASIC that had never been tested before. This is not what every victim survivor experiences.
Some woman. And I kind of think that the scale of it was important. So we're talking $9 million, right? Because often the stereotype is, and I've read one of the stories in already this morning, a 19-year-old who was severely abused by a partner. But this woman is more like a sophisticated investor, already a woman of wealth, probably a woman of significant education to be in that position. And this is not the stereotype, right? But it is classically still, if you are in a situation where there is power asymmetry, this can happen to you. It's not a factor of age, it's not a factor of education. And in fact, in some cases, the wealthier you are, the more likely you may be to be subject to predatory action. We're running over time, but I just want to get a little bit on the record about your recommendations 54 to 58 around bankruptcy and the case study of Jenny. And I do want you, before you go to that, just talk to 21, recommendation 21, where you make a very simple suggestion that to sign for withdrawals should be something that is a requirement in a joint facility.
Yeah, it seems like a no-brainer, really. This is just product design with safety from the beginning. Yeah.
So those who are interested, have a look at Recs 21, 22 and 23 with regard to very simple changes that require, I think you describe a little friction. Yeah, we can't have a fraction too much friction. Although it could be a good title for a song. Now, case study. Jenny was married for 12 years. Then you make 4 or 5 recommendations there around bankruptcy regulation. Could you speak to that, please?
I'll just note that actually just this morning, Attorney General Dreyfus has put out a media release addressing a bunch of these. There is some law reform on the table, which is exciting. It is the first time we've had an Attorney General go into bat for pro-debtor bankruptcy reforms in a long time. They don't go as far as we would like. We had called for a $50,000 threshold. I think it's going to double it from 10 to 20, which is a great change. But yeah, look, these are all going to be helpful reforms, and we do appreciate the Attorney General for pushing those forward, and we definitely support them getting passed in the spring, I think, is when they're coming. And there is, I think, going to be, I'm not sure it's in this submission, it probably was in the financial rights one, another consultation on a no asset procedure. We also really support that. That is something that comes from New Zealand. It's for debtors who have really no assets and need to go bankrupt. And even though for victim survivors of financial abuse, we would love them not to have to go bankrupt, but there are going to be lots of instances where a person does not get to see an advocate before they have already filled out a debtor's petition because they don't realize they have other options. And in that case, a 1-year no insolvency procedure is far less harmful for them than a full 3-year bankruptcy. It means it'll come off their credit report much sooner. It means they can have a fresh start in much faster. So that is another piece of law reform we would support. But again, there's just one of the things that isn't reforming is, again, we just need more friction in this process. A victim survivor with no access to financial counseling or no advice from an advocate can fill out a bankruptcy form online, and it gets approved by AFSA. If the form has been completed, it gets approved.
Now,
right?
The thing that concerns me most significantly about this, and this is what I want to try and get on the record and understand clearly, is the impact that would have then on a family, home, assets, and how is that failing? How is that part of the system failing? Somebody goes, oh, I've got too much debt, I can't do it. What am I going to do? Sign this form, agree to this, get the problem out of my day, take the kids to football. But there's a long-term consequence. So explain that, please, on the record.
One of the long-term consequences that appears when somebody might be going through property settlement is that a bankrupt spouse does not have standing in relation to the property that's vested in the trustee. They can't get orders from the Federal Circuit and Family Court in relation to that property. They can in relation to super, but it creates a situation where the perpetrator, who's not bankrupt, can get orders in relation to that property. So to be clear, the financial abuser does their whole abuse thing. There's racked up debts. There's a car that's in her name that he's written off. She's got the debt. Things are going badly. She's in a crisis situation. She signs this document. Now, in addition to burdening her with all the debt, he now gets rights to the house because she's taken the effort to try and clean up some of his mess. Yeah, or just tried to get debt collectors off her back, to be perfectly honest. Like, it could be just the pressure of having to deal with that and then being presented with bankruptcy and not really understanding the consequences that could, play out in the Federal Circuit Family Court. And that idea of a bankrupt spouse not having standing was designed to protect the non-bankrupt spouse, but what we're seeing here is an unintended consequence for people that have experienced financial abuse.
And so what's the fix?
Well, in our view, our accredited family law specialist is of the view that a bankrupt spouse who has experienced financial abuse or family violence should have standing in relation to that family court property settlement. That should be taken into account. I should note that there was an exposure draft released last year in relation to the Family Law Act amendments specifically to property settlement, and that introduces financial abuse and economic abuse as considerations in property settlement. But in that consultation, EARG raised this issue around bankruptcy because we saw that exposure draft did not resolve that issue. And we note that there's also, as Julie has pointed out, the Attorney General's Department doing work in relation to personal insolvency and looking at the review of bankruptcy. So there's two concurrent reviews happening and then operating in silos, and we have got recommendations in both of those consultations that talk about this issue. But it's probably a very good example of why we've recommended in our submission that there needs to be leadership through a task force, ideally through the Attorney General's Department.
So there's some
with secondees, harmonisation.
Federal entities, but also some harmonising, particularly when it comes to power of attorney within jurisdictions as well. So there's a bit of work to do there.
Absolutely, yeah.
Well, can I thank you very much for your evidence today? I'm just having a look at the time. So the committee will send you some questions on notice. If you could reply to those, if possible, by the 5th of August, that would be helpful. The committee will suspend for a short break and return at, let's say, 11:50. I now welcome representatives from Women's Legal Services Victoria. I understand that information on parliamentary privilege and the protection of witnesses giving evidence on two Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Jessica DeVries, Director of Legal Services. Bronwyn Davis, Family Violence Financial Counsellor.
Thank you very much. Do you have an opening statement? Yes. Thank you.
First off, I'd like to pay respect to the traditional custodians of the land, the Wurundjeri Woi-wurrung people and pay my respects to their elders past and present. Women's Legal Service is a not-for-profit specialist community legal centre that's been providing free specialist legal advice since 1982. We work with and for our clients to address legal issues arising from family violence and relationship breakdown. We work alongside our clients as advocates and lawyers to promote their rights to live free from violence and make informed choices about their relationships. Recognising the intersection between jurisdictions, we specialise in family violence, family law, migration, child protection, victims of crime and sexual assault. We focus on our clients' safety, recovery from violence and economic security. We do this by providing legal advice and representation to women and non-binary people with a wraparound model of service delivery where our clients are also supported by social workers and financial counsellors, depending on their needs. We also advocate for law and policy that respects and promotes the right of women and non-binary people, and building the capacity of other professionals and communities to identify and respond appropriately to legal need, particularly in the context of family violence. We are a member of Women's Legal Services Australia who previously gave evidence in Canberra, and we have also endorsed the recommendations by the Economic Abuse Reference Group. By way of background, in 2015, Women's Legal published the Stepping Stones report, which examined the legal barriers to economic equality after family violence. At that time, women that were interviewed identified that there was a lack of understanding by police of the financial consequences arising from family violence and a lack of action in stopping economic abuse. Conditions included in intervention orders were largely unhelpful in preventing economic abuse. Women who were often the victims had to flee their home and this had serious financial implications, and there was at that time a major shortage of available housing for women. Service providers such as energy retailers, telecommunications services and banks had a low awareness of the difficulties faced by women, and those industries were trying to enforce joint debts, even in circumstances of family violence, placing women and their financial recovery at risk. Women had little knowledge or understanding of their legal and financial rights following their experience of violence and separation, and this lack of knowledge often resulted in them staying in unsafe relationships. Women who were involved in family law proceedings to resolve financial issues experienced a lengthy and stressful process, and often the outcomes were inequitable and unfair. Many women chose not to pursue financial settlements after a relationship breakdown because of the barriers created by family violence, which further caused financial disadvantage for women. And perpetrators were using joint debt to continue to perpetrate violence against women with no legal recourse to sever their joint liability. Some 9 years on, women still continue to face these same barriers. Women's Legal Service staff report that financial abuse is experienced by most of our clients in some form, and its impacts are devastating and continue to be far-reaching. The harm can extend far beyond the time a victim survivor leaves a violent relationship. My name is Bronwyn. As I said, I'm a family violence financial counsellor. How family violence financial counselling is unique within the women's legal service space is that we provide a trauma-informed and safe journey for the victim survivor as they're predominantly coming to Women's Legal Service for legal advice, so we're there alongside them trying to assist them to resolve their financial matters so that they can work towards financial recovery. The legal system, as we know, is very traumatic, so we're there just to help minimise them repeating their story and taking some of those financial pressures off them while they're engaged with so many different services and supports.
Thank you very much, Ms Davis. Now, before we continue, let's just check our technology and make sure that it's all working. So can I just confirm that you can hear us and that we can hear you? I'll start with Senator Pratt.
Yes.
Great. You can hear us and we can hear you. Mr Hawke.
Yes, yeah, I can hear everybody.
Excellent. Thank you. Thank you very much. I will go to one of you, whoever seeks the call, to go first on this occasion. Is anyone seeking the call there, online? No.
Sorry, Chair, I just had an in.
Okay, Senator Pratt, you're ready to go?
Yes.
Thank you.
Thank you. Can I ask, in the context of what patterns you can see in people's bank accounts versus the tools you've got to resolve those with the banks quickly to protect your clients?
Sorry, can you repeat that, Senator Pratt?
Yes, thank you. Can you tell me about what you see in people's banking records and just an overview about how you try and resolve those issues in terms of preventing further abuse with banks? What obligations do they have to listen to you and take action, and what are the barriers there specifically? If you can step us through an example of that.
It's quite a big question. Some of the barriers.
Ms Davis.
Sorry.
I'll just put your name because
sorry.
Senators can't hear it. So Ms Davis is speaking.
Sorry.
No, sorry, it's good.
Some of the barriers that just come to mind straight away is just the level of evidence required when I do engage with a creditor around the family violence, and when working with a client, like they're part of the process through every step. So something that a creditor sends back, I'm sharing with that to the client. So the first thought of that client is, why don't they believe me? Why do I need to provide, like I've said this so many times, like why do I need to say it again and again? So that's one of the first things that come to mind is a barrier, just a level of evidence required to substantiate family violence. I think what else was part of the... Sorry. I think it can be quite complex. You're conducting often a forensic examination of those bank statements. You're tracking transfers from related accounts and trying to match and identify what those payments relate to.
Are you doing this on hard copies?
Yes, for the most part.
Which is quite different from an AI digital tool that could be applied to the information held by the financial institution.
That's right. So it is simply a manual examination of those bank accounts. What we do often really come up against is that we don't have access to all of the statements, all of the material, because there hasn't actually been full financial disclosure, particularly if it's in the context of a property settlement. So there are a lot of gaps, but then trying to get that information from the other party, even when they're legally represented, takes a lot of time, and often there's not a lot of recourse when they're not compliant with their obligations.
So in that context, that might include you might be able to access your own bank records going back a couple of years, but if you need to go back further than that, you have to apply to the bank. What kind of obligations could be on banks to provide information in an easily searchable manner? For example, if you've made substantial deposits into a spouse's account, what kind of obligations could accrue because of that to a bank in terms of providing those records to you as an organisation, by way of example?
Sorry, Bronwyn speaking here. Usually when I'm looking through bank statements, I'm looking for things to substantiate red flags to the banks. It's not necessarily that I'm looking for the same purpose that the lawyers are looking for in terms of needing to see substantial deposits. Like I'm just looking through, to identify some of those red flags that might be there, such as there could be multiple transfers going out a day to his
personal account, and then using that information to go back to the creditor to say, like, you should have been on notice that these things were happening at the time. And then I think legal would have a different perspective in terms of the information they're looking for through the bank statements.
Often our last resort, if we can't get disclosure, whether that's through the bank or through the other party who is the perpetrator, we may be relying on something like a subpoena. But that's only useful if you've actually got court proceedings. There's an emphasis in our system on, as you probably know, trying to settle and resolve financial disputes before you apply for orders in relation to a property settlement. So some of those...
You're flying blind then, aren't you?
Yes.
You've only got the drip feed of information that you can extract.
Yes.
Which may not disclose the whole situation. So what would a fix to that problem look like? What would you need?
I think
from the banks, right? Not putting it in the hands of another lawyer or a public servant. From the banks who are facilitating the behaviour, what do you need from them?
I think it's that ability to request information, even if the Privacy Act, there's the overlay of the Privacy Act that doesn't allow you to access accounts for the other person.
Yep. But it would be good if you were the person's friend down the street who just wanted to have a bit of a nosy.
Yes.
But they've actually gone to you and you have verified from your observation and understanding of them that they are in a situation of financial hardship at the very least, probably financial abuse. And with the authority of your role, your position, and the professional risk to you, to make sure that you don't do anything malicious, should that be sufficient to open the door to the bank to interact with the Privacy Act and say, like, a carve out for an inquiry of the kind that you need to make?
Definitely. I think often on its face, and this is across so many jurisdictions, there's not an understanding that there's professional consequences for us if we're making requests that are not supported by evidence and there are no grounds for. So we always use and request information ethically and in compliance with our legal obligations. But my colleague Bronwyn might be able to speak to this. An issue that they face as financial counsellors is often just verifying who they are with different institutions and say the ATO, and they have to give their MyGov details. They have to give personal information that
they'll ask for our tax file number with the ATO or date of birth, which then potentially compromises our privacy as well when having to give that when advocating. That is
presumably that's been set up to make sure that you're not the nosy parker down the road, right? So that there's some risk for you because you don't have a profession that could sanction you in the way they would sanction a.
I do, like, we financial counselling do belong to a peak body and there would be sanctions. I think it's just some institutions don't recognise financial counsellors in the same way that a lawyer is recognised, or an accountant or another profession. We're not always recognised in that to that same level, and that could be from a misunderstanding of what we do as well. I was just thinking of a good example of where, in Victoria, like Vic Roads, if there's family violence and if the car registration's in the person using violence name, but the victim survivor has always driven that car, has always had possession of that car, then they can apply to Vic Roads to have the registration transferred in their name, and there's a bit of a process with that, but there are things in place when there's family violence to allow these sort of things to happen. So the same would be for the Privacy Act, like there needs to be discretion in a similar sort of way to allow things to happen when there is family violence.
Thank you, Ms Davis. Back to you, Senator Pratt.
Thank you, Chair. What difference would the equivalent of safety by design obligations, a bit like design and distribution obligations, which I do understand are reasonably new, what difference could they make, and how could some of the difficulties you have in accessing information be embedded in not just how products are used and distributed and the technical details of them, but also access to information for you as financial counsellors or legal professionals, for example?
not sure how to answer it. If we can, we'll take that question on notice.
Thank you. Last question, Senator Pratt.
I think I can leave it there and listen to other people's questions, and do come back to me if there's time.
Thank you very much. Ms Mascarenhas.
Since you guys look at this from a legal framework, from your perspective, what do you see as the biggest federal government legal gaps in helping victim survivors achieve financial justice?
Can't provide an easy answer because I don't think there is just one solution.
You're welcome to talk about a few.
Yes. It's a whole host of things. I think our learned colleagues before spoke about the reforms to the Family Law Act and the exposure draft that was released last year that was seeking to amend the Family Law Act to modernise it, but also what we were advocating for is that family violence should be a consideration in a property settlement. So you're looking at legal reforms in the family law space, in banking and in financial regulation, but it's multifaceted. It's not only just about that person's interaction with those institutions, if we're looking at it in that sense, it's also then, well, if that interaction was poor, if they weren't actually complying with their obligations, what redress or what recourse do they have for those decisions to be reviewed and for banks to be held account in those instances. And it really does require a strong regulator and a strong system for independent review. And then on top of that, you've also got how you've got government bodies like the ATO, Services Australia and ASIC, and how that they could be sort of strengthening their responses to this issue and actually being able to provide legitimate redress for victims of family violence who've experienced financial abuse. What we see working in migration, for example, is that women on no visas, they have sometimes no options for social security support once they leave a relationship, and so that can then put them down a pathway where they are incurring significant debt just to survive. So in our submission that's to follow, we talk about Bianca, who came here on a temporary visa, for example, and when the relationship broke down and she began to fear for her safety, she fled the relationship. She had to take out payday loans to be able to pay for rent and bond to secure housing. That was the only financial support she was able to access, and she had some casual employment, but it was quite precarious. She eventually received assistance from our service and financial counsellors and social workers assisted her to apply for family violence flexible support packages, which is offered by the Victorian Government, and PRAP, which is the Private Rental Assistance Program, where, again, the Victorian Government assists with the payment of tenancy bonds. In that circumstance, she was only forced to go down the road of getting payday loans because she actually didn't have a social security safety net. And it then has lifelong impacts for them if we're not able to get the debts waived. And then there's the ensuing issues with their credit history as well. And then we have, for some clients on visas, they have no work rights. So if there's no social security safety net and they can't work, there's very little that they can use to survive.
Following on from that, one of the things that I was curious to have an understanding of is the access to services for women from culturally and linguistically diverse backgrounds and other disadvantaged groups, women with disabilities. Do you feel like the system is set up to support them, and there's probably an opportunity to also talk about that segment of people that don't have visa rights in Australia?
I don't think the system is set up to support them. contracts and any other documents relating to finance. They're difficult for someone to read if they're a native English speaker. It doesn't matter if you try and use plain language, if you're using words like encumber or mortgagee, mortgagor. It's another language even to, I think, someone who's a native English speaker. And then
they might only encounter it once in their lifetime, right?
Yes, that's right. And then that's it becomes even more difficult if you're from a culturally and linguistically diverse background. And even if there was written, translated information about those products available, a lot of our clients aren't actually fluent or literate in their main language. So even that is not enough. So it's access to interpreters.
And who pays the cost for that?
The onus should be on the bank.
Why is that? That's going to make it more expensive for everybody else. Here, I'm just going to put it all on the record. That's the kind of response we'll get.
Our clients can't afford to live, let alone afford to pay for an interpreter. We rely to provide our services on an interpreter's fund to be able to pay for those services for our clients.
Do you need those interpreters to be multi-skilled in that they could observe coercion and culturally literate?
Yes, we do. We see in the case of some interpreters and translators who do not have the highest qualification, for example, that they actually can reinforce and perpetrate the power and control that someone has experienced, particularly where they're from a particular cultural background. For example, why are you thinking about leaving? You shouldn't leave. They can have all of those conversations with a client in language that we have no perception or understanding of. And so sometimes we've had, if clients have some English, they'll be able to tell us afterwards, I felt really unsafe, or that was not what I said, and he was telling me to do this. So it's about having access to interpreters that are appropriately trained and trained in family violence as well, so that they're not...
How many banks have a suite of highly trained, suitably educated and aware people in their employ to do this kind of work?
I'm not sure, but when I ask a client, did you have access to an interpreter when signing or anything related to what we're talking about, the answer is usually no, or that they weren't offered one. So yeah, I'm not sure what the banks have available, but the answer is usually no.
So legally, if someone doesn't understand the contract that they're signing, is that contract still a binding agreement?
I'm not sure, because I come from it from a different approach in that you didn't have it. And usually it's not just that on its own as well. There's other red flags as well when trying to resolve the issue. And a bit like how I think it was Julia talking before, how it goes down like that hardship path. That's usually what happens too when we raise all these red flags. Usually the path of complaint changes to hardship. They'll waive it. The client is satisfied with that because it means they can move on. And we don't always get to see accountability or the outcome for what it actually is.
Do you ever see anything like a requirement for somebody who's undertaking a loan to write in their own word and their own hand what they understand they're doing?
It would be nice if things were like in person in that way rather than just ticking something online. I think it would help minimise how some of these loans are put through so quickly. I live in regional Victoria as well. Like, a lot of banks are closing, so a lot of the stuff that's happening is all online. They can't necessarily go into their local bank because they're closing one at a time, or even just local services are closing in the regional area. So that's a huge barrier as well. But yeah, it would be nice if something like how they were talking about that 60 seconds, like why does something need to be 60 seconds? Like, that there's a bit of time behind something before it's being approved.
Often the only thing they're required to do is sign their name.
What do you recommend, Ms. De Vries?
I think, like Bronwyn was saying, in-person interactions are ideal, as are as I was saying before, access to interpreters, so you can explain in language, these are your obligations, and then you can, the bank or whoever's on the other end can then really test, do you understand what you're signing, essentially. I know here, as lawyers, we, particularly when we're working with elderly clients or with mental health or disabilities, we'll do capacity tests. So we'll test the capacity of that person to understand what transaction they're entering into, what are the implications, and then we may assist them, for example, to make a power of attorney. So it's really putting in place processes that really do test the understanding of our clients, but also letting them understand this is where they can get further help if they want to make informed decisions.
So if you had something that would say even, have you got your own bank account? How much money do you need to operate your personal budget every month? Have you ever been stopped from working or earning money by your partner? Have you ever been forced to sign over any financial assets that you own? Have you been required to pay a dowry? Does anyone in your partner's or husband's family hold jewellery that you once belonged to you? Like, if there were like a series of questions that people actually had to answer no to, I'm sure coercive control could still push for that, but it would be a little more friction that might be dissuading for some individuals.
And sometimes it's only in asking those questions, it'll be the first time they've actually been asked that, and they may actually have an understanding of, so that's family violence, that's sexual assault. So even if they're still mired in a relationship that's unsafe, it might be that first opportunity for them to get some awareness that what's happening, and so, for example, the loan that they're being asked to co-sign, is not for their benefit and not in their interest, and something that they could be coerced into doing. Like you said, it won't stop everything, because I think if you've got a coercive partner, that relationship of power, control and fear might still make you say, no, I'll sign on the dotted line. But
there's the three words, you've just used them: power, control and fear. If any of those things are happening, power, asymmetry, control of your behaviours, if you are fearful, then these are all significant indicators.
And that's where we need, so when they eventually do leave that situation, that's where we need the institutions to respond appropriately after. So if something's gone through due to the financial abuse and family violence, it's after when they've left, which they could still be at risk of family violence, but that's when we need the institutions as well to respond appropriately and not put so much burden on the victim survivor with evidence and in what they're asking for. There seems to be an assumption that they've left, therefore they have all the answers right there and then in terms of what their situation is going to look like, and there can be pushback from institutions as well. And it might be a couple of years down the track that someone decides to come through financial counselling to resolve their financial issues when things are a bit more stable and they don't have as much going on in other areas.
Yeah, they sort out as much as they can themselves before they come to you guys.
Potentially. Can I just...
Last question, because I think we need to get on to our next witnesses.
It was going to be from a culturally and linguistically diverse background perspective, and a sense of whether there are enough people from COLD backgrounds in banking institutions or even support services. And the thing that I see when I just go door knocking, when a volunteer knocks on the door and they're from a Caucasian background, there's not a conversation. But when I come up, there's so much more dialogue. And the thing that I just have a sense of is that whether we're getting a full sense of the picture and making sure that we have that more wholesome discussion that's happening. So maybe it's a conversation of whether you think that there's enough cold support for.
I'd say there's not. And I would even say when I have someone come through as a client, like even I need to check with other people and services to make sure that what I'm saying and asking is appropriate, because I don't know everything about every culture, and I want to make sure even the service I'm providing is safe for that person. So there's always something to learn and do around that as well.
Good to begin with common humanity. And then we need extras on top of that, don't we, to try and understand one another. Can I thank you very much for coming to give us evidence today and for all the work that you do in supporting people who find themselves in a very difficult position in their life. May your work continue to become smaller.
Thank you.
If there are questions on notice, and I expect there will be, could they be provided by the 5th of August? I now welcome Dr. Manjula Data O'Connor, representing the Australasian Centre for Human Rights and Health. I understand, Dr. O'Connor, that information on parliamentary privilege and the protection of witnesses giving evidence to the Senate has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
My name is Manjula O'Connor. Data is my maiden name. Just put it in the middle.
Thank you.
Sorry, what else do you want to know?
That's all. Do you have an opening statement that you
Yes,
want
I
to
do.
read to the committee?
I do.
Thank you.
I'm grateful for this opportunity to present the views of Australasian Centre for Human Rights and Health regarding migrant women, especially those from South Australia, South Asia, not South Australia. So that was just a abbreviation I'd put in there. Financial economic abuse is an important problem that specifically is enlarged among migrant and refugee populations. Certain cultural practices make them more vulnerable. For example, male control of finance is an acceptable practice in patriarchal traditions and cultures such as the South Asian. The cultural acceptance of control of the household money, the joint and the individual bank accounts by men is a symbol of unity between the man and the woman. The acceptance of male control of finances makes it hard for the victims to identify when the culturally acceptable practices can cross the line and become abusive. And this is the reason why financial economic abuse remains a hidden form of domestic violence amongst migrant and refugee communities. And to that, I can add my experience as a psychiatrist, expert in this area of gender-based violence. I see these women in my own clinical practice, mostly women from South Asian background, from the cold communities, as you were saying before. And I have published papers that show that the financial abuse amongst women who were presenting with the suicidal ideation, it was almost 100%. 100% of women were suffering some form of economic abuse and coercion about money. And later, as I will speak about, the dowry demands and the dowry abuse. Language barriers and lack of knowledge of system poses barriers to help seeking until it's too late. And I've seen women in my practice who have been ripped apart, having their savings all gone, completely lost by these men who have come into the country, sometimes even sponsored by the women, and have taken their savings. So there is a strong role of institutions that can help women. So the banking system, when the women notice that there is a huge amount of dollars being transferred, often women who have complained to the banks that the banks have not been helpful, particularly because their accounts are often in joint names, and therefore banks don't quite understand why this woman is complaining about the fact that her husband has taken money, because on the surface of it, she's given permission to do so. And whereas the permission is basically almost, as I said before, a cultural practice that really disadvantages women in patriarchal cultures. And that's the thing that, as you were saying before, people who are not from these cultures, like patriarchal cultures, don't quite recognize the pressure the women are under to comply with the coercive demands of the men, their husbands. And when they go to the banks, they will say, but you've got your signature here, or you had a joint account operating. So this is something that the banks really need to come to grips with. And it's so important to have those culturally aware personnel working there, or people, preferably people from the cultural background, so that the diversity of the bank employees represents the clients that they are serving. Do you want to talk about the role of ASIC? Now, South Asian community, particularly the Indian community to which I belong myself, are a very enterprising community. They're very ambitious, and they have, the minute they land into the country, they start to do business, and they have companies that have directors. And often people, males who are toxic and abusive, tend to then take advantage of their vulnerability of their ignorant wives, who are made directors of the company without their knowledge of serious responsibilities that they are landing themselves in. And women don't often know that they are going to be actually responsible for losses of the company. And this is the role of the ASIC, that they have to be very aware, dealing with the culturally linguistic background women who are migrants, especially first-generation migrant women, that they recognize that this is not a small thing that they are taking on. And as I said before, I see these women in my practice and also in the community, and I have heard some horrendous stories. I want to speak about the role of family law courts, because they do not appear to be familiar in the myriad ways in which financial abuse is being perpetrated by perpetrators who stand to gain from the cultural tradition of collectivist patriarchal societies, but at the same time, when it suits them, they become like part of the Western individualistic culture, which is self-centered in the way the affairs are run. So the law courts are actually making decisions regarding these money matters that are effectively based on either fake or no information provided by the perpetrators, and they're gaining financial benefits by claiming parts in the marital property to which they have not even added a cent, as well as removing their own savings and showing losses, so that the victim actually gets none of their access to their savings. It's causing women to become extremely poor after divorce, and that is a major problem, because the family law courts, most of the judges do not have the culturally linguistic background, and they don't understand the migrant, particularly women who are not as well aware of the systems as their partners or their perpetrators. and the courts are being gaslit by these people, and they don't recognize it. So there are other examples. Now, I want to talk about the dowry abuse. And dowry is got different meaning in different cultures. So in the context of South Asian marriage, it's the bride and the bride's family that give what are called oversized gifts to the groom's family. And in the African context and the Middle Eastern context, dowry cash, which is actually in the form of cows, each cow is about $1,000. African context, dowry cash is given by the groom to the bride's family. And there are abuses that go on in that system as well, but I'm not fully aware of those because those are not well studied, but I am going to speak about the South Asian context, of which I am an expert. So typically, dowry gifts tend to equal or exceed the annual income of the giving family, and that is it's not considered a crime, but it is an enormous social pressure on the families. The bride's parents willingly or not give gifts to the groom and his family. The cultural practice of dowry giving has the potential to give rise to a sense of entitlement among those grooms and their parents, those people who are abusive and toxic. Dowry becomes abusive when the groom and his family demand, extort, coerce, feel aggrieved by the amount, content, or quality of dowry gifts, and feel entitled to demand gifts before, during, or after the marriage. Such dissatisfaction and refusal to comply by the victim is known to lead to violence, emotional abuse, and even murder in Australia. The problem can be facilitated or exaggerated by the process of migration. Citizenship, residency of a rich country like Australia makes the groom very valuable in the eyes of the prospective bride's parents back in India or in other South Asian countries. It signals that their daughter is going to have a good life, and that's why they are willing to pay more heavier dowry amounts. And this, in fact, the sponsor, who is been in Australia usually for many years, has a lot more power in the eyes of the bride and her family, and this gives rise to a lot of power differential and lays down opportunities for abuse. And so the migrant spouse, usually women, are vulnerable to coercion, control, extortion, emotional and physical violence. And as I said before, in 2015, we had one murder in Melbourne. There was lots of years of dowry demands and coercive demands that eventually led to murder.
Dr. O'Connor, I'm going to ask you to table the rest of your statement because I know we've got limited time and there are many questions. So it'll go up on our website. But can I just go to my colleague, Ms. Mascarenas, to begin asking some questions?
Sure.
Thank you.
My understanding is that in India that dowry has been made illegal.
Yes.
And can you talk about how much that's actually implemented and in my mind, dowry abuse happening in Australia, I see as a transnational crime.
Yes.
In my mind.
Yes, but So, in India, dowry abuse was made illegal in 1961, and then the laws were further strengthened in 1985, and the problem was so acute over there that women were being murdered on a regular basis. And usually they were burnt brides, like, their saris would catch fire, and usually sitting and cooking by the stove. And it became well known whenever a story came, bride was burnt, that it was related to dowry violence. and that's why the feminists of India, who are quite strong, in fact, further, said to the government that the laws of 61 are not enough. So then it became a non-bailable offence, that as soon as an in-laws and husband was implicated, they were put in jail without further question, and then proper hearing would happen after that. But it's a but that it has given rise to some impact, in that people now realize in India that it is a bad thing to do, but it has not stopped. It has not stopped. Massive amounts of dowry still is given from the bride to the groom because of the fear of the parents that the groom will not be happy and his family will not be happy if they don't give their daughter significant amount of gifts like household appliances and cash and gold and jewelry and diamonds and so on. And the richer the countries become, more the dowry gifts are being given. Now, what's happening is that those gifts are given in India, and the groom brings back to Australia the cash and the gold or whatever else he can carry, and the rest is left with the parents over there. So when he comes to Australia, and if he is, for example, in debt, say for international student loan, then he feels it's his entitlement to ask for more money from the parents. And if she refuses to ask them, because, and I have hundreds of patients like that if she refuses to ask, then there is an ongoing coercive demands. And unfortunately, it is sad indictment of mother-in-laws, but the mother-in-laws often play a big role in inciting their sons to create this atmosphere of continuous demands, put-downs, and withholding of affection, social exclusion within the family. This is a new daughter-in-law who wants to belong to the family, and because she is not providing more dowry, then she gives rise to exclusion and depression and suicidal behaviors.
Do you think that there are legislative instruments that we need to prevent dowry abuse from happening here in Australia?
They're not adequate. We have Senator Pratt, I heard, is here. Yes. She was part of the
dowry
inquiry in 2017, where I gave evidence, and the inquiry recommended that the dowry abuse be included in Family Law Act, so that everyone knows very clearly that this is not on in Australia. And unfortunately, whilst the government responded to every other recommendation, which was related to Migration Act and various other things, this one, our main recommendation or main request and recommendation from the committee has not been implemented yet, and we are unable to understand what the problem is. It's such an easy thing to do. It's an example of economical abuse. Not that hard. When I met with the policymakers of the Attorney General's Department, they said, but, we have economical abuse. Why do you need dowry abuse in there? Because it's a fundamentally different crime, and it's a transnational crime, because we do think that there is a possibility of working across the nations in solving it. And if we have the law here, we can then firstly work with other NGOs in India to educate the communities about what this transnational crime looks like, so the parents are more open-eyed when they are choosing the grooms for their daughters, because a lot of these are arranged marriages, and that they don't understand the vulnerability their daughters are being put through, that they need to be aware of the red flags when people start to demand money, car, extra jewelry for their relatives or for their grandchildren or aunties or grandmothers, that this is not going to stop here.
Do you think that our immigration system could play a role in almost having a check to see if dowry is an aspect of a relationship. And the thing that I know with partner visas is that there's a real sense of the department wanting to test that it's a real and genuine relationship. Do you think that that's maybe an instrument that would help work out those genuine relationships versus relationships that might have financial abuse / dowry abuse in them?
Yeah, so we have made a lot of recommendations to the government around temporary visa holders and including dowry as an example of family violence on its own to qualify for the residency visa for these women whose sponsors withdraw their sponsorship. And it has, I think it is in the Migration Act now. I have a meeting with the Home Affairs next week again, and I will definitely be asking them to look at it again. So the other thing was about the validity of whether the marriage is genuine or not. Now, it's not quite connected with dowry because it's always given in the context of a marriage, but it's a separate issue, and we do think that the government has come around to our way of thinking that it's not always possible to demonstrate that they are partners living in partners together in Australia if the perpetrator refuses to have their name on the lease or in the joint bank accounts and things like that. And I think the Migration Act, I got an email last week to say that they are going to expand the provision. And once again, as I said, I have a meeting with them next week, and we hope we will be able to convince them to add those factors.
There was a statistic we heard earlier about a NGO that was having a discussion with women from a cold background, and the question that was asked was whether these women knew whether they had a bank account or not. So it wasn't about financial abuse or dowry abuse, it was just simply, do you know if you have a bank account? 16 out of the 24 women did not know if they had a bank account. To me, that's an indication of financial literacy of some cold or migrant women within Australia. Do you have any comments or observations on that?
Yes, I have seen that. The women don't have a bank account of their own. But when they start work, they almost always have a bank account. The only problem is that those bank accounts are operated by their perpetrators. And so they look like they're in control, but they are not in control. And this is where it's much more difficult to detect. But for women who arrive and recently arrived and haven't started work, or they are here, the other category of women who suffer enormously are those who come on tourist visa, but they have been married abroad. And their perpetrators bring them here on a tourist visa because the perpetrator never had intention of marrying them and never had intention of living with them unless they had complied with their demand for enormous amount of cash and gifts. And I've had so many of these women, and unfortunately, yes, they don't have bank accounts, they don't have name on their lease because sometimes the perpetrators own the properties when the women come. And so this is something that definitely the immigration department can do at the port where the visa is given, that the woman is actually asked to have a bank account open here so that it can be like a legitimate, her legitimacy in the country.
Senator Pratt, some questions?
Thank you, and I want to thank Dr. Marta O'Connor for your work with the committee now and on the previous dowry abuse inquiry. I understand that the current government responded to the 2017 report, and it sounds like from what you're saying, you're working with them now to work through implementation of the migration recommendations, because I read their response to the report and I could see that those
had been supported. What kinds of issues should we be looking at as a committee to, I guess, support their proper implementation, as well as, yes, picking up the definition of dowry abuse in the Family Law Act?
I think, Senator Pratt, I really do thank you for that 217 hearing. It was such a momentous time for us. So the one thing is that we do need the dowry abuse definitely included within the Family Law Act. We already have a definition of dowry abuse within our laws of Australia, as in the Victorian Family Violence Protection Act. We already have been able to get that in there. So that definition can easily be transported into the Family Law Act. And the second thing is that whilst the government responded to the recommendations, as I said before, most of their responses were they were willing to act on them, but the one that we wanted mainly about the Family Law Act, they have not still done it, and that's about nearly 6 years later. And the second thing is that if dowry abuse was included in that coercive control legislations of each of the states, that would make a big difference as well. The national principles of coercive control were released by the Attorney General's Department last year in December, and that in that, dowry abuse is mentioned as an example of economical abuse in their paper, which was good to see. We just want that this becomes part of the legislation. Now, I have not seen the New South Wales Coercive Control Act, which I have to, because it was only recently proclaimed. So I have to go and see in that as to what they have done with the dowry abuse. I did recommend it to them. I did appear at the hearing. So hopefully, so the immigration one, there is some movement in that, in the sense that I can't remember whether they have formally written it, but they are definitely accepting it in cases when they're coming through, because some of my ladies that I've seen in my clinical practice and have referred to Immigration Department just based on dowry abuse have received their permanent residency visas based on that and economical abuse. So there is a lot more, there's a sense that the Immigration Department is a lot more receptive and not necessarily, they're more open to ideas and suggestions, and very cooperative and helpful, and we're very grateful to them for that.
In the context of your submission where you've raised directorships, what could the regulator do when people apply, for example, for a director's number, to ensure that, I guess, someone is a fit and proper person in terms of understanding their responsibilities, but equally, even if they do understand their responsibilities, they might not be able to decline if they've been coerced into holding that position. How could we work with ASIC and other regulators on that issue?
The ideal would be that ASIC actually has a contact person for these, particularly women who are applying for directorship. It should not, I know it costs money, everything costs money, but it would be very useful if they did have someone who could just pick up a phone and give them a call and say, do you realize this is a very serious responsibility, and you could land up and have a personal phone call without the perpetrator or without their other partners being present. I think a people's person or someone to connect with the these migrant women is, I think, it'll be a very important and useful step.
And what about obligations on those coercing someone into becoming a director?
I'm sorry, I didn't.
What about obligations on somebody who coerces someone to become a director?
Oh, right. So basically, the person who actually, I'm not sure if, say you have a company and you want more directors on it, and you want to invite, maybe that person needs to know if they are inviting other people that this is actually putting the other people in jeopardy by doing that. Like the losses, they have to be borne by individual directors, individually and severally. That's the word that's used, and that is a very like, if the company is making money, great, but when it's starting to lose money, it's a very big burden on people who are directors of the company. And so I do believe that ASIC has a responsibility dealing with migrant women, migrant people, but I think generally they should be informing people that this is not something to be taken lightly.
Thank you. Back to you, Ms. Mascarenas.
One of the aspects that I think is different in financial abuse in subcontinental culture is the aspect around jewelry. And like I know that jewelry is often a part of gifts that are given, and but it's also something that's not in a bank account. It's not something that it's a tangible thing that you touch. And I'm wondering what rules we can have in place around that aspect, because I know that sometimes, you know, a bride will have $10,000 worth of jewelry, which ends up being given to the mother-in-law, never to be seen again, particularly if they flee that relationship. There's also this aspect of like who owns that jewelry, and whether once someone leaves a relationship, whether they've got the legal rights to try and obtain some of those assets, whether it's in a bank account or whether it's jewelry.
That's the reason why we need the transnational awareness and regulation, because the jewelry, you said 10,000. Well, 10,000 gets you nothing now. Right. it's usually between $50,000 to $100,000. It's not small amounts of money we're talking about. Yeah. And so this jewelry, as you said, is often kept by the mother-in-law back in India. Or if they do bring it to Australia, the husband will take control, and the mother-in-law is usually here as well. She will take control. And when the relationship breaks down, the first thing is the casualty is the truth, right? Yeah. No, she never gave it to us. Or she took it back, and we never seen it. And so what really needs to happen here is, and this is so difficult because when the women are getting married and coming from their country to a totally new country, new family, they don't want to think about things going wrong. Who wants to think about your marriage or ending up in domestic violence? They think there is so much trust put upon that man that this jewelry that she will be safe and all her assets will be safe. And they don't read anything about domestic violence. They don't read anything about dowry abuse. And we, even though there is an app, government app, that the women get given to look at about domestic violence, most women don't look at it. And we do believe that, and the Department of Social Services, we asked them to make a pamphlet and hand it to people when they get the visa in their country. And they did do it, but it's now gone like online. We still believe that a paper pamphlet would be an important thing to do for women to give to them. But more importantly, I think the men who are getting married need to have it. They need to know. They can't do this thing. Yeah. You would be surprised. It is so common. It's so common in Australia. And nobody ever thought Australia has a dowry abuse problem. When I first led the campaign in 2012, the patriarchs of the community said, there is no such problem. You are making it up. And now it's almost ubiquitous. If you see it, you know what it is, and the women feel confident to speak about it because previously they weren't telling anyone. They never thought anybody would understand. But we really do need to create transnational apparatus to educate as well as to work with the governments across both countries to see what can be done here, because it's not just a problem of Australia, India, it's a problem across India, UK, US, Europe, Middle East. It's global.
Well, thank you very much for your submission. Thank you for your continued public advocacy. I knew the 2017 report because Senator Pratt certainly made us all aware of that. But from 2012 to be doing this, 12 years later, it's a very, very important time for your evidence to come forward. So thank you very much for your contribution today, Dr. O'Connor. There may well be some questions on notice, and if you could provide responses to those by the 5th of August, that would be most helpful. Good luck in your further work. The committee stands adjourned for a break now and will resume at 2 p.m.
Can we take a picture?
Thank you. I now welcome representatives from the Australian Banking Association. I understand that information on parliamentary privilege, the protection of witnesses giving evidence to Senate committees, has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Thank you. Anna Bligh, CEO of the Australian Banking Association, and my colleague
Amanda Pullinger, Head of Customer Policy.
Wonderful. Thank you very much. And do you have an opening statement?
Yes.
Thank you.
I start by thanking the committee for the opportunity to appear before you today, and I'd like to start by recognising the traditional owners of the land on which we meet, the Wurundjeri people. I pay my respect to their elders past and present and extend that respect to all other First Nations people. For the committee's benefit, the ABA's membership includes 20 banks from across Australia, including the 4 major banks, as well as Australia's mid-tier banks and international banks. I want to start by saying that the ABA and all of our members welcome this committee's work to further shine a light on what we regard as a very important issue. Many years ago, financial abuse would have been rarely on bank employees' minds, and most customers wouldn't have thought or wanted their bank to be involved. Fast forward to now, and financial abuse is an issue that banks and their staff are confronted with every day, whether it be in the context of family and domestic violence or abuse involving older Australians or people with a disability. Both forms of abuse have their different challenges and complexities. However, both of them take away the financial independence of an individual, and both often involve coercive control. Another complexity is that financial abuse is often hidden. It can be incredibly difficult to see, as abusive behaviour such as controlling a victim's finances can appear identical in bank records to a healthy relationship where there are arrangements for one partner to manage most of the finances. Its hidden nature therefore presents additional challenges for banks, although significant inroads have been made across the industry to better prevent, identify and support customers impacted by financial abuse. Much of this effort has been centred around making it clear to victims of financial abuse that they are not alone and that banks have a range of support options available to help them get back on their feet. Banks can help in very practical ways, whether it be assistance in opening up new accounts, resolving issues around joint accounts, advice on financial hardship, and referrals to extra support services. The ABA continues to work closely with our members on how they can continue to support customers. We have, for example, developed industry guidance with guidelines related to elder abuse first released in 2014 and in 2016 for domestic and family violence. These guidelines are there to help banks provide consistent arrangements to support customers and cover important areas such as awareness raising, staff training, communicating with customers in a safe and confidential way, and referring customers to internal and external support. Both guidelines were reviewed and updated in 2021 and will be reviewed again later this year to ensure that they remain best practice. Our Banking Code of Practice also sets out enforceable standards that individuals can expect from banks, including taking extra care with customers who are experiencing vulnerability. An updated code was approved by ASIC late last month and comes into effect in February 2025. We have also led various external communication campaigns to raise awareness about financial abuse, elder abuse and financial hardship. An ABA member working group also drives ongoing industry-level policy development on assisting vulnerable customers. One piece of work that the industry can be very proud of, I think, is the commitment by many ABA members to adopt the use of financial safety by design principles. This is world-leading work to better protect people facing financial abuse. Across the industry, 16 banks have updated their terms and conditions to make it clear that their services and products cannot be misused to perpetrate financial abuse. Banks are working on how to best to design their products and services with a safety by design lens. This must be done with a measured approach and informed by consultation with advocacy groups and victim survivors. Because as our world continues to digitise and evolve, so too does the nature of abuse. This can mean that despite best intentions, there are times when the design of preventative measures can then be weaponised by perpetrators. To illustrate the complexity, 2 to authorise arrangements were introduced as a measure to stop an individual withdrawing cash from joint accounts or redraw facilities without the consent of both partners. Unfortunately, banks have subsequently seen that these arrangements can also be used as a tool of abuse to prevent the other joint account holder using the account independently or setting up recurring payments, for example, from the account. Whilst measures by banks have helped to keep customers financially safe, there is always more that can be done. Our submission makes a number of recommendations about law reform that we believe are crucial to elevating the industry's approach to the financial abuse. I'd like to just highlight two of the changes that we believe are well overdue and absolutely key to achieving better visibility of abuse and the ability to act on it. Firstly, industry has proposed changes to the privacy regime to make it more straightforward for banks to report suspected cases of elder financial abuse to authorities in circumstances where the bank is alerted through changes to transaction data but is not able to establish informed and express consent from the customer. Second are proposed changes to Australia's enduring power of attorney arrangements that were recommended in 2017 by the Australian Law Reform Commission. These include the harmonisation of enduring power attorney arrangements across all jurisdictions and the introduction of a national online register so that banks and other financial institutions and service providers can more easily establish the authenticity and currency of these instruments. I draw the committee's attention to the fact that it has now been 7 years since the Australian Law Reform Commission made these recommendations, and we have seen no progress to date. Again, thank you for the opportunity to appear, and I'm very happy to take your questions.
Thank you very much, Ms. Bly. Ms. Bullinger, did you have anything that you wanted to add?
No.
Thank you very much. I'll go straight to you, Ms. Mascarenhas. Just so everyone knows, this is a unanimously agreed inquiry by the committee, but the idea came from Ms. Mascarenhas.
I think that it's great that you guys have 20 organisations that you represent, that you'll have a sense of purpose and oversight as to what they're doing in relation to financial abuse. Recognise that different organisations will be at a different stage of their journey on being proactive in preventing and stopping financial abuse. Do you guys do a benchmarking exercise to have a look at where the 20 banks are at? And I recognise that there's a code of practice and people have adopted it, and I think that I think you said that 16 organisations have implemented some good recommendations, but yeah, I'd like to get a bit of a sense from a benchmarking perspective.
Sure. Well, we're not a regulator, so I think I wouldn't describe it as benchmarking in that sense, but as I said, we do have a working group on financial abuse. It meets very regularly and represents all of our banks that have a substantial retail offering. And in that committee, very regularly, these issues are discussed. And banks are pretty honest with each other about these things. This is, on the one hand, they've got to be very, very careful when they talk about products because of competition law. But ensuring that customers are safe is not really an area that they compete on, and so they, they work through where they're up to on particular things, and often one bank will say, "We've just noticed something happening in our bank. Have you seen this? This is what we're doing about it." So sharing that kind of information. As I said, we're not a regulator, but if we knew that we had a particular member that was, either really dragging the chain or for some reason was finding it difficult to implement, then we'd obviously be having conversations with them.
And is there a set? Do your members submit data to you guys so you've got a bit of a sense of how much financial abuse is happening from a sectorial perspective?
No, they don't. Most of them would collect information internally about how many cases of various kinds that they had seen, but they very likely collected in different ways. And I think data is really important, and it's a really important and powerful tool in understanding any social policy issue. And I think one of the things this whole exercise has given us some pause for thought is what would more effective data collection look like? Where is that data best collected? So every now and then, for a particular purpose, we might put a data request to our members, but they have very large data obligations to government agencies such as the Bureau of Statistics, to ASIC, to APRA, predominantly to APRA, and then the other regulators use that data. So, there is, I think there is a lot of scope here to think about what sort of data would be helpful, not only to banks but to government. So government already looks at APRA, for example. Banks are required to submit monthly, I think, or maybe quarterly data on the number of customers in default, and whether they're in 30-day default, 60-day, 90-day default. And that's a very helpful tool for the economic agencies of government to understand when there's economic pressure in the economy. So there's probably something that I think we could, think about here that would get us more comprehensive data. I know you're talking to member banks over the next couple of days. You'll find, I think, that a lot of them will have some of their own data, but it won't necessarily be collected on an apples for apples basis. And that, I think, requires a bit of external thinking.
Yeah, I think data poverty really about things that matter in this context is just the reality of it. There seems to be a lot of blind spots where information is held but not shared, perhaps held in particular ways that doesn't reveal the cost to the person who is a victim survivor, but is a debt management tool and measurement of that. So it's looking at it from one way or another, two sides of a very joined coin, but different data points that don't really reveal what we know is $5.7 billion per annum impact and $5.2 billion particularly for those who experience domestic financial abuse.
Yeah. And I think you're absolutely right. I think definitions is one of the things that's a bit, tricky. Particularly when you're talking about calculating losses, one of the things that defines this sort of financial abuse as opposed to something like a scam is that often ownership of the funds is contested between the two parties. And so at what point and how do you determine exactly? But I think that doesn't mean that there's not a lot of data that could be collected very rigorously. And even if that data's a bit, even if it's not 100% accurate, it would at least show you trends where things are going up or down, I think.
Can I borrow this diagram for a moment?
Maybe we could get one in front of you as well.
It's okay, I'm familiar with it.
Yeah, great. So the thing that I find fascinating about Catherine Fitzpatrick's diagram on financial abuse and the parallels associated with frauds and scams. And so when we're looking at frauds, it's from an economy perspective, it's about $0.7 billion. For scams, it's about $2.7 billion. For financial abuse, it's in the order of $5.7 billion. And I think you made the point that there is a contest as to where that money belongs. Do you have a sense of how much money has been recovered for victim survivors when they've experienced financial abuse?
No, I don't have a number off the top of my head. As you've said, data is not easy and not consistent in this area. But I think it's actually quite important for the committee and for us to talk with the committee about, what distinguishes. There are a lot of similarities between some kinds of scams and frauds and the sort of financial abuse that people experience at the hands of either an intimate partner or a family member or carer for someone who's elderly. There are some similarities, but there are really, really important distinctions. So in the case of fraud and scams, there's no doubt about who owned the money. If someone takes money out of your account, it was clearly your money. In the case of financial abuse by, as I said, either an intimate partner or someone who's caring for you or a family member, those people often have authority to act on the account. They're joint accounts, so they've actually got authority to act on it. And so then there becomes often an argument about whose funds were they. And that's one of the things that banks often have to try and sort out with customers. I think the other important thing here is not all scams, but overwhelmingly, scams often involve a chunk of money taken out of your account by someone you don't know without authority, or sometimes have tricked you into authorising it, but it's someone you don't know, unless maybe it's a romance scam. In the case of financial abuse, this often happens over years and years and years. So it might be that someone literally is using the victim survivor's money for all of their living expenses. So by the time the victim survivor wants to talk about this, wants to disclose it, wants something done, that money's gone. It's been drunk at the pub. It's been used for buying clothes. It's not necessarily that the money, that there's $100,000 taken all at once. It's often because these are long-term relationships, and that's, if you're an older person, one of your adult children is providing some care and support for you to stay in your own home. They do all the groceries for you, and they start to feel a sense of entitlement and think, I'm doing all this, none of the other siblings are, so I'll just throw some of my own groceries in here. And that starts to become more and more until actually they're using mum or dad's money for all of their groceries. By the time that the other family members become suspicious about this, that, as I said, that money's, it's not sitting in an account somewhere to be recovered. So I'm just saying there's a spectrum of these things, and it's the other thing that I think is important is that in some cases, the abuser, particularly in intimate relationships or relationships where there's coercive control, the abuser is not abusing the finances of the partner because they want to accrue wealth to themselves. It's because they want to control the person. So they may not be taking the money, but they might have taken their debit card and made it almost impossible for them to use their own money. And that's a way of controlling their movements, controlling what they can or can't do. So their money might be still sitting in the victim survivor's account, but getting access to it is a different thing until they go and reveal to somebody that this is happening to them.
And so what I'd say is that I think that there's instances where I'm going to say that there's a grey area. Yeah. From a victim survivor perspective, it feels like in some instances banking products are being used, are being weaponised against them. And from looking at the legislative environment as it is at the moment, it's almost like it's okay to be scammed from a stranger, but if it's an intimate partner, that there isn't this legal framework that helps support you. And so maybe following on from that thinking, what tools does the banking sector need to be able to actually help victim survivors get a better sense of justice to try and achieve that financial health and success?
Again, I don't believe that anyone in banks at anywhere, and particularly you'll have an opportunity over the next few days to hear directly from people who are working at the front line on these cases. I don't believe there's anyone in our banks who are working to protect perpetrators. They do everything within their power to recover money when there is that money to be recovered. They cooperate with police when police are taking matters to the courts. I think one of the things that's important to appreciate, and when I look at something like this, and I think it gives us pause for thought to think about how do we think about these kinds of crimes, because they are crimes. I go back to how do we deal with this in the criminal justice system? So if someone physically assaults you, it's an assault, and it doesn't matter whether it's by a partner or a stranger in the street. But the police can't prosecute an assault unless they have a witness who is prepared to give evidence that that assault happened. And we've learnt over years and years and years that very often victim survivors do not want to give evidence in court. They don't want to prosecute. Often they don't want that partner to go to jail because he'll lose his job and they'll have no income. There's a lot of complex reasons why. And so what we've done in the criminal justice system on physical assaults is we have provided a system of apprehended violence orders, for example. Now, that is, it's not the same as taking a perpetrator to court and convicting them of assault and putting them behind bars, but it is a system that's been developed to recognise the emotional complexities and the safety issues that victim survivors themselves want protection. They don't necessarily want to go down that criminal path. And I think it's not a dissimilar thing here. Police and banks to some extent will only be able to prosecute or pursue or recover funds or prosecute perpetrators if the victim survivor is willing to give evidence. And they are sometimes, and banks help them by giving them data, cooperating with the police. But where they're not, what our banks try to do is to take a very much the safety of the customer lens. Because sometimes disclosing this, just disclosing it, puts a victim survivor's life at risk. And so this is not something that, they can treat lightly. It's a very, very serious, high consequence thing for a victim to do.
And I think we had some cases on, I think, Victorian legislation on fines being able to be allocated elsewhere, and survivors wanting to put survival at the forefront, and choosing not to go down that path.
And you'll have instances of that from banks as well, where they've contacted someone, where they've told them what they can see happening, asked if they're all right, and they, for all understandable reasons, don't want to pursue it.
A place where I think the banks can play a really important role when, let's say, a woman is fleeing domestic violence and we see the breakdown of the relationship, and from a family court's perspective that can take you up to 3 years, is the family home and whether the woman and children get to stay in that family home. And I think that that's a real role, a real tangible role that can be played. And sometimes what we see is that either maybe someone's not on the account, or on their own they're deemed not to be able to service the loan, where the mortgage repayments are lower than rent in the current housing rental market that we have at the moment. Do you have some comments on how the banks can be more proactive at helping at that end?
Yes, I do think there's an interesting intersection, or maybe a failure to intersect, between family law and responsible lending obligations, and I think banks do grapple with that. It may be, so there's different circumstances. There's, as you said, there's circumstances where the survivor's name may not be on the mortgage title, and that can be a very difficult circumstance. If both parties have their name on the title, that's also has its own problems, because the perpetrator may leave the home, so the victim survivor is there potentially with children, but can't meet the payments without the dual income. These are good questions to ask some of the banks that you're meeting with this afternoon, because they deal with these cases all the time. There are things they can do, and that they do, particularly if they know that there's a potentially good settlement likely to come from the family court that will assist. They can, defer payments for a while. They can reduce payments for a while. They can do interest only. But they also...
I just interrupt there with a while.
Yeah.
Because there's the timing of the resolution of the outstanding debt matters, which seems to be quite a tight time frame. And then there is the reality of where that intersects with the family court matters. And that's in a completely different timeline. These two things do not seem to talk to each other in any way at all.
I think that's a fair observation, Senator. I do think, though, it's important, if the victim survivor's name is on the title, then one of the things banks will take into account, and these are not, they will start from the point of view of keeping that person in their home, keeping the family home intact, particularly where there are children. But it does come to a point sometimes where the person's equity in that asset will start to erode. And that's not in their financial long-term best interest. And so banks will have conversations with people where sometimes the very best thing for their financial security is to sell the property and buy something smaller or in a different suburb, or, that's a last resort, but it's often a conversation because people are actually, most people, their only asset, the most important asset in their life is their home. And if they're not able to make payments over a very prolonged period of time, then they run the risk of being in a much worse position. But that all depends on things like what the property market's doing, how long the family law case has been, how protracted it's been. So every case is different.
Can I ask if you have any data on how many mortgages for somebody who finds themselves in financial distress as a consequence of financial abuse by an intimate partner are translated into longer-term loans with a reduction in the payment to match where the actual income exists. How often does that happen? Because ultimately that seems like a bit of a win-win. Somebody stabilises their life. The bank has payment. There might be a new 30-year loan drawn. How often is that occurring to absolutely prioritise keeping that person in, rather than we think it's in your best interest if you move to another suburb? Because sometimes that is definitely not going to be what the person wants to do.
No, absolutely. Sometimes one of the things the person wants is to get a long way away from where they think the perpetrator is. So, every case is different. As I said, banks will do, their priority is to keep people for whom it's the right decision, not a security issue, to stay in their home. But at some point, letting people drift into further financial difficulty is not the right thing for them. For all the reasons I outlined before, we don't have centralised data on that, but I think you will find that some of the banks that you talk to will be able to give you at least an impression about how often that happens. Can I just go back to one of the points in your question, which was along the lines of where someone's mortgage might in fact be less than what the rental market might be. I'm aware that there are one of the issues. There's many different issues, but it's not unusual, or at least for some victim survivors, that for a period of time they will be on supporting parents benefit. The it's APRA guidance, not ASIC.
It's ASIC.
ASIC, sorry, ASIC guidance. So it's called in the industry, it's called the haircut. There is a range of different kinds of income that the regulatory guidance requires banks to discount a little bit. And that's things like if you work in hospitality, tips I don't even think they count. But if you're a consultant and you have uncertain, you're not a PAYE taxpayer.
Commissions.
Sorry? Commissions. So you can only count 80% because they're judged to be higher risk income forms. That's also the case for things like supporting parents benefit. And I think there's a question I would have thought there's nothing more certain than
a government payment.
Obviously it changes once the child reaches a certain age, but that's all foreseeable. So, I think there's issues like that would be worth the committee getting some more advice on.
I'm also interested in offset accounts, and sometimes if you spend time on single mums fleeing domestic violence Facebook groups, one of the comments that you sometimes find is they're in the process of leaving a relationship. They can see what's happening in the home loan account and the offset account, and as they're going through that separation, money being taken out of that offset account to basically put mortgage payments at risk. And I'm wondering if you've thought about safety by design principles at that point where a couple has decided, yep, we're going to separate, what should ideally happen with that mortgage account? But also, my understanding is that AMP is the only bank that offers 2 separate offset accounts. Is there a reason why there's not more banks that have separate offset accounts for couples?
I thought there was more.
There's more than that.
There's more than that? Okay, great.
I'm not with AMPs.
Okay, right.
I think most of them now are offering some form like that.
I guess the question is, if we know it's a product that is a preventative product that puts a bit of friction in the system, why that isn't advanced more quickly as the best practice and made available? Because all of these questions go to product design. And once upon a time, electrical cords were of a certain type. We changed the electrical cords because we improved safety. There's a lot of product out there. There's supposedly a lot of choice. There's a lot of confusion because there's just a storm of choice for people. What efforts are going into prioritising and ranking low risk product, particularly given the fact that we know that 40 to 60% of relationships are going to break down? Anticipating, we've got divorce, not because we want it, but, and law around it because we know we need it. If divorce is factored in when people are making joint mortgage arrangements, what product is dealing with that actuality?
So as I said in my opening statements, we do have we have a working group on this issue, and we have contracted Catherine Fitzpatrick last year to work with the working group on safety by design, and we've started. We spent the last sort of half of last year working on the terms and conditions issue. The next project they're doing is mortgage lending, and we've had our first workshop on that.
So the terms and conditions is specifying what financial abuse is, and that it is a detriment for somebody to use the product in a way it's not designed to abuse someone.
Yes.
And what's the consequences for that?
The bank reserves the right to terminate the banking service to the prosecutor, to the perpetrator. There are numbers on this. Do you have them?
I don't have those numbers.
Yeah, we take that on notice.
That would be great.
Yes.
How many reports?
Yep.
Since the terms and conditions have been put in, and what is the consequences and actions for those individuals? Because that takes the power away from the perpetrator, and it takes responsibility off the victim.
Yep.
Yeah, it's also something banks you're speaking to might be able to talk to as well.
They might have some numbers of their own, but so we certainly, as you'll appreciate, some banks have come, people are coming online on this. All the four majors have done it last year. Some of the smaller mid-tier and smaller banks coming online, but I have seen data on that, and it's what is interesting is one of the things the banks do first is to send something saying, we've noticed you're using the account like this, and we're asking, basically cease and desist letter, and in about 90% of cases, that disappears.
Okay. So we notice you're using the account in this way. Just clarify for me if we notice that you're using the account by putting in revolting terms in the descriptor. That's the AI lens. Yeah. Is that the only way AI is picking up what's going on, or are there patterns of money movement that are clear to the banks that are triggering those kinds of letters as well?
I think it's more the former than the latter,
which is what I was afraid of.
But I was just going to say, I think I should correct my answer slightly before. Banks don't write those letters unless they talk to the person who's receiving the abuse,
because at the other end is
and there are cases. There are a number of cases where women, where the survivor does not want that to happen, because it would be a trigger in the relationship, and the same would be true of any other intervention. So I don't have, as I said, I suspect because it's clearer. And as I said earlier, sometimes the problem here is the sort of behaviour can actually be. So a couple, both parties are putting the same amount of money into the joint account. One partner seems to be doing most of the withdrawals, most of the expenditure, because you can see the two different cards. This is not unusual in strong, healthy, non-abusive relationships. One partner has more responsibility for household, children, etc. And so this would not show up as something unusual, but it actually could be. Could be the same as what you would see, where someone has, in a coercive way, taken the debit card, put a 2 to operate on. And that can effectively leave that woman with nothing.
So can I put it to you in the way that we were once unable to detect cancer of particular kinds because we didn't have the test capacity, that we currently perhaps or have not yet developed the tools for data analysis that indicate high likelihood of abusive, financial abuse behaviours. And that we're unlikely to get to that point unless it becomes an industry standard, and that there's sufficient data shared and the research is done. Because I'm increasingly confident with large-scale data that good researchers will find particular patterns of behaviour that highlight certain interactions. And is the response to that, well, these transactions are starting to look quite risky on here, so, we want you to get some insurance in case things go south, or even earlier than that, say, well, there's an insurance product you can provide for in case there's a breakdown and there is some financial abuse, because we know that this actually occurs.
Look, but potentially, I think you're right about, as we see things like AI used more and more, that we will get better data and we'll get it more easily. It won't all, I'm just saying it just won't
capture
always
the complex sociological realities, on every occasion.
Yes.
Yeah, I understand.
And as I said, some things that are perfectly healthy, thriving relationships can look exactly the same as relationships that are, because these abusive relationships they're insidious, they're behind closed doors, the people who perpetrate them are criminals. They spend their waking days trying to work out how to persecute somebody all day long, and they're very cunning. So that doesn't mean we've got an obligation, I think, just like government, police, everybody, to use data, to get better at it, to close loopholes, to make the net tighter, without at the same time designing a system based on the assumption that grown adults don't have agency. So it is a tight rope. Something like a two to sign arrangement.
Yes.
I mean, I've got a joint account. I can tell you, I don't want to take my partner every time I go to the shop so that he can stand there and authorise the payment. Like that, we don't want the system where we, with all the goodwill in the world, end up with something that is just not workable.
So maybe then you have your own account, right?
Oh, I have one of those too.
So, well, and isn't that part of the solution, right?
It is.
That we require people, if banks are going to provide products of certain kinds, that there is observation of financial independence in a separate account, and that becomes a requirement. If you're going to have a joint loan, that you must also have your own separate bank account with a livable amount of money and orderly transactions that indicate you're not being coerced.
Well, I think it's any ideas are worth thinking about. I think it's worth thinking through what would be what if any other consequences are there.
Yeah, well, we heard from what was the 1634.
Oh yeah, so there was a.
Yes, I saw this in the. It was 16 out of 24 of the women who came to a financial literacy workshop. So it's probably not but it's a very worrying figure. They
and it wasn't even an indication of financial abuse. It was like, do you have a bank account?
Yeah, don't know.
Which huge concern.
Speaks volumes. It speaks volumes to the size of the task. I might just take you back. You mentioned, divorce. Relationships break up.
Yes.
And they're not all of them are abusive by any shot. Most of them are not abusive relationships. But nevertheless, separating money is a tough, kind of unpleasant thing to do. And banks work with people separating joint accounts and mortgages all the time. But so mortgage lending is the issue we're tackling now through the product safety by design process. But there is something, I think, to be thought about at the very front. It's a bit like a prenup or something.
Yes.
Because by and large, people set up joint accounts together at the beginning of relationships when things are, there's notable exceptions to this with financial abusers, but for most people, they set up a joint account when things are pretty good. And that's probably the point at which to say, you need to tell us now, should you no longer wish to have a joint account, should the relationship break up, these are the kind of 3 or 4 ways that this can happen. Which one do you want us to put in place at the request of one of the partners? But as I said, even saying that, you can see how a perpetrator could stop a woman from having access to the account if you're not
at that
careful
point,
about
in terms of how that's set up.
Yeah. So but you might be able to. But thinking about how do you do it at the beginning, there will still be terrible, cunning perpetrators who'll find some coercive way around that.
Yeah.
But that doesn't mean that you wouldn't solve a lot of the problems potentially by thinking more clearly at the front end.
Can I just ask a question about consumer advocates have told us that banks often resolve the financial abuse matters on the basis of financial hardship or compassionate grounds, even doing that when there have been complaints raised in relation to responsible lending or maladministration. And they say that this masks the responsibility on banks in preventing and responding to financial abuse. Why is this happening? because it involves AFCA as well, and we've got advocates for predominantly women fleeing domestic violence, financial abuse, all enmeshed. They want to get out. They've got support of a lawyer, and unless their lawyer is willing to advance and push these things through AFCA, there's actually no registration of what's happening. So I don't know if we have data that's accurate.
Sorry, are you saying that banks should be required to report if they breach responsible lending laws or in some way fail to...
There are lawyers who are saying there have been failures of responsible lending laws. There has been maladministration. That's not really contested, but the matter is resolved. Like, how do we get rid of this problem? We'll resolve it by saying on compassionate grounds or financial hardship, this matter disappears. And then the reality of the failure to responsibly lend is never really brought to light. So it becomes a way to hide those failures rather than
No,
advance
Senator, I
to
think
them.
it's important to say that banks have a legal obligation to report a breach of responsible lending laws to ASIC. And
if they self-identify.
Yes, but if they didn't, it's a very serious offence, and ASIC's currently got a matter before the courts on this. So, banks have very big compliance teams. They have a legislative requirement. If they identify that something's, so if they had a case in AFCA that identified that, that they had made a loan that was not consistent with their responsible lending obligations.
But that would have to be a finding from AFCA? Because this seems to be part of the stickiness of it, that, that somebody's had a good look at these matters and said, hey, these people should never have been given this goal. This is a breach, right?
And if that's the case...
And then they say, okay, well, let's sort out the person. Priority, the individual, get their life sorted. Then, after the life is sorted and financial hardship or compassionate grounds have been applied, the matter still lingers. Right now, then somebody has to take it through AFCA and a finding has to be made. And until such time as a finding is made... No?
If the bank identifies that they've done the wrong thing, they have an obligation to report it to ASIC. And failure to comply with
if
that
the
report...
bank identifies, but what if the bank does not accept that, yet that is what is being advanced by the financial counsellor who has had a pretty good look at all of these matters and does consider that it's impossible for that person.
I would imagine AFCA would consider that as well.
Yeah, but you're talking about something that doesn't go to AFCA.
Yeah, it kind of hits a barrier and doesn't quite complete the cycle, and becomes a place for banks to continue their practices.
Look, a breach of their responsible lending obligations is one of the most serious failures a bank can make. They have compliance teams that literally sit down with cases and work out, did we fail here? Did we do the wrong thing? What do we learn from this? What do we got to do about reporting it? I think what I want banks to be dealing with people on compassionate grounds, and if they think they've done the wrong thing, then working to assist that person without forcing them to go through a complaints process is the right thing for a bank to do, as long as the person is adequately provided for, and the bank should also report the failure to the appropriate regulator, who will decide what action to take. So I don't think you can underestimate how seriously banks take this and how much they work it through. And I mean, by all means, question the banks when it comes. But they, as I said, they have various teams, including they'll have something like a sensitive matters team that deal with the most complex, the most difficult. If you're dealing with an 80-year-old whose adult son is taking money out of their account, who don't want to believe it, the son has power of attorney, he's threatening to not let her see the grandchildren. I mean, these are really complex, difficult cases, and they have people sitting down, literally working through case by case by case. And if they identify that the bank has breached any of their obligations at law, as I said, they have a very serious duty to report it. And if they fail to do so, then the consequences are quite serious.
Can I just indicate that the Economic Abuse Reference Group's submission is extensive. I don't know if you've had a chance to look at it. There's quite a number of recommendations in there. I think I'll ask the Secretary to send it to you and give you a chance to have a look at that and respond, because there are a series of case studies there that are very specific. and it would be quite helpful to get your response to those recommendations and ideas.
We've got it's publicly available,
It is.
I think, on your website. We've got a copy. I haven't had a chance to go through it, but I have read some of the other submissions. But we're very happy to go through it and come back to the committee with a view on the workability or other. All ideas,
At this point of time, it's like there's an awakening, really, isn't there? For me, I've been thinking about this. It's kind of like once upon a time it was, that's a family down the street where, there's a lot of shouting that goes on in there and everybody just turns their head away. Domestic violence is, I think we've said it's everyone's business. So people are now engaging with physical domestic violence with a very different orientation. I think we've hit that point now in terms of financial abuse.
Yeah, I think banks have been very clear for some time that financial abuse or control can actually keep victims in violent circumstances and this is nothing new. My first job out of university a long time ago was in a women's refuge, and women would literally ring reverse charges to the shelter and say they were coming and they didn't have any money to pay the taxi. And, I'd go out and pay the cab. Like, she literally had nothing in her purse. And these were in the days of cash. So that control, if you can imagine what that's like to not be able to have even bus fare, is incredible control. So it's certainly been there forever as a tool of abuse. I do think that banks have done a lot of really good work in this space, and it's making a very big difference to the lives of people in terrible circumstances. But we can always, we've got to keep an open mind to what next. What's the next tool that we can use better? What's the next understanding that might help? And I think as you'll hear a bit from some of the teams who work on this, when they see certain circumstances, it gives them, an understanding of, I hadn't thought about how the perpetrator could use that, against you. So we'll go and rethink the product, or we'll, think about how we warn people, or who the target market is, and so it's a learning. Everyone is learning in this space all the time, and I think it would be fair to say, governments of all persuasions over the last, I don't know, what would it be, Senator, 40 years, 50 years, struggling to get the Family Law Act right. That's really the central authority to determine ownership of funds and distribution of funds at the end of a relationship.
So I've got two questions, and then I know Senator Pratt wants to ask one as well. Going to that family law property settlement and the length of time and the disconnect in terms of the time frame, when consumer advocates call on banks to give more comprehensive hardship arrangements for victims, there's often pushback from banks saying they just can't offer more than 3 months at a time, and they cite then the APRA standards for the rationale of why they're doing it. No, it's got to be done in 3 months. This is the time frame. This is the time frame. But a different reading of the APRA standards would have them perceived as being a little bit more flexible than that. And the chair of APRA said at the ABA conference in June that APRA's prudential framework is principles-based, which creates significant room for banks to run their business the way they want. In banking, that means the ability to set their own business strategy, pricing and risk appetite. The risk appetite around potential defaults in these circumstances is one thing that they could apparently have some more control over than is the current prevailing narrative.
And they do. The 3 months is an interesting one. 3 months is often given literally within 24 hours. It's the sort of, you clearly have a case that we've got to get under the hood of.
Let's pause.
So let's just pause. We'll give you don't have to make a mortgage payment for 3 months now. Let's go and have a look at what's happening for you. And then when the bank really understands all the circumstances, how long since, because that person may have been making mortgage payments for 12 months while the matter's in the family court, and it's only when things get to the point of, I don't think I'm going to be able to keep doing this. So otherwise, other people have just left the day before, so there's all kinds of circumstances. But the 3 months buys not just the victim survivor some time, it buys the bank time to really understand the person's circumstances, and they can and they do offer quite much longer term arrangements than that. And again, you could get some examples, I think, from some of the teams today. But so I don't think it's accurate to say that banks only give 3 months. 3 months is the kind of, okay, let's just bang, we can do that. That's low risk. That's, that's 3 mortgage payments. Let's just do that right now, and then let's sit down and work through what is the best thing for you. What are your circumstances? What are all of your outgoings, your incomings? What's happening in the family court, etc.
Okay, thank you. Do you have any sense of the number of interpreters that banks employ to engage with culturally and linguistically diverse communities, and particular services for cold customers? And the other thing I'm thinking from a literacy point of view is often people interact with complex text in fear, and they are happy to be guided by somebody. They tick, and if they're in a coercive relationship and they really don't want to do it, they will still sign, because there's peace in that, there's safety in that, they'll just go ahead. Are there any products where the person is actually required to put in their own words what it is they understand they have done?
Let me start at the beginning. I don't think it's so much that banks employ the interpreters. They tend to engage interpreter services, on an as-needs basis for customers with particular linguistic backgrounds. This is something that banks regularly do, but we've now, one of the new provisions in the new code is to put that into the code as something that banks will do for customers. In a multicultural country like Australia, I think you'll find banks are using interpreter services quite a lot.
I guess the financial literacy of those individuals can be very varied.
Very varied.
And the other thing we heard today is that having the cultural familiarity is sometimes a risk, particularly in the case of a dowry matter, where it's like, well, the conversation's happening in a language that the bank doesn't actually understand, and you should stay in this relationship anyway. Shame and the whole cultural milieu that's against what we are trying to achieve is actually being enforced, and the banks might not necessarily have any insight into that.
Look, that is the case, and there is a limit, I think, on what banks and bank staff can do. But one of the things that most banks do, as I understand it, is where you've got 2 or more people going on to a mortgage, taking on a mortgage, they will talk separately, or to another joint loan. They will talk separately to both parties. And if one of those parties or both of them had a linguistic issue, they would have interpreters for those separate conversations. Now, I think it's impossible for banks to ever know if the perpetrator is in the room when they're having the conversation with the other party.
Digitally, unless they do it in real time, real space.
Yes, but But we're talking about telephone calls generally. But sometimes it is face-to-face. But I don't think you should underestimate that the kind of people who are living with every day with coercive control, part of surviving is to get very, very good at not showing it. And, even face-to-face bank staff can, up to a certain point, they take all the precautions. But as I said, we're dealing with some really quite extreme circumstances in some cases. So, so banks do take, and the other issue, of course, and we've got more protections in the new code, is where people are asked to take on a guarantor. The other thing is beneficial.
Substantial benefit clause we have in the code. So the intention is that when you're taking out a loan, you have to demonstrate that you're going to get a substantial benefit from that loan. So there'll be questions that are asked around that as well.
So if it's for a mortgage on a house you're both going to live in, that's pretty obvious, mutual benefit. But there's...
If it's establishing a business or if it's buying a property in a single name, etc.
Yeah, but there would have to be, in those circumstances, you'd probably want separate legal advice as well.
And does that happen with small personal loans, like for a car of $10,000 or $20,000 as well, of the substantial benefit test?
If it's in one name, that would be a bit challenging. But if it was I don't know. Actually,
if it's two names on the loan, and if it's bank finance, not a car company finance, because we can't speak for what they do.
Yeah.
But if it's bank finance, yes, it's a substantial benefit. So yes, if the person doesn't have a driving licence, or well, even then, if the car is being used to take them to work and their children pick their children up from school, then it's a mutual benefit.
Right. There are a number of questions on notice that I'll ask about a few models for domestic violence that deal with physical domestic violence and hierarchies of need and capacity to respond that seem very differentiated by comparison to one team taking information, even though if one person is allocated, it doesn't necessarily mean the support that needs to happen is happening. But I think there's a few innovative practices that are happening with that. Senator Pratt, can I just go to you for one question?
Thank you. I did have a few more, but I could put them on notice.
Thank you. I think we've all got questions.
Can I ask? Yes. Can I ask, please? Banks are now making contributions to financial counselling funding. Is this meeting expectations in terms of what was forecast would be contributed by banks?
Is the money? Yes, it is.
Yes.
The first payments have been made, I think. Yes, they have. Senator, the financial counselling organisations, their preference was that a new organisation be established to receive that money, and then to work with different financial counselling organisations to allocate those funds. That organisation has been established. It has a board, and I was advised, I think, a fortnight ago that the board has now appointed their first CEO. So I'd be surprised if any money has actually flowed yet from that organisation to financial counselling organisations. But we're doing this in partnership, and that was what all parties agreed was the best way to do it. So it's still, I'm being honest, we're still in the set-up stages, but now that there's the first CEO on board, and it's someone who's had a lot of experience in these things, I would expect to see that activity will really start to speed up now. But you'll appreciate they had to get a chair, they had to get a board, they had to advertise, go through a process. And did you have any?
I was just going to say, Senator, the funding is also not just from banks. I'd be amiss not to mention it was from insurers and energy companies and telcos as well.
Do you know what the quantum is?
I should know that. I should know the answer to that, having been worked on it for so long. I was in the realm of about $10 million.
$10 million. And is that likely to, per year, and is that likely to increase? Is there...
I think there was a scale up in so it's a 3-year trial.
Yep.
Minister Risworth it's her department that sort of led the work on this. And there was a small scale up, I think, year on year for that.
Thank you. Well, as much as we have many more questions, I think most of those are going to have to go on notice now. Can I thank you, Ms Bly and Ms Bullinger, for being here. Thank you for your work in this important area. Thank you for your very, very solid contribution in your submission, and do expect questions on notice. If you could provide responses to those by the 5th of August, that would be very helpful for the committee. I hope you have a lovely afternoon.
Thank you, and thank you for the opportunity. We will, of course, take those questions on notice and come back to you.
Thank you very much. I always feel like I should call you Premier Bly still. Miss Bly doesn't quite do it. I now welcome representatives. Thank you. I now welcome representatives from the Bendigo and Adelaide banks. Thank you. And Senator Pratt, because you've been so kind and patient, we'll come to you for the first questions, if that's all right.
No problem.
Thank you.
Are we having opening statements? Sorry, I've missed.
We're just about to
We're
find
going
out.
straight to questions now, Chair. Okay.
So we have had opening statements provided to us in hard copy, is that correct? Excellent. Okay. So in the interest of time, can we table your opening comments? I will give you 1 minute each to kind of go to the headline thing that you want to put on the public record verbally, and then I'll go to questions from Senator Pratt. So the first thing we need to do is get your names and the roles, the capacity in which you appear today. We'll start with you, Mr. Fennell.
Thank you, Senator. My name is Richard Fennell. I'm the Chief Customer Officer for Bendigo Adelaide Bank.
Thank you.
Hi, Hayley Bransgrove, Customer Advocate for Bendigo and Adelaide Bank.
And Will Conlon, I'm the Chief of Staff and General Counsel.
For Bendigo and Adelaide Bank?
Bendigo and Adelaide Bank.
Wonderful, thank you. So, Mr. Fennell.
Yes.
Yeah, 1 minute. What's the headline that we should take away from Bendigo and Adelaide Bank?
I think from my perspective, Senator, we recognise this as a very serious issue, and I think it aligns with part of our ethos when we think about our role as a bank, and that is to feed into the prosperity of the community and our customers. Now, at a macro level, that sounds great, but at the micro level where these issues occur, it can be challenging on a case-by-case basis. Now, with slightly more than 430 branches across Australia and the fourth largest branch network of all the banks, we still see a really important role for face-to-face banking in working with customers who are victim survivors of these sorts of situations. And what we look to do is make sure that our staff are very well trained to identify the risks in this space so that they can then respond and, importantly, work with the specialised teams we have in place to provide them with information they can to make sure we can then support those customers or refer them to those specialised centralised teams.
Okay. And this case-by-case matter is very important, and also it is good to hear from you, like we heard from Cobra, about face-to-face and how that changes the way in which you can conceive of responding to the challenges that we know are out there. How many customers do you have, Mr. Fennell?
Just over 2.5 million.
And how many accounts do you hold?
I think I'd have to take that on notice, but I believe we have on average around 1.9 products per customer. A product may have multiple accounts, so I think we're probably fair to say that we're up towards 5 million products. But as I said, some of those products may have multiple accounts linked to them.
Yeah, fantastic. And how many people do you have in your hardship team?
So our financial awareness support team, our FAST team, is the specialised area that Hayley leads. So why don't you comment on that team?
Yeah, so our specialised team that specifically deals with customers who are vulnerable or experiencing vulnerable circumstances is just recruiting some more staff. We've had to upsize due to demand, and we'll have 11 FTE in that team. That's separate to our hardship teams that sit in another department.
All right, so I'm trying to get the sort of sense of response capacity. 2.5 million, most of those accounts are going to function okay, and people won't need that service or provision. But what percentage of your client base, of the 2.5 million, fall into hardship or vulnerability?
From a hardship perspective, from a lending perspective, I'm very pleased to say that we actually underperform in that area from the perspective of lower level of hardship or arrears with lending than the industry average. But right now, that's sitting around 0.4 of 1% or 0.5 of 1% of accounts are in hardship. And when we're talking about lending here, and residential mortgage lending in particular, we're talking in the order of a couple of 100,000 accounts. So,
how many have you got in your hardship team?
The hardship team, again, I don't have the figures to hand, but it's in the tens of people. It's not in the hundreds. But I think
so. Under 100.
Yes, but you do that maths, and we may have in the order of 1,000 loans in hardship at any point in time. So 30 or 40 people, again, will get you the accurate number. That is a reasonable capacity to handle that number of loans because you're not dealing with every loan every day.
Right. And Ms Bransgrove, the differentiation between hardship, that's just when somebody is in arrears. Mm-hmm. How does it tip into your area?
So overall, we've had about 27,000 customers identified as potentially being vulnerable since 2018. Of that, about 8,500 are potential victims of financial abuse. When we apply the lens over hardship, about 2.4% of our hardship applications since September have been related to family and domestic abuse, so it's quite a small number for us.
Okay, and you've got, did you say 11 FTE?
Yeah.
And you're going to increase that to how many?
No, 11 will be the number we go up to.
Okay, and how many have you got at the moment?
8.
Right. Okay, thank you. Senator Pratt.
Thank you. Can you hear me?
Yes, we can, very clearly.
Great. Can I ask where you have issues in innovating for safer products because of existing laws or regulations?
It's an interesting perspective. The innovation, I guess one area around innovation that would be helpful in a place in an area like this is around privacy laws and the limitations that brings to our ability to share information because of the potential for breach of privacy laws would be the one that springs immediately to my mind. I don't know, Will or Hayley, if you have other examples that you think are challenging from a regulatory perspective.
Not from a product design aspect, it's more so when things go wrong.
Do you want to expand on that a little bit further?
Yeah, so in the instance of a joint mortgage or things like that, where we have one party who may be perpetrating domestic or family violence on the other, unless we've got explicit express consent from that party, we're not able to make any disclosures to any law enforcement agencies.
Would you be aware of any law enforcement agencies who have concerns about clients that you have?
I'm not aware.
They have no way to let you know that they've got concerns?
We have done a pilot in the past with, I think it was Vic Police, in terms of what a cooperative relationship would look like, but I don't have the information to hand.
Do you want to take that on notice?
Yeah, absolutely.
Because clearly, you know, these blind spots are where coercive behaviour absolutely festers. Back to you, Senator Pratt.
Maybe if she's not online, I'll seek the call.
Have we lost? Senator Pratt, you might be muted. We can't hear you.
Yes, sorry, I was.
There you go. That was a mystery
Can
solved.
I ask,
At least we've fixed one
in
thing
terms
today.
of technological advances and innovation, what you see the future looking like that could help us prevent financial abuse. So, for example, if people can better match receipts in terms of having obligations, for example, on supermarkets that can then be attached to people's bank accounts. People now do that through apps, etc., but it can be quite hard to match up your transactions with receipts. And I guess if you're opening joint bank accounts, it would be great to, you know, at the start of a relationship and the opening of a joint bank account, for people to understand that they can use technology to get an overall picture of household expenditure, and that everyone in the household has a right to see that and what was purchased, and to be clear about when expenditure is private and when it's not. In addition, things like blocking cash withdrawals or blocking alcohol transactions and making that easier to do, and being better using merchant codes. For example, a teenage account where those things are blocked could be just useful for someone who might have enduring a power of attorney for someone where you do want to be able to give someone some financial independence without you needing to do oversighting all of their finances, etc. Like alerts to large withdrawals, for example, if you are the trustee for someone, to ensure that other people in the family might also, under that arrangement, have a right to be notified. Those kinds of things.
Mr. Fennell's nodding furiously, so let's hear from Mr. Fennell.
Yeah, thanks, Senator. I think that is an area that really is an opportunity into the future. Right now, our digital bank offering is primarily through a brand called Up, and we have 900,000 of our 2.5 million customers use that brand and that digital-only offering. As a relatively new development without the old legacy systems that it's based on, we've been able to build new capabilities through that offering. So, for example, and in our submission, we highlight the ability to identify where there are multiple small value transactions that are unrequited, and we will then, where we identify those, assess if those transactions align with the potential cases of financial abuse, and also look at the messaging that goes alongside those. And then we have the ability to block messaging and the like from those payments. Now, the reality is those incoming payments might be valid payments, they may not be, but what we're trying to do is stop the verbal abuse that often goes with the messaging ability alongside those payments. That's an example where some of these new technologies do give us the opportunity to think about these things differently, identify trends, identify exceptions like you're highlighting, where unusual transactions might go through. Today, again, when an unusual transaction goes through Up, we will often go back to the customer to check that that is an expenditure that they intended to make, particularly if it's to a new recipient. And these are the sorts of opportunities with these new technologies that I think will be available, even if not today, in the not too distant future. The challenge is identifying what are the sort of transactions that fit into the categories that we think highlight potential financial abuse. And customers don't necessarily want to be challenged on every transaction they're making. So it is an interesting one to try and identify the specific examples that have a high propensity to align with these sorts of situations.
Can I add to that, Richard?
Yes.
And in that context, how is it to see what kinds of transactions are taking place? So, for example, I've just had a bunch of romance scam websites in my bank account, but if that was legitimate expenditure, for example, in a joint bank account, should it be? How can we make it visible to all parties that that's the expenditure, that what that expenditure was, so that it's not kind of sitting there without visibility?
So Ms. Bransgrove wants to respond to your first question,
yeah.
And then we might come back to Mr. Fennell.
Could receipts go back to? Could we set it up so that when you get receipts, they're able to be automatically attached back to your banking records, as customers are now doing more of themselves?
Ms. Bransgrove.
Yeah, so the premise of Up Banking is built on building financial literacy and financial well-being of the customers that bank with them. Every single design decision that's made through that app is built with that in mind. It provides spending insights on a monthly basis back to the customers that breaks down your spending into different categories and says this is what was up, this is what was down, and it gives you those insights over an extended period of time, which I think is the beginning of sort of the type of innovation that you're alluding to there. Yes. In terms of card controls, both Up and Bendigo have those within apps, so you can turn on card controls to block gambling, alcohol, online transactions, whatever it may be.
But can you turn them off on the app just as quickly as you turn them on?
Yes.
So they're not permanent?
That's an issue that we do have, is that they are user controlled, so that does present challenges, but speaks to the need for individuals to also maintain financial autonomy at the same time. So it's a juggle that we're trying to balance. Up also does provide alerts and notifications for spending that comes out of joint accounts. So if the secondary party to the account withdraws funds without telling you first, you will get a notification that tells you that that has occurred.
And are these perhaps the kinds of obligations that could be looked to in when someone has an enduring power of attorney, that those obligations, that there's an obligation to turn them on and ask your bank to do that?
I think, yeah, that's absolutely an opportunity for something like that.
Thank you.
And do you see any particular issues around law reform and regulation reform that would help you enhance the safety of products?
Our main concern in terms of law reform is what Anna spoke to previously with enduring power of attorney abuse. We have quite a large cohort of older customers, and use of power of attorneys is very prevalent within our customers. We do have challenges, especially with our frontline staff, understanding those documents, implementing them effectively, and carrying them out.
And we've just moved to put a centralised team in to support the management of those powers of attorney, to make sure that the team in our individual branch networks aren't relying on their local knowledge. There is a centralised team that they can contact with questions in relation to power of attorney to make sure that they are implementing those appropriately.
And what kind of regulatory reform would you like to see to make that job easier?
The National Register and a harmonisation across states.
Everyone's singing from that song.
And you would see that as urgent?
Absolutely, yeah.
Okay. Last question, Senator Pratt.
In terms of blocking transactions based on merchant code, we saw a large investment in smart card and cashless debit card inside government systems. What can banks learn from that? And if people do want products like that, how easily can banks offer them?
So is this around the merchant identification point, Senator? Is that the aspect you want to follow up? Because one of the things, again, if I can use Up as an example, was one of the first to actually use some smart technology when, in a lot of cases, merchant codes are very difficult to decipher what the actual expenditure was and where, to identify based on the location where that occurred and through the code from the merchant actually what who the merchant was where that expenditure was occurring, so that when you are receiving a debit or credit card statement online, you can actually see that, okay, it's not just to some strange code or a subscript. You can actually see that that was at a particular merchant, whether it be a retailer or some online provider of services or anything else. That then allows us.
So I've done that manually for my own bank accounts when I see stuff I'm not sure what something was. How can AI and other tools make that more automatically generated, for example?
That's what we're doing through that Up offering, is that's automatically occurring. So you'll then see the merchant identification in the sort of language that you're used to seeing, the brand that you have purchased from, and then that feeds into the categorisation that Hayley was talking about, so you can see on a monthly basis how much is being spent on subscriptions, how much is being spent on groceries, etc., etc.
That's terrific. Is there anything we can do in a regulatory sense to make that easier for you to do? And how do we better mandate that across more banking products?
I'm not sure we see a gap from a regulatory perspective in us being able to provide that today. And I guess it is up to each individual bank to decide if they see that as a value add they want to provide to their customers. As Hayley mentioned, the ethos behind our Up offering is to provide financial insights and to help people to better understand their financial situation and how they're spending their money. And so
it seems to me, though, it would be difficult to implement principles of safety by design in your products unless you were actually doing that.
Yes, it would be more challenging unless you can get that insight. That's true.
Thank you, Senator Pratt. Senator Ms Mascarenhas.
I was interested in your stat that you said earlier that the number of defaults that Bendigo Bank has compared to other banks. So I think you said it was between 0.4 to 0.5%.
Yeah.
And what's the national average?
I think it's around 0.2% higher than that.
Right. Thank you for actually having stats on financial abuse of your clients. And so I think I calculated it to be about 3.2 customers per 1,000 customers. And so I feel like that's an easier way to think about it. And we haven't got stats from the other banks yet, but it'll be interesting to see how you compare to the other banks. Do you feel like there's particular things that you are doing in this space that's innovative that you would like to see other banks pick up? Or do you feel that rather you're stealing, not stealing, borrowing, sharing activities like what Commonwealth Bank has been doing from an algorithm of stopping financial abuse?
Look, the reality is we probably would see ourselves more in the fast follower category, being a relatively small bank compared to the four major banks. Look, where we see opportunities to move quickly to address opportunities and issues, we will do that. But more often than not, we're learning from the other banks rather than necessarily leading the way. I think that's the reality, just given our scale and resource base. But again, Hayley, I don't know if you want to... I mean, there's a lot of sharing of information in this space amongst the banks, which is, as you heard earlier from the ABA, this is not an area we look to compete on. It's an area we look to cooperate in the best interests of the broader community.
Absolutely. And why now? Why now?
I think we've all been on a learning journey, Senator. So it's not suddenly now. This is our financial awareness support team was set up in 2018 to respond to this. So some would argue maybe that was a little late, but that's been 6 years that we've been investing in this space and learning. But that's a journey we're on and we'll continue. And I think over time we will better understand the risks and issues in this space and how we can then respond to try and support those customers that are falling victim to these crimes.
On your website, where you talk about financial abuse and the definitions and what the bank can do, one of the things that is never sign documents you don't understand, and one of the conversations that we've had from previous witnesses today is around culturally and linguistically diverse backgrounds, and particularly people signing things like becoming a director of a company or co-signing loans, etc. With loans or other banking products that have quite significant implications, are there verbal conversations that are being had to make sure that people understand that? And this is probably a question on notice. Has Bendigo Bank and Adelaide Bank engaged in any interpreters to help people understand what their financial obligations are?
So we use two different sources of interpreters. We actually ask our staff to identify if they are multilingual, and that allows us to use staff to support interpretation of things like loan documents, and we're using staff who actually understand banking. And so in
That's a very big difference.
Yeah, in many cases they are staff that work in our branch network. And because we've been identify that they may speak Spanish or a Bahasa or any sort of language, we then will go to that person, arrange a time for them to join in the conversation to translate on behalf of the customer where English is not a language they're comfortable to use. If we don't have staff with that language capability, then we'll use an interpreter service. But our preference is to use our internal staff who have the multilingual capability.
How many of your 2.5 million customers are from culturally and linguistically diverse backgrounds?
Look, I don't know if we can, even on notice, give you a great answer on that. I suspect that we would be not vastly different to the society in which we operate, particularly with our newer offerings like Up, which is an online bank, and I think is attractive to a lot of younger Australians who are often there's a high proportion of recent migrants who have English as a second language. Our traditional Bendigo bank brand and retail business tends to have a slightly older demographic and probably less, a slightly lower range of variety when it comes to backgrounds from a cultural perspective.
So the people who use the Up platform and then the people who use the more traditional one, how many are in each group?
Yeah, so 900,000 customers with Up,
Yep.
1.6 million with Bendigo.
How many of those 900,000 are in the hardship?
Well, actually, I think right now it's probably zero because we've only recently started offering lending through our Up platform.
Okay.
It has historically purely been for transaction
Savings and
accounts and
analysis.
savings.
Yeah, okay. How many from the Up platform are in the vulnerability team?
I don't have that on me right now, but we can come back to you.
Okay. How many people in the vulnerability section are multilingual?
Also can come back to you on that one.
And how many in the vulnerability section are trauma-informed trained?
Not as yet. We've got that on our roadmap to occur within the next 3 months.
Okay. And what sort of pay do these people get and what qualifications do you have to be on this team?
I think it's this is a guesstimate, around 85 to 95,000 annually. Generally speaking, they are people that have come internally from our branch network that have really strong customer service skills, the empathy, all of the emotional intelligence factors are what we're looking for in those staff. And then when we bring them into the team, we're upskilling them on the specifics that they have, but there's no set qualifications.
So there's no degree qualification of social work or... No. Okay. And are there any people in there who have law degrees?
Not currently, I don't believe.
Okay. What about in the hardship team? Same thing?
The hardship team...
Culturally, multiple languages?
Again, I'd have to check on that. But these are often... What we're looking for there is people who have a mix of credit skills. So they have often come from a lending background, but also that empathy piece. That team, which we refer to as our Mortgage Help Centre, the focus of that is trying to keep people in their houses. So it's not about necessarily trying to maximise the return for the organisation or speed up the return, because we find that it's in our best interests and the customer's best interests. They are aligned with staying in the property. So the objective really is there to try and find a set of circumstances, assuming the customer wants to stay in the property, where they can afford to continue to service that debt.
So can you provide a notice, and even if it needs to be confidential for commercial in confidence reasons, the number of people in the last 3 years that have gone through the hardship program, how many of them have stayed in the house?
Yep.
Those who've left and the reasons why. Because sometimes that might be a safety determination, other times it might be a financial one. Also, can you overlay that with how many people have been through the family law machine, slow-moving machine?
Yeah. If we have that last piece of data, we will provide that. How well that's correlated, I'm not 100% sure, but we'll do our best to provide that information, Senator.
And also with regard to, you heard me asking questions of the ABA with regard to responsible lending and maladministration. And how many of you advanced? How many cases of irresponsible lending or maladministration have been advanced with regard to Bendigo, Adelaide Bank and UP?
Again, UP has only just started on the lending side, so I'm not...
Zero?
Yeah, I think that's...
So how many times have you had to report maladministration or irresponsible lending?
It happens from time to time.
Yep.
Again, I don't have exact data on that, but when we identify, and there's a number of ways we do identify that, we do hindsight reviews on loans immediately when loans are advanced to identify if there has been a breach of any of our policies, and including responsible lending. That's a major focus for us. If later on, when a loan maybe goes into default, it is a standard procedure for us to assess at that point in time if there was an issue around maladministration or indeed responsible lending. And we have remediated customers where we've got it wrong. We do not always get it right.
And do you immediately report that once it becomes apparent to you, or do you just resolve it?
No, we report that
immediately.
Yep.
Immediately. So if there were financial counselling services that were declaring that they believe that irresponsible lending has occurred, and that's reported to you, does that trigger your...
We would investigate.
That you would investigate?
Yes.
You wouldn't necessarily report?
It would trigger the hindsight, and then the outcome of the hindsight would determine the report.
Okay, and the hindsight is assessed by you, your business internally?
It's an independent team internally.
An independent team internally?
So it's independent from those that have done the original lending. So it's reports through to a different area of the bank.
Okay. So one of the things that's concerned me in the inquiries that we've been undertaking with regard to consulting is the self-determination of what conflict of interest might look like and how that's managed. Internal reporting has some flaws. What KPIs are people measured on? How does my career advance if I become the one who's constantly figuring out that there are problems here? How are you managing all of that hot stew?
Yeah, I understand that culturally you could look at that and be concerned about that. I see no evidence of that. Our objective is to, if there has been something we've done wrong, we want to identify it to make the customer good for that, and also make sure that the regulators are aware of where we haven't got it right.
So can you have a look at where irresponsible lending or maladministration has occurred?
Yep.
Because you'll have this individual data, and have a look, cut it for us if you can on a culturally and linguistically diverse lens. Have a look at that. Also, where we're talking about age related, and any other way that data can actually open up some insight into what's going on. Is there a particular cohort? Is there a group of from a particular industry that's operating? Is the reality of multi-generational housing for particular communities creating problems? And are you doing that kind of analysis anyway?
Yes, we'll try and cut that data and see if there's any particular trends that we can identify. Some of those, I suspect we may not look at it that way with things like multi-generational housing, but we do cut information like age of borrower when they take out loans and things like that to see if there is, and we do, there is much greater scrutiny, for example, for borrowers over a certain age taking out a loan to make sure that they can see that loan through to completion when the expectation is they would normally reach a retirement age before the loan is completed. They're the sort of things we look at from a responsible lending perspective to make sure that they have an exit strategy other than...
so I guess that begs the question, what is the exit strategy that is embedded in the products that you design, knowing that 40 to 60% of people who get a shared mortgage are going to break up? What's the exit strategy there?
Yes, the reality is we don't ask couples who want to take out a mortgage to provide us with details of an exit strategy if they break up. Do
you think maybe it's time for us to accept the reality, Mr. Fennell? I mean, I'm a romantic and I love the thought. I've been married for 40 years. Hooray. How good is that? How abnormal is it though, right?
This is exactly what we were talking about in the roundtable that Anna mentioned with Catherine Fitzpatrick and industry. We literally sat around like this and threw around ideas like, should we be saying to people when they're sitting in front of us, the likelihood is that this is an outcome, what do you want to do in that situation?
Which is the abhorrence of having a prenup was a cultural phenomenon. Now is the abhorrence of having a discussion about if this falls apart, what are we going to do about the mortgage? What about tenants in common? Is that part of a solution? Have a think about that as well. I'll put that on notice. Back to you, Ms. Mascarenas.
These might be some questions on notice and into numbers. So we had the 8,000 customers that have experienced financial abuse. Would you be able to tell us an indicative dollar value as to the value of the transactions?
Unfortunately not. We have gaps in the data that we're capturing in this, and that's something that we're very aware of and that we're taking steps to remediate. And potential losses isn't something that we capture right now. It's something that we will definitely think about moving forward, but I can't quantify it now.
Which follows on to the other question, and I know that you're doing work around this, and so the thing that I know is that there's like the order of magnitude of financial losses associated with financial abuse is in the order of $5.7 billion. Would you have a dollar value as to how much you've helped victim survivors claim back from perpetrators?
No, in the same boat with that one.
Do you do that?
It is a lot more challenging in those circumstances than it is for fraud. We've got whole frameworks set up for recouping funds under the fraud. We don't have that framework set up for funds.
And do you see that the lack of that framework because of a lack of legislation in that space?
Yes. Yeah. That's the big challenge. One of the big challenges here is in a lot of cases there is no prima facie illegal activity going on, and again, as was discussed in the earlier session, without a victim being prepared to make a claim against the perpetrator. And this is the challenge, whether that be elder abuse, whether that be abuse within a marriage. It is a challenge.
I'm going to send a couple of documents to you. One of them is a model of best practice for financial abuse service, and it talks about very different ways of responding. I know you've got 8 people in your team. This model, I don't know how it will work for 8 people. It talks about 1, cold referrals, warm referrals, co-location and outreach, integrated, highly coordinated, collaborative, and then in-house. With very, very different kinds of level of skill embedded. If you look at the descriptors of, the sorts of clients that you've got to deal with, I'm sure you're dealing with all these types of people. And if you're setting up a workforce to do this, I'd put it to you that understanding banking is going to be one thing, but actually understanding people is probably going to be even more important. And that this is an area that, people who have done 4 years of sociology might be critical for you to be able to engage to give a proper trauma-informed response rather than a banking-informed response. And that partnering between those sort of 2 different skill sets might be something that's important. So just ask you to think about what you've got in terms of what this best practice model might indicate. And then the collaborative service model for legal and non-legal support is another document that's indicating, 2 pillars, how it could provide service and drive change and create a feedback loop for the development of product.
Yeah, and I think the thing, just looking at this very briefly, Senator, the idea of some of those services being in-house and then partnering with specialist services makes a lot of sense from our perspective.
We're consultants, I say.
Yeah.
There's a lot of claims about skills that are not matched with capacity.
Sure. It's just given our scale, our ability to necessarily have all skills in-house can be a challenge from time to time.
Yeah, it's wonderful. Okay. I think we're out of time, so there will be questions on this.
And we'll be happy to respond.
And I'm going to ask all of the banks, if I can, to have a really good look at the Economic Abuse Reference Group submission. There are multiple case studies in there with a range of recommendations that follow. I'd be very keen to hear from each of you how you respond to that particular sort of case study and what you think about the level of ease of implementation of the recommendations, which don't go all to you. Some of it comes to government, etc. But where appropriate, would be of interest to you, would be enabling for you.
We'll be happy to do that.
Great.
Can I just add a comment on what Senator O'Neill said? From a, say, fraud and scams perspective, you have your hackers testing the system.
Yep.
In some ways, the case studies that are in that submission is a really great way of testing what your internal systems are to go, if we had this case, how would our system approach this? So,
and it actually mirrors the way we work with, as we identify case studies that that Hayley and her team come across. We look to learn from those, and we do, through the training we provide to our frontline staff, use those case studies as part of that training to help them identify future cases.
And I will say to you, I've asked ASIC what they do about directors, how they ensure that people who are signing up to be a director actually have the skills that they're supposed to have, and there's been no proper answer there as well. But I can tell you one thing as a teacher, if you think you've taught something, the only way to check it is when the learner gives you back the information in their own words, then you know something's happened. Without being able to say it in your own words, there can be a lot of fakery, I found over the years.
Yes.
So that is a challenge, I think, in terms of complex new knowledge for once in a lifetime mortgage acquisition. There's not an appetite to engage with that. And asking somebody to actually put in their own words what they think they're doing is a potentially very powerful way to open up a conversation about what safety then might need to follow, depending on the level of response. Yeah.
Yes, and it parallels what's been implemented at an industry level around people providing guarantees.
Yes. Do you know what this means?
Yes.
Yeah, exactly. Yeah. Okay, well, thank you very much.
No, that's
and if you can assist the committee by returning any questions on notice by the 5th of August, that would be most helpful.
Be our pleasure.
Thank you. I now call forward representatives from the National Australia Bank. Great, thank you. Very much. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to the Senate has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear?
Jocelyn Turner, I'm the Executive of Customer Resolution and Remediation. I'm appearing on behalf of NAB.
And Edward Grieve, Head of NAB Assist.
Thank you. Thank you very much. To be fair to everyone, I'm going to ask you to table your opening statement, but give you a minute or two to speak to what you think are the really critical parts of this that you want to put on the public record for anybody listening.
Thank you. Good afternoon, committee members. Thank you for the opportunity to build on NAB's written submission, and we really look forward to contributing to this important discussion. I would like to recognise the traditional owners of the lands on which we meet today, the Wurundjeri people. I pay my respect to their elders past and present and extend that respect to all other First Nations people. My work at NAB brings me into close contact with customers at every point of their banking experience. My team resolves customer concerns and then works with the bank to improve our service. We support customers who are experiencing all forms of abuse. Many colleagues across NAB come into contact with Australians impacted by financial abuse every day, and we recognise the important role banks can play in protecting our customers. We also partner with a number of organisations to refer customers for expert help. Good Shepherd, our longest-standing partnership of more than 20 years, offers no-interest loans to customers. Together, we have supported over 1 million Australians with over $500 million worth of loans. We've committed $6 billion between now and 2029 for affordable and specialist housing. NAB has undertaken several initiatives to tackle financial abuse on the banners of prevention, intervention and support. Rather than me outlining each of those, how about if I stop my statement there and go to you for questions? We really look forward to this opportunity to have a conversation with you.
Wonderful. Thank you very much, Ms Turner and Mr Grieve. Can I just ask you how many customers you do have?
So it depends on whether you take customers or accounts. So the number is somewhere between 9 and 13 million.
So customers 9, accounts 13. Okay. And how many people, how do you structure your support? Do you have a hardship and vulnerability differentiation or any other forms of differentiation?
Yeah, so we have our NAB Assist team, and they are responsible for looking after customers at the point in which they tell us that they are starting to enter financial difficulty. Part of that team, up until recently, has been the financial hardship team. That team has just recently moved across to sit with me. So my team now consists of financial hardship. I look after complaints. I also look after remediation, which includes responsible lending. So I'll be looking forward to having a conversation with you about that. And that's all I've got in my team.
Okay. So how many people
across that ecosystem? So we had 800 people sitting in NAB Assist, of which 120 of those were sitting in the hardship team that's recently joined my team. I have 120 to 140 people sitting in my complaints team, and then sitting in remediation, I have a large number of people, and that fluctuates depending on the work we do, but the core of our responsible lending team, I have another 30 people sitting in that team as well.
Okay. And do you have a vulnerability team separate from that?
The vulnerability team sits as part of our hardship team.
And how many are dedicated to that task?
So I'm going to say that's 30 to 40. You'll have to forgive me. I've only had the team for about 2 weeks.
Okay, it's all right. If you want to correct anything on the record, that's
Thank
fine.
You.
So the vulnerability determination, how does that occur, and how do you staff that part of your team?
So the responsibility for identifying vulnerability actually is consistent across our entire network. So our frontline staff are responsible for identifying it, right through to my team. We don't necessarily hand off teams. So we have a customer support team that does help us manage vulnerability, but quite often we will deal with that inside our complaints team as well. So although at the moment we have a specialist team of 15 that deals with vulnerability, it does occur and is supported across multiple parts of the organisation, depending on the customer's issues.
Okay, so I'm thinking really about a person who's in a financial abuse situation. How could that sit across both of those?
So it sits across, so the primary accountability will sit with NAB Assist or into customer care, but if the customer, for example, raises a complaint, we will determine who's the right person to take that forward. So it might be one of the complaint team specialists with the support from Customer Support Hub, or it might be the other way around. It's really determined by what the customer needs.
Okay. And how is that triaged? Who does that triage, and what skill level do they have?
So what do you mean by triage?
So when you go to the hospital and the nurse looks at you and goes, okay, emergency, get them in, or you go to the back of the queue and wait till, we're finished so you can get that bead out of your child's nose. That's a triage.
That's done in the customer care team. So the customer care team, the 120 people, the first call goes into them and they triage whether or not it's something that can be dealt with by the majority of the team, or if it needs to go to specialist handling from the customer support team.
And what is your capacity to deal with that? Do you have spare capacity, or is it always absolutely chockers?
Everyone is always very busy.
Right.
Yeah.
So how, given the state that people would be in by the time they really are ready to say, look, I'm in a very vulnerable situation. They might say it in other words, but somebody's got to identify that. Might they have to wait to get access to somebody with the skills necessary to help manage the situation?
They should have access to somebody immediately. If they're calling in, there's somebody ready to support them all the time.
Okay, and would they have that same person then manage them if they are vulnerable?
Not necessarily. So once that triage has been done, they might be referred through to another team who can provide them with specialist case management support. Okay,
so a team of specialist case management, but I don't want to retell my story over and over because I'm needing trauma-informed response by that stage, okay? I don't need somebody who understands a banking product. I need somebody who understands a human being. Yeah. How is that being managed?
So I would have to say that that's something that we continue to struggle with, particularly if a customer tells the story first off to someone in a frontline team, like a branch or a contact centre, that is then referred through to a specialist team. More often than not, they do have to tell their story again. It's something that we are looking to work on. In terms of the trauma response training, we are in the process of rolling that out across NAB Assist in order to better support our customers and our people, to be honest with you, in having that conversation.
Yeah, well,
they're not
the
easy
assumption that the person who's receiving the information is in great tip-top mental health, right? Yeah. Not always the case, especially if you've been doing this for a long time. So how do you manage that staff that receive it?
So we invest in a very significant mental health and wellbeing support program that supports all of our teams across NAB Assist. We spend somewhere in the region of $500,000 a year on making sure that we have the right level of support. The other thing that's most important is, even just to the very point in the moment, if someone's taken a call that is difficult, we encourage them to not then take another call. They need to have a break. That's really important, and it's part of our scheduling, and right through to making sure we have sufficient training and support so that they feel like they're equipped to have the right conversation.
Okay, so say I'm triaged, I told my story once, I've told my story twice. Do I get someone dedicated to looking after me?
And do you have a view on that point in the process?
I think it will depend on the nature of the customer's situation. So for a customer that requires an ongoing level of care and assistance, absolutely, the process would be to refer them to a case manager, so they've got a single point of contact moving forward. But it does depend on the nature of the customer's circumstance. If it's something that can be dealt with more readily to support that customer and doesn't require ongoing assistance, it may not be referred to a case manager.
Right. So most cases of financial abuse are not going to be simply resolved. They're going to be complex. So what's the caseload for all these people inside who are carrying, individuals? How do you allocate complex cases, and what do you pay these people, and what qualifications do they have?
So in terms of caseload, I might need to take that on notice in terms of the specific numbers. Payment, in terms of salaries, they can range anything from sort of 80,000 up to 120,000, that kind of range. And we don't necessarily require any specific kind of qualification. However, that is something that we would look for as a great addition. What we look for mostly is, does the person have the right aptitude and approach, and can they maintain empathy in the moment through the conversation?
Mm. I guess I'm just signalling there that the task of the person who's at the end of that phone is so critical to the proper management of this issue. Coming through as a banker, product management is a good skill, but it might not actually meet the need of a complex situation for a person who is in a domestic violence situation characterised by financial abuse, but potentially other forms of abuse as well.
And that's something that I absolutely believe we need to continue to look at, because it does, I'm with you, it is a huge ask to ask any colleague to get on the phone and have that conversation day in and day out, and we need to make sure that they have the right skills to be able to support customers, but also they have the right skills to be able to support themselves.
Can I just go to the issue of reporting? That what we've heard from consumer advocates is banks often resolve financial abuse matters on the basis of financial hardship and compassionate grounds, even when there have been complaints raised by financial counsellors with the banks in relation to responsible lending and maladministration. What are your protocols if a financial counsellor acting on behalf of a client of yours, of a customer of yours, raises responsible lending or maladministration? What happens?
So that is referred to one of my teams for review, and that can be referred on the basis of being a complaint raised by the financial counsellor. It can be on the basis of the customer raising it directly with us.
Yep.
It can be on the basis of us seeing it inside the loan, because sometimes we can see a banker hasn't done everything that we would expect, and also we do review our loans as soon as they go into hardship, so we make sure that we understand whether or not that loan was appropriately given. So the combination of all of those things means that it's referred to my team. In the last 12 months, we've done 1,600 reviews of files that have been a concern to us. And where we find that we have done the wrong thing, we immediately move to remediate the customer. We have got a document, which is our policy, which I'm very happy to share with you, that's very clear around if we find that there's a concern, the very first thing we do is we look to compensate the customer, and then at the point at which the customer's been compensated and put back in the position that they should be in, that's the point at which we then consider, do they need any further hardship assistance? It would be inappropriate for us to provide simply hardship support to somebody if we've done the wrong thing, and we actually should be in a position where we need to put them right first.
So who makes the determination about whether there's been a breach of responsible lending or maladministration?
So my specialist responsible lending.
So that's an internal.
It's an internal team
decision.
It is an internal decision. That team, I keep that team separate from all my other teams, so they're sort of ring fenced off to the side by themselves, which means that they are able to make that decision without fear or favour.
Okay, I want to totally believe that, but I have some concerns about that. How many of those are referred then to reported to ASIC?
So I don't have the exact number of what's then reported to ASIC as a final breach, but we have a formal process to do that, and that's data that we can definitely get.
So you would report to ASIC at the end of a process, not as immediately as it comes to hand?
No, because sometimes something is presented as being a concern, and then you do the review and discover that it isn't.
Yeah.
So, and it's always case by case. So, but mostly we do the review first to determine whether or not we've
And
breached.
can other people, like if I didn't agree with your review, who do I get in to have a look at your review?
So AFCA absolutely has a look at our review.
Okay.
So you can go to AFCA.
We've had evidence put to us that AFCA have been made aware of maladministration and irresponsible lending and have not responded to that. Does that surprise you?
That does surprise me, because certainly in the cases that I've seen, that's not my experience at all. My experience is they're very good at identifying and referring that straight away. So,
okay.
And I also look after, so just to give you some context, when I say I look after complaints, I look after the team that also deals with AFCA on a day-to-day basis. So I've read a lot of their recommendations and determinations, and that's not my experience.
Okay, so many more questions I noticed, but can I just go to the prevention piece? We've been hearing from banks that the work informed by the advice of Catherine Fitzpatrick and Flequity, I think is the company, a social enterprise, has led to change to customer terms and conditions which allow you now to suspend or close a customer account where what you've described as unacceptable account conduct is identified. On how many occasions have you activated that new capacity?
So at this point in time, we have exited 18 customers off the back of, so that's been a combination of a number of things, but certainly off the back of our blocking of abusive transactions, the verbal abuse issues. I know that certainly only seem like a small number off the large number of 370,000 that we've blocked, which is about 13,000 a month. What we will often see is that is the number of transactions where that has occurred, not necessarily the number of customers. So one person can obviously do that multiple times, and that process is very clear. As soon as we see the unacceptable language, we stop the transaction in the moment, provide a warning, and the majority of those tend to stop at that point. We have then taken that through to 2,000 reviews, of which we've issued 328 warning letters. So what we are seeing is definitely the warnings we're giving to customers is very effective.
Changing their behaviours?
Changing their behaviours. Now, obviously, that's changing the verbal abuse inside the transaction.
Yeah.
I'm not.
It's not changing.
I'm not naive enough to suggest that that's changing their behaviours permanently. But from that perspective, we're at the point where we've now exited 18 customers.
Okay. And what are the consequences for them more broadly? You know, they just go to another bank and start up?
Unfortunately, yes, because under the Privacy Act, we're not allowed to tell anybody as to why we exited them.
Yeah.
Yeah.
So this Privacy Act is a very powerful and important.
It's very important because it also protects people.
Correct.
Yeah.
Correct.
Yes.
But are there any interactions between the police force and those who are concerned about domestic violence and triggering domestic violence awareness and the banks? Are there any interactions?
Absolutely. So we certainly work where we see if we believe a customer is in clear and present danger, we will refer that to the police immediately. So that would
How do you see that?
So if a customer calls us and says, "I'm in danger, he's about to hurt me, something's about to happen," then we would refer that to the police immediately.
What about if he's about to hurt me financially?
That is a different challenge because we don't have anywhere to refer it to, and that's one of the things that we've talked about in our submission that would be wonderful to see is an improvement in the regulatory framework that gave us somewhere to refer customers. We do have different state bodies where you can refer for elder abuse at times, but every state body has a different definition of what is acceptable or what they'll accept and looks at different topics. So harmonisation of that plus broadening that would make a really big difference.
I have many more questions, but not enough time. Over to you, Senator.
Happy
Ms. Mascarenhas, and then Senator Pratt will come to you.
At any point in the future, I'm happy to continue this conversation.
Thank you.
It's really important.
Thank you for your stats on the number of abusive transactions and the prevalence of that. Do you have a number of your customers that are experiencing financial abuse?
I have a number of different stats that I can give you, so we can start working down if you like. So I've got our requests for hardship on a monthly basis at the moment, and they have been obviously significantly escalating over the last 12 months. So we're sitting in the region of just over 5,000 a month. And then if we go down to kind of the next layer, when we look at the volumes that we're getting specific calls in to our teams, that's just under 3,000 a month. To our specific domestic and financial family violence coded calls, we're seeing that in the region of about 200 calls a month. But to give you a sense of why I'm concerned about that, the same time last year it was in the region of 60. Yeah, so those are the sorts of numbers. Yeah, and so the other number that I'm also quite concerned about is that I look at all the time, obviously, is complaints. And if I look at the complaint volume where customers are using the words, so we've done a keyword search only, so it's not perfect. It's not perfect. But to give you a sense of the relativities, when we started, we tracked back to sort of the beginning of FY20, where we were looking at about 40 complaints per quarter. Someone would mention some sort of domestic or financial abuse, and we're now seeing that at 70 to 100 per quarter. So they're definitely numbers that have me particularly concerned.
I'm going to let you know that you've given me goosebumps because one of the things that they say about financial abuse is that it's an earlier indication of physical violence escalating. And you saying that the calls this time last year were 60 a month and now they're 200 a month. But what we're seeing simultaneously is the number of women who have died this year being at an elevated level. And so the thing that I'm thinking from a data perspective is some of your data you can use to do predictive analytics. And so the thing that's interesting is that this is data that us as a government's not collecting. But if we had access to that data, it's kind of like, right, okay, this is escalating. This is what we're going to see. And not every case results in physical violence or a homicide, but to me there must be a correlation, but I'm not academic.
I'm not sure that what I'm about to say is going to give you comfort precisely, but the reason why I ran these numbers is exactly because of the number of deaths we were seeing, and personally, well, more than troubles me, it horrifies me.
Yeah.
So I wanted to see what inside our data we could see. So that's what I can see. The next step is exactly as you say, is to take those case studies to try and understand what actually happened in those situations, and then to work out whether or not we can codify those and use them in our data, because that is absolutely the next step. Because as you've heard from a number of witnesses already today, what normal transaction behaviour looks like can look very similar, but there will be clues in each of those cases that we can learn from, and so that's the next step. So once we identified them, the next step is to work out what can we learn from that and use to inform our data models so that we can be better at identifying it earlier.
Do you have a sense of whether other banks have seen this uptick in?
My sense is that I don't. Well, unfortunately, we won't be out of whack with anyone else, because I do believe this is unfortunately what we are seeing, and it is directly correlated to the increase in financial pressure.
So you have some great products that are available, or great initiatives, and so the no interest loans, which you have been doing for decades, amazing. It would be interesting to have a sense of what the stats are around the use of those loans, and but also I'm interested in your domestic and family violence grants of up to $2,500, and getting a bit of a sense of how many customers you've supported through that.
So I can give you, on the domestic and family violence grants of $2,500, we've seen not as... So I'm going to say is the numbers aren't as high as I would like. So in 2023 we made 16 payments, though to give you a sense of it, in the first 6 months of this year we've already made 14. So you can see that the trajectory of that is doubling. The question that I have, which will be the same question that you have, is whether or not that's enough and whether there's more we need to be doing. What I'm hopeful is that that's representative of those grants are for women who are in absolute desperate need and absolute fear of safety of their lives. So they really are to help somebody move out of a home. It's to give them access to a phone. It's to get them into a place where they are safe and able to take care of themselves. So that's why that number is really important. Please don't look at that number and think because it's so small that it's not a problem. It's more I think reflective of the incredibly acute notion and the reason why we have that loan. In terms of the NILS loan, I can give you a little bit more around that as well. So probably some of the numbers that we've already given you, we've got, since 2003, we've provided 400,000 microfinance loans valued at $520 million, supported 1 million customers, as I said before, and there are 2 specific programs that have supported family and domestic violence, one of which is about economic empowerment, and the other one is for vehicles. One of the things I would say is the family domestic violence one specifically is about to be discontinued because the long-term government funding has been withdrawn. So that's probably one of the other things that I would say that we see often in this space is you have services that are offered for a period of time and then they're withdrawn because the funding isn't consistent, and it comes in a very piecemeal way. So that would be something else that if there was something else we should be looking at, I think that's one of the big areas that we should be looking at as well. I have lots of other stats on that, but I'm sure you have other questions.
Do you know if you have a dollar value of how much money has been recovered from perpetrators for victim survivors?
I don't have that number. I wish I did. But I can certainly assure you, because of the number of cases that I personally work on as well, we work very hard to recover the money, as much money as we can. It's not always straightforward because that money is enmeshed, and more often than not you will see, because of the lack of financial literacy potentially of one partner versus another. They don't know. There's not always an understanding of why the money is being withdrawn. Quite often we'll see the withdrawal of money for ATO debts, etc., that not both partners don't necessarily understand. And in the breakdown of a relationship, the communication around those matters becomes very difficult. But we take it very, very seriously when money is withdrawn from a joint account and that both parties don't agree, and we do an investigation to make sure we understand where that funds have gone and what it's for, and if it's not appropriate we ask for the return of those funds. We encourage customers also in dispute to put a block on that account so that actually that money can't be withdrawn. But I also acknowledge that potentially puts the parties at risk, because then it puts them at risk of being put into physical safety issues.
You're aware of ASIC's review of...
I am very aware, yes.
Yes, and how would you characterise their response to the sector overall?
I think their response has been excellent, and I think it certainly starts to shift the bar for all of us, because I think there's definitely more we can do. Will it be enough over time?
Is it fair to say previously it was a rinse and repeat model? Okay, this is our standard operating procedure. This is what we do. This is what we do. This is what we do. I would put to you that it is easy to have such a model when the people who are answering the phone are banking specialists, not sociology specialists.
Yeah. So I would absolutely agree with you, and I think one of the things that ASIC has done is really lifted the bar for all of us, and we now need to work through what the appropriate response is.
And do you believe at this point of time that the National Australia Bank has made a sufficient or material enough change that if ASIC were to come and have a look at your practices now, they would see there's movement?
I would absolutely be sure that they would see movement. Am I happy that we've done enough? Absolutely not. So there's a lot more work ahead of us.
What about staffing going forward? Are you going to increase your staff in
yes.
your...
We're in the process of doing that right
Hardship and vulnerability, like it seems every bank has different structures, so who are you getting in and where are you going to put them?
I'm in the process of getting the approvals to put them in, and then the next thing is where am I going to get them from?
Yeah, so what did you seek in terms of additional staff and why? What's your rationale?
So at the moment we have, we're looking for an extra about 25% increase, and I'm just sorry, I just was running that number in my head. 25% increase, and the reason we're doing it is just simply because of volume. So we're looking at the numbers of the calls we're getting in, the number of customers seeking help.
Right, so 25% increase in staffing for your hardship.
For our hardship team.
Okay.
Yeah.
And remind me how many are in that?
120. So I've asked for another 25%. My maths might be slightly off there. I apologise.
Okay. All right. So, and what skill sets do you require?
That's my next step. So the next step will be once we get approval.
Role descriptions.
Will be role descriptions. That's what we need to look at.
And what capacity?
Yeah, capacity and capability. And this review has come at the perfect time because it does give us an opportunity to think quite deeply about who the right people are and where to find the right people.
Okay, I'm going to ask you, like I've asked the other banks, and I'll be asking, and the Secretary will note this, the Economic Abuse Reference Group have provided the committee with a very fulsome submission and quite a number of case studies, and I'm going to ask you, like the others, to interact with those case studies and the recommendations that have been put there. As Ms Mascarena said, it's an opportunity for you to critique your practices. What would you do in this circumstance? Where are your protocols that would lead to better outcomes? You know, like some understanding of that, and whether the recommendations you would see as possible to be implemented by you, and in some cases it's for government, whether you think they're good ideas for government to implement.
I'll certainly look forward to reading that. I've seen a little bit of the summary of it, and there's certainly some ideas in there that I think are really interesting.
There's some shocking stories in there. Yeah. Like, seriously, you just go, oh my God, how could some people be so malicious, so cruel, so deliberate in their abuse of a person that they express some care or loving relationship with?
Unfortunately, I see it on a day-to-day basis, and it is, at best, heartbreaking.
Senator Pratt.
Thank you, Chair, and thank you to our witnesses today. Can I ask if you've seen in your examples and experience cases of dowry abuse. And so you might see money coming in from South Asia, whether you can, whether you've been able to track assets going from one family to another, where abuse has resulted at the end, and whether there are things in international banking protocols we should be looking at.
So I certainly don't have that data specifically, and to my knowledge, we haven't looked at anything like that. However, what it does raise is a really interesting opportunity for us as we go through. As I said before, we are looking at how we can use data to better identify types of financial abuse, and it's a great one to raise, and it's certainly something that I will add to the list of typologies for us to have a look at.
Yes, so it would be worth talking to Professor or Dr. Mangela O'Connor, Data O'Connor, about that, and some of the women that she has worked with where cases of abuse have been prolific. So where money's been transferred, whether it's to pay student fees or as a dowry, that's not been then used to the benefit of a couple mutually, as you might expect it to be in the case of dowry, and whether perhaps there are even better banking products for couples establishing, for migrant women to increase their literacy around these issues.
There's certainly interesting ideas and things that, I'll be honest, we haven't thought about specifically, but as I said, we are in the process of reviewing our data and how we're approaching this, so this is a great opportunity to add that into the mix.
Thank you, that would be really helpful. Do you see particular legal or legislative barriers to innovating safety by design?
I think we've already discussed
the Privacy Act.
Yes,
Yeah.
So we've definitely discussed the Privacy Act as being one of the things that we are concerned about. We've talked, other witnesses obviously have talked about the power of attorney and enduring power of attorney issues. I think probably the other things that I see tend to be less about the way products are designed and more about the way they're used, and more about what's sitting inside the Act. So things like the National Consumer Credit Protection Act, as an example, the financial abuse is not actually currently recognised as a cause of inability to meet obligations. So that does make it a little bit more challenging when we are looking for different solutions for customers. The other act that we are concerned about is the way in which the Credit Reporting Act works, which the Comprehensive Credit Reporting Act works, which obviously is something that is incredibly important and we stand behind. However, in situations where two parties are in dispute and one of them would like to take on a financial hardship arrangement, which would mean that both parties would, because they've got a joint lend, both parties would end up with a financial hardship information indicator on their account. That can lead to specific safety issues and concerns for women in particular. At the moment, ASIC have granted us a temporary no action position, allowing us to withhold that, and we would be really keen to look at a permanent exemption. In fact, I've seen cases quite recently where this is a fundamental issue, where ex-husbands can use that to weaponise the situation, and the consequence for a woman of leaving that home is potentially her and her children then have nowhere to live. So there are definitely circumstances where I can see there are barriers to us being able to support customers in the way that we would like.
And are there things we could be doing in terms of documentation for customers prior to them needing to access documentation that would be covered under the Privacy Act. Before, at the opening of a bank account, for example, so that mutual access is guaranteed from the outset so that people can opt into products with greater safety attached to them from the outset, and so that financial risks within a relationship can be addressed before they become abusive.
So I absolutely agree with that, and certainly we can always do more to uplift that content. The other thing that I would say is that in my experience, one of the biggest issues with that content today is that it's actually incredibly complex. I do think a simplification process would be really worthwhile. They're very complex documents. They're difficult for customers to read and understand. We've done a lot of work to try and simplify our terms and conditions, but there is always more that we could do. The regulation at the moment really doesn't think about ease of communication of very complex topics. It talks a lot about how you communicate those complex topics in a complex way. So that is definitely an area that I'm personally very interested in, and we're certainly very interested in as an organisation.
And what about transaction by transaction, using AI, searching for merchant codes and making sure that households have more complete financial information? So, for example, there would be an expectation in joint accounts that both parties can understand the transactions inside it in an independent way, without necessarily needing to ask their spouse what something was. How much can that be automated with AI and changing technology? For example, just merchant code descriptions and the like.
So we've worked very hard on uplifting that over the last couple of years, and certainly the quality of that content is significantly better now because of the AI and the sorts of tools that are available to us. The other thing that we have sitting in our internet banking is the ability to go in and have a look at the way in which a budget is constructed and where money is being spent. I'm also very cognizant of the fact that while on one level we talk about that as a very good thing, which it is, it also creates potential harm and risk for customers as well. Sometimes there are expenditures that the other party would rather wasn't brought to light in the relationship, and the discussion of it can create harm. So I do think it's an area fraught with significant danger. But I also can see the absolute advantages. Unfortunately, as we have heard today, that is the answer that we see on pretty much every topic.
That's the last question.
Yes.
Senator Pratt.
Thank you.
Could you advise how many of your hardship team, your vulnerability team, like that combination there, how many of them are multilingual?
I don't know that I have that data. We don't have that data.
Is that a priority in employment?
Not necessarily, but it's not a barrier either. So it
certainly shouldn't be a barrier.
It's certainly not a barrier. Sorry, I just
yeah.
Of course, it's not a barrier.
Yeah. The reality is, people being able to speak in their own language is a very significant thing.
Yes.
So if you could take on notice, how many people on that team are employed there and operate in multiple languages, and how many times you have to get interpreting services in?
So we will definitely have a look at that. I'm not sure I have the data about the cultural background of our colleagues, because I'm not sure if we collect that. But if we do, we can give it to you.
So cultural background is one thing. I want to know if they are actively able to converse with somebody who rings in distress in that language. How many languages you offer that service in? How many of those are employed within your bank? Right. How many people come from a consultancy service that might be available at a different time, or
We will attempt to give you that content.
Thank you.
But we also do use. We can certainly give you the number of times that we refer to Language Loop, which is the provider that we use for interpreter services.
Yeah. And what's their skill level, and how culturally literate, what about trauma-informed stuff for them as well, right? So
That's a
kind of
great
get that
question.
sense.
Yeah.
The next question I'll notice, if you could take the descriptors, the AI that's coming in that's finding that the descriptors of abuse, right?
Yeah.
No longer, I can't abuse you by phone anymore because I haven't got your number. I can't come and abuse you in person because I don't know where you live, but I've got to pay child support and I'm going to abuse you every chance I get through the banking, right? That's been interrupted by AI.
Yep.
What other AI observation are you doing to identify coercive behaviours?
So we have at the moment and it's very, very early, so we're in the process of doing an early investigation as to whether or not we can use AI to identify financial abuse in accounts. So we're working really hard on that at the moment.
And do you have any research partners in that endeavour?
I don't think we do at the moment, but I will double check with the team.
Okay. So, how many people are working on that, and what other products are you doing? What other ways? Because it sounds like I was hopeful that AI was doing more, but it seems like that's the only thing that it's doing is identifying when people use abusive terms in there.
So at the moment, yes, but I think that's more reflective of the fact that we are all still experimenting with AI, and that's more reflective of the technology itself rather than and how new that is. We are very quickly running a number of experiments.
Right. So, we'll hopefully get some more information on that. There probably will be further questions on notice. Certainly, I'm going to send you a couple of documents and ask you to interact with that and give us, the committee, some feedback on what you think there. Can I thank you for your attendance today, Ms Turner and Mr Grieve. Thank you to your teams back there, and I look forward to, seeing the implementation of higher and higher quality responses to the needs of your customers who are experiencing financial abuse.
Thank you. This is such an important conversation. We're very privileged to be part of it. Thank you very much.
Thank you for coming. If you could respond to those questions I noticed by the 5th of August, that would be helpful for the committee.
Of course. Thank you.
I now welcome representatives from the Commonwealth Bank of Australia to come forward to the table. Senator Pratt, I'll come to you first. Great. Welcome. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Thank you. Kylie Elizabeth Rickson. I'm the Chief Risk Officer of the Retail Banking Division of the Commonwealth Bank.
And I'm Angela McMillan, Group Customer Advocate for the Commonwealth Bank.
Thank you very much. Now, to be fair to all of the banks that have come before us today, thank you for providing a hard copy. In the interest of time, we'll table this and it'll be part of the record of our conversation. But I'd just like to give you a minute or so to talk to the key things that you really want to tease out from what you've put in writing.
Thank you, Chair. Firstly, I'd like to begin by acknowledging the victim survivors and their representatives who've contributed to this really important inquiry. Our support can largely be described in 3 areas. So firstly, we've significantly invested in supporting victim survivors through our CommBank Next Chapter program. Secondly, we've been focused on strengthening our products and services to improve their design and the use of technology to better identify instances of abuse. And thirdly, we've been focused on improving the capability of our employees to identify and respond to financial abuse with 18,000 customer-facing staff receiving specific training on this area annually. We welcome your questions.
Oh, thank you. Thank you, Ms Rickson. Just before I go to Senator Pratt, can I just ask that first question of how many people have you got in your specialist response teams? How have you got them structured?
Yes. Angela, do you want to take that one?
Yes, certainly. So if we talk to vulnerability in the first instance, so I have the Next Chapter team within my remit, so within the Group Customer Advocacy and Vulnerability team. We currently have 20 headcount, so these are specialist trauma-informed individuals. whose sole role is to provide immediate banking support to individuals, no matter who they bank with, when they contact the bank seeking support around domestic and family violence and financial abuse. We also, as part...
So no matter who they bank with, so if they're with NAB and they ring Commonwealth, you help them?
Yes. Yes, under our Next Chapter program. Sitting alongside our Next Chapter team, making up that 20 headcount, is a team known as Community Wellbeing, and they are there to provide specialist advice and guidance to other parts of the organisation, so that wherever someone who may be experiencing financial abuse and domestic and family violence enters into the organisation, they can get that specialist support.
How many are there?
So that makes up the 20 headcount. So
okay, so Next Chapter is 20?
Yes. So and both teams combined
is 20?
20, yes.
Okay, and what about hardship? Is that in a separate category?
That is in a separate part of the organisation.
Yes.
And so how many have you got in that team?
So in the hardship team, there is a little over 200 people. I think it's approximately 215, and there is an extra care team within that hardship team of approximately 50 people, and they deal with these specific cases of financial abuse. Okay, and how does that intersect with the 20 in the Next Chapter guidance group? So the entry point might be different, as Angela has said, in terms of coming through the front line or through Next Chapter, or the customer may have called us because they can't pay their loan repayments, for example, and they need support, and they may come directly into the hardship team through that avenue. So could you have somebody of the same profile who is in Next Chapter also be in the extra care team under hardship? Yes, that's right. And so there's some overlap. Yes.
I would say that the point of differentiation between the teams is that our extra care team in a hardship space is very much structured in the case management approach. Our Next Chapter team is very much there to provide immediate support to customers who may be experiencing financial abuse. So they're very much, their focus is on ensuring that banking is safe and that the individual themselves is safe, referring them into other parts of the organisation such as extra care if there is specialist support that's needed as part of their circumstances, or referring them to some of our external support partners as well. So it's not a case management function, as it will, it is a support function in the moment.
Okay, so it's more like it's a triage service in a way.
To a degree,
yeah.
To a degree. Yes.
And does provide some immediate services in relation to emergency funding and information that might need to be done or steps that might need to be taken around authority on accounts, setting up new accounts and connecting those people with other external agencies that we partner with where they might need a new mobile phone, etc.
Okay. How many customers do you have?
In the retail bank, there's approximately 12 million customers.
And 12 million, you've got 215 in your extra care case management area. How are they all going in there? Are they happy with their workload? Because that's not many people for 12 million.
Well, out of those, so we have in hardship, we have approximately 350 cases relating to financial abuse, either domestic and family violence or elder abuse that we're dealing with within that team at the moment. And it isn't the case that so while people are, we might be supporting them in a quite intense way for a period of time, and then they may go on to a deferral or a payment arrangement, and we would be checking in with them from time to time. They might be awaiting, for example, the outcome of a family court or some other negotiated settlement. So we certainly have both workflow tools that look at what they're actually going through in terms of the workload, and we also have the ability to bring in case managers from different areas as well if there is like peak and flow. We're very mindful that those people are our most experienced practitioners. They have been through, and there's a really good combination in that team of people who understand the credit products, which is critical to be able to provide bespoke solutions, but who have also been through the appropriate training and are long tenured employees where they've dealt with lots of sensitive cases. So we have trained all of our people in that area and more broadly in collections with an external provider on empathy style training that is very specific to mental health and domestic and family violence, and we do that on an ongoing basis. We also provide those people with access to ongoing support for their own health and wellbeing as well, and check-ins.
So the collections through an external agency, that is outsourced, that's debt collection, is that correct?
That's right. We don't refer these sorts of cases into debt collection where we are aware and are case managing those cases. Clearly there might be some circumstances where that happens, not in relation to home loans because we don't refer out to debt collectors, but in consumer finance where we are not made aware of that situation.
Okay. So one of the things that ASIC said was that there's a gap between what really is required in terms of hardship response and what banks are offering. How have you changed your processes since that finding or that statement from ASIC?
Well, firstly, I'd say that in the individual feedback that we received from ASIC, CBA was told that we compared favourably to other lenders in many areas, and in particular we were called out in relation to some of the more customer-centric bespoke solutions that we have. Nonetheless, there is more that we can be doing. So some of the things that we're working on is better communication to customers through the end-to-end journey that they're on, and how we are reporting. So whilst we have various KPIs, looking at what aspects of those should be reported up through to senior management and the board.
To drive the sorts of change you need. Are you looking at increasing the headcount of your hardship team?
We respond. So we respond to the sort of workflow that we need based on a forward-looking plan. So, for example, on the broader, both across collections and within hardship, we monitor what cases we're seeing, and also that collections team will work with my team in risk to understand what is the forecast of customers that we think will be falling behind on their payments, and then the collections and hardship team will do workflow forecast to see what their FTE is, or the staff numbers that they need, and they will forward hire, for example, where they can see that they're going to need more people, and so we have done that in the past, and we will continue to do that. That's part of our operational rhythms.
At the moment?
At the moment, that is part of our operational rhythm. So we are constantly looking at... Have you gone
up or down? And what are you planning for the next 6 months?
We have increased our overall numbers in collections from time to time as we've needed. So it's sort of peaked and then gone down.
Collections. I'm talking hardship. Are they the same thing in your mind, or are they different?
Well, hardship is a subgroup within the broader collections area, and so they're subject to those practices as well in terms of looking at forward workflow and understanding what resources that we need, and then we are able to forward hire or move people from other parts of the bank that are appropriately qualified.
So that's about getting the money back collections, right? And hardship sits within that, and I understand that that's what a bank's business is. But we're really inquiring into financial abuse. So how many, you said 350 financial abuse, DV or elder abuse?
Yes,
is that the total?
Yes, so active cases we're working with now within the extra care part of hardship.
Which is 50 people looking after 350
cases of domestic and family violence, and around 50 cases of elder abuse, and there would be other extra care cases in there as well.
Yep.
As I said, that workload, is we look at how many files that one person should be managing at any one time, and that's part of how we monitor workflow.
And when I get a file in that extra care unit, does that give me that person to deal with? Or could I be shopped around to different?
Yes, it does give you that person to deal with. And obviously sometimes if that person is on leave or, but yes, it is case managed. Yes.
Okay.
Yes.
And is there a plan to increase the extra care workforce?
As I said, we look at that, and if there is, if we can see that there is more flow that's coming into that area, then we will hire into that area.
And so I guess if you can take on notice, are you on a trajectory of increasing or decreasing?
Yes,
that?
we can absolutely take that.
That would be good. Can you also advise how many multilingual people are in that team?
Do you want to talk about next chapter?
So from a next, if I can refer back to next chapter, just to give you some context in that crisis support function. So out of the 20, we have 8 languages which are spoken, and those are spoken on a regular basis. And if we have a customer who needs to be referred into our collections space, that will be done via a warm transfer. And if language support is required, then our specialists will continue with that support.
Okay. How many of your extra care people are multilingual?
We'll have to take that on notice.
And is that a priority in terms of engagement of people in those roles?
Well, certainly being able to communicate with empathy and effectively is a priority for us.
Yeah. In English or in which languages, or all 8?
Well, we use the next chapter multilingual staff that we have, as Angela said, to make that connection. I'm not aware if there is specific hiring practices that prioritise any specific languages or multilingual people specifically in that team. But they do have access to the next chapter team.
Yep. I guess there's a concern about having deep knowledge. The other thing is these are people who have come from within the bank who understand your banking products. Have you got any people who are social workers or community workers or lawyers in that extra care team to deal with the complexity of matters that are going to emerge?
I'm not aware of specific backgrounds. They would be of fairly differing backgrounds, but the common factors would be that they're long tenured and experienced people within the bank, and that they have those critical understandings of the products and the credit landscape and the laws relating to responsible lending and our policies, and that they have been through the appropriate training that we have specific to trauma, domestic and family violence, elder abuse and empathy.
But no one is required to have a degree qualification?
Not to my knowledge.
Oh, okay. And roughly what the wage range for people in those roles, especially the extra care team?
I'd have to take that on notice.
Thank you. My last question is the descriptors versus data. The AI tool, which Commonwealth Bank have offered to share, and we've heard about this collaboration from the ABA and other banks here this afternoon. It seems to be a tool that can pick up where abusive language is put in a descriptor box when money is transferred. What other AI lenses are you applying to pick up financial abuse?
As some of the other witnesses talked about earlier, there's other areas that we are also exploring. One of those is in relation to using AI to detect elder abuse where powers of attorney are in place. That is not something that we have in production yet, but we are experimenting with to understand whether it can be effective. With these matters, as I think Ms. Bligh talked about earlier, sometimes the same transaction histories and data can be elder abuse or coercive control in one situation and be, representative of a functional relationship or, principal and attorney relationship in another. And so I think what is yet untested is just whether, particularly the most recent capability and technology around generative AI, which has different capability to some of the previous modelling that we were using. Whether that technology is able to really detect quite subtle patterns of behaviour and combinations of patterns of behaviour that might provide what we call typologies, which are like scenarios. So that is what's really important to test. I think there's an opportunity also in relation to the coercive control legislation in New South Wales to do more in this space to see what new technology can actually pick up. It is going to be challenging, but I think that we welcome that challenge, and we really want to explore what can be possible that will then enable us to think about what are the indicators of, in the case of coercive control, where it is a criminal act now, to give us enough suspicion that we're then able to report it. And I think that would be, a great step forward. If that's
off the individual who is being abused.
It may well do, yes, although one thing that we really need to keep in mind is the safety
of
the individual and even if consent isn't required in certain circumstances because it's a criminal matter that we have suspicion of, it's still really, really important that we are, in touch with and think about, what the victim survivor's situation might be.
And may I just add to that, the success of our own abusive messaging program and the AI model there has been the overlay of human eyes. So whilst that model is identifying about 1,500 high risk, if we call them high risk, where they meet the parameters of the model instances per year, we're finding that there are quite a number of false positives within that space, and where
so no robo-debt for Commonwealth Bank. You're going to make sure you have some people involved in the decision making.
Yes, human in the loop, I think, is important.
And also, it's also important because that human then has an ability to look at the customer's banking profile in totality and then reach out to the recipient to have a conversation with them, not only from a safety perspective, but so that they're aware of what additional support is available to them. So that's been a critical part of the success of that program.
If I can just roll back to you said 8 languages.
Yes.
Do you know what they are?
Yes, they include Arabic, Farsi, Urdu, Bengali, Hindi, Turkish, Hebrew and Swahili.
Okay, and that was determined by what?
Those are the languages that are spoken by the employees that we've recruited into that team.
Okay, and is that connected to the profile of your customer base? Or is that just a happy accident?
It is a happy accident, but it is actually supporting us having conversations. Particularly, we've heard today about the impact of financial abuse in certain Southeast Asian countries, and so that is helping us build relationships with those communities and to develop not only support materials but also to partner with some of those under our CommBank Next Chapter innovation program to develop more innovative ways of identifying, supporting and protecting.
So that's people speaking and responding in real time. What languages are documents available in?
Yes, so we actually have a number of documents. So in particular, and I've got an example here, identifying financial abuse flyer, which is a 2-pager, which talks in very simple language and it's designed for individuals about what is financial abuse and where to go for support. So I would have to double check my numbers, but I thought it was about 18 languages that is available, and that's on our website.
Right. We might get that on notice from you. Do we give Senator Pratt a call? Because she's hanging on the end of the line there. Thank you. Senator Pratt.
Can I ask? Thank you. Can I ask in terms of enduring powers of attorney, whether we need more legal mechanisms that hand over less control and we're able to develop with today's technology banking products that provide a better in-between space with more transparency? Where might new technology and law reform take us in terms of being safer and more confident in enduring powers of attorney?
Firstly, I'd say that enduring powers of attorney are obviously a very important instrument to ensure that, and broadly speaking, are used to great effect and the advantage of all concerned in many cases where a person is incapacitated in some way. We know through this work that there are instances where those powers of attorney are abused by the attorney themselves or other family members who are influencing that attorney. I think there's been, I won't labour this point, there's been two very important changes that I think has been pointed out by a number of submissions around harmonising enduring powers of attorney. At the moment, the methods of operation, because they are state-based, are complex and different, and that makes it harder and in some ways, more open to abuse where they are different and where there is no national register, where banks and other institutions find that it's difficult to, particularly where someone is incapacitated and you can't speak to them directly because they're a protected person, to understand whether the power of attorney is valid, has not been revoked, is not operating within other sort of instruments. So in saying that, I would say that's, I think, one of the most important things that we can do. There may be other product innovation that could be supportive, but I would say where there is a perpetrator who is determined to abuse, then one of the other things that can really help us is that where we do have suspicions, we're more easily able to report that to the right agencies. And I think, as has been detailed in other submissions, whilst that is available to us in relation to public trustees or age and elder discrimination agencies in some states, it's not available as a remedy for us to report in other states, even where we might have suspicions and we then cannot, the protected person is not able to give consent, and the attorney who's committing the abuse is clearly not going to, it's not going to be in their interest to let us give us consent to report or consent to make other arrangements. So I think they are the most important changes that could be made in this space.
Just on the capacity piece, in March of this year, CBA actually established a capacity referral pilot where if one of our frontline team members suspects that there could be potential elder financial abuse, particularly at the hands of a power of attorney, that we are able to refer that particular customer matter to one of three agencies, being the Age and Discrimination Commissioner in New South Wales, the Human Rights Commission in the ACT, and the Office of the Public Guardian in Queensland. And as of the 27th of June, we'd made 11 referrals to those organisations.
Thank you. Who else could we be working with rather than just, for example, giving a family member or the state a enduring power of attorney? It's pretty easy to take over someone else's bank accounts because they need you to. But, should that be possible, or should there be other banking tools available that have greater transparency attached to them before you go down the path of enduring power of attorney? So, for example, if you're supporting a family member with addiction and so they give you their logons or something and say, look, please stop me from spending all my money. They're pretty difficult situations to be in, but you not necessarily want to go down an enduring power of attorney path. What kind of support and banking products are available, particularly, for example, for people with addiction? The cashless debit card and the smart card are innovations of government, but they're not broadly available banking products that you can opt into, or, for example, work with a financial counsellor to, consent to having more control over your finances by a third party?
Look, I'd say that there are, Senator, methods of operation that are present in current, accounts that can support, and certainly some people use those with third-party authorities on accounts, and so, but I guess many of those same instruments can be the instruments of support, but can also be instruments of abuse. When it comes to, alternate things like cashless debit cards, etc., that is something that we're not able to provide that kind of product, and I think we're very mindful that there's a balance of agency that needs to be considered here. I know merchant.
If someone wants to opt into a cashless debit card type arrangement with merchant code blocking on it, why shouldn't it be a mainstream product? And I would note, for example, the Commonwealth Bank does have a large presence in remote Indigenous communities, both inside and outside the Northern Territory, where you would see, I guess, the variation in banking practices because of their historical existence of the card or its removal in other places.
Yes, so if we think about agency, one of the options that we do offer to customers currently is through our Next Chapter team is to actually have gambling blocks placed on debit cards, which is at the request of the individual. So for us, agency is an incredibly important part, and obviously we know that that is one of the principles that underpins safety by design is that individual ability to make decisions about your own finances. So that's what we see and we have adhered to as part of our gambling block process. More broadly, our products don't currently allow for merchant code blocking. I probably wouldn't have enough information to say what those potential implications of that could be beyond the agency.
And look, I think one of the things that other submissions have talked about is it's an area where there is lots of data issues in relation to being able to get appropriate merchant information in relation to exactly what types of products we cannot get at the moment. Say for example, it's a merchant like Woolworths or even a pub where you can't see the underlying data of what someone is actually purchasing, like the product or unit level data. That's not something that's available to us right now, and that means that gambling is clearer in a sense because we can identify specific merchants where merchants provide broader products. If you don't have the product or unit level data, then it's really difficult to provide those kinds of blocks in a meaningful way that then don't have unintended consequences.
Last question, Senator.
Yes, I can totally understand that, but surely there should be a possibility, for example, to split your money as the government did so that a large portion of that money has a block on it for alcohol, gambling or even cash withdrawals.
As I said, I think this is an area where there is a lot of both issues in terms of understanding how that would operate in practice with thousands and thousands of merchants across nationally, and also I think the matter of then agency around how you would sort of put that into practice.
Do you think, though, that some people are taking on responsibility for other people's bank accounts because they don't have that level of agency inside the system currently to be able to say, I want to commit to blocking these transactions and I need support to do that. It's very much an all or nothing situation currently.
I would agree that there is situations where there are products that might be beneficial in some way, and then in other ways they can be used where there is disadvantages. And so for every product, even things like the products that we have now, you can set payment limits. There's certain blocks that you can put on those accounts around international transactions, etc. So there is instruments that are available now within accounts that we have, and even with those instruments and methods of operation, they are still open to abuse. And so I agree that it's a very it's an intractable problem. I don't think we know quite what the solution is, but I think that there's opportunities to keep trying to innovate and balance that context of agency and people, being able to decide in advance, what they might need for themselves or someone that they, care for, that might support them through, difficulties around addictions, etc.
Yeah, but in that context,
we probably need to stop there, Senator Pratt, because we're at time, and I think we've got a couple of questions from from Miss Mascarenhas.
Okay.
Thank you, Miss Mascarenhas.
I just wanted to sense check the numbers of financial abuse, and I think that the NAB indicated that for their stats, it was around currently 200 calls a month, and so I don't know if that's necessarily 200 clients or 200 calls, but at the moment you guys are actively managing 350 cases?
That's specifically in hardship in relation to credit. So Angela can talk about then the interactions that we have at Next Chapter, which might not be related to credit. As I said, they're people who call in and want support from us in various different ways, which may include a referral into the hardship team.
So in a financial year 23, we had around 22,000 customer interactions through the Next Chapter and community wellbeing teams. This past financial year just gone, that has increased to around 25,000. And we
did you say transactions, so not
interactions?
So does that mean individual or clients?
So what that covers is individuals who contact our Next Chapter team. They can do that via phone or chat. It also includes the interactions that our frontline staff are having with customers experiencing vulnerability and seek support from the Next Chapter and community wellbeing teams.
And how many would be Commonwealth Bank customers, since you guys are very lovely in offering this service to other customers as well?
Yes, I'd have to take that question on notice, but the overwhelming majority obviously is CBA customers.
It's clear that CBA is doing lots of innovation and leading in this space. It's evident of that. One of the things that Senator O'Neill was talking about is the use of AI to predict financial abuse, and we hadn't heard that from anyone until you guys were talking about financial abuse for elder abuse. And the thing that I love about that concept is often technology is used as something that's disadvantaging our elderly population, but this is an example where we can be using AI tools to actually empower these people that aren't necessarily going online and checking their transactions and then going, oh, look, my son's taken, another $5,000 out of my account. Who knows what that was for? So congratulations on that. I'm wondering.
Just note we're exploring that and hoping that it's successful. So it's probably too soon for congratulations.
But you do have a relationship with the University of New South Wales.
Yes.
So there's an academic rigour to this, and you've got some pretty good research going on there. So that's also part, I think, of something that's happening at Commonwealth Bank. Yeah.
The fact that it's being spoken about is great. One of the things that I'm interested in understanding is why CBA investing a lot in this space, and because for some people it would be kind of like what's the commercial advantage? Why are you guys looking at leading in this space? And I think for one of our banks, they're kind of like, we're happy to be a first follower, but not necessarily a leader. And so what's the imperative?
So happy for me to take it, is so in about 2015 we started to really look into the financial abuse space. And I do want to acknowledge the work of both Catherine Fitzpatrick and also Rebecca Glenn, who used to work for the Commonwealth Bank and were part of some of the very early foundational work in this area. So for us, we recognise off the back of the work that Catherine and Rebecca and our partnerships with UNSW have really resulted in is an awareness of just how far-reaching the consequences and the impacts of financial abuse are. So from our own research, which we conducted last year, we know that over 40% of the Australian adult population has experienced financial abuse or knows somebody who has. And if you think across our 12 million retail customers, we know that that is going to be impacting a significant number of them. So we recognise that as Australia's largest financial institution, that we have a role to play in addressing this scourge. And so for us, that is the driver. The driver is we recognise that we are a leader within this country. We know that we have one of the largest customer bases, and that we know that our products and services are used by a significant number of the population. So for us, we recognise that we have a role as part of that whole of community response.
And that also drives us to experiment in other product innovations. So, for example, we do have a home loan product called Property Share. It enables customers to have a home loan account that is tenants in common rather than joint tenants, and therefore if a customer at the outset has a larger deposit, for example, then the property, the asset and the loan account is able to be recognised as being split into various percentages. Separate accounts are then set up, and then customers can contribute separately to those payments, and that whilst that product also requires cross guarantees to enable us to secure the asset, what it does do is importantly provides transparency on who has contributed to what, a pathway in, a pathway out, and where that property, for example, it might be a family court order or another sort of negotiated settlement where the property is sold and there is equity remaining. It enables us also to clearly see what the proportion of that equity is and allocate that and make sure that the right people get that product.
And that works in multi-generational loan structures as well?
At the moment, multi-generational. So if you were talking about things like the Bank of Mum and Dad, where they would be providing part of the deposit, for example.
Some community practices of multi-generational living in one property.
It's a property share product. So what it would enable you to do is sort of split the share between different parties. Yes.
Could be 3 people. Could be 4 people.
I'll have to take that on notice because I'm not sure how many it would be, but conceivably, yes.
Yeah.
And it is, I think it is something that we should be, that's potentially needs to be talked about more across the industry, those types of products at origination in lender and broker conversations.
So could I indicate there'll be some more questions on notice? Some of them will go to the sociological challenge of actually responding in a trauma-informed way. It's not training about trauma, but actually deep practical understanding of it. So there's 2 documents of that coming. There will also be the economic abuse reference group, which we're going to ask you to really interact closely with, look at each of the case studies, give us a sense of what you would be doing in that circumstance, and the recommendations. I'd also just like to go to the intersection between Commonwealth Bank writing its own loans as opposed to brokers writing loans. And this is a question will go on notice to everyone from all of the banks. What percentage of broker written loans end up with economic abuse challenges or partner abuse challenges by comparison to the ones that are written in-house? And if we can also go to the risk to customers that's embedded in the decision by the Commonwealth Bank to change their payment structures for post-Hayne, there was a Royal Commission opened up, a pretty clear line and said the commissions need to be capped. CBA has changed its policy around that. I know that Mr. Longo, as the chair of ASIC, was very, very negative in that. How do you believe that, the fact that people are going to be paid, increased caps would allow a manager on a $200,000 salary to earn a maximum of $360,000 with a bonus of 80% of the base pay. How much risk is embedded in that, and have you done any audit about, the risk of that particular decision in terms of generating economic abuse?
We take responsible lending and compliance with those policies incredibly seriously. That decision that we took to change the lender rem of certain numbers of our lenders very, very seriously and with due consideration. It was considered by senior management and the board. We recognise that we were competing against the broker domain for top lenders, and that whilst we were never going to be able to compete financially to the same level in relation to competitively for staff, we wanted to be able to provide more variable pay for our lenders.
Yep.
We feel that we can do that in a way where we can monitor the activity, and we do, and monitor the activity and ensure that there is no increase in misconduct. There may always be individual cases, but we have a number of frameworks which have monitoring, quality assurance. My team has a data-led approach where we run 80 indicators of compliance with credit policy and legislation over all loans that are funded every month, and then on a risk-based and random-based approach, open files and look at those files. And so, as I said, it was...
Should be able to give us some pretty good information on notice then with regard to that, and if there's more risk embedded in certain, in loans written by brokers as opposed to in-house. I do note that I don't think you were able to give us a number of what people are paid in your service response line in terms of looking after people, but the average has been between 80 and 120,000 based on the evidence from the other people competing for talent in the same place, which is very, very different from $360,000 for the people who are writing the loans, people who are cleaning up the mess of the loans where, financial abuse occurs. Are at a very different pay scale, very heavy-duty work.
And there is a wide range in those pay scales of lenders. That's certainly not I couldn't tell you what exactly the top salary is, but it's a very broad range across our lenders, and it's also a range of salaries in other parts of the bank as well, including in our customer care teams, depending on the experience and qualifications.
So, look, many more questions on notice. If it's possible, if you could provide those to the committee by the 5th of August, I'm going to thank you for being here today. This will actually conclude our session today. Thank you to all the witnesses who've appeared. Thank you for their evidence today. Can I also thank Broadcasting, Hansard and the Secretariat for their work in preparing for today and keeping us on the road, literally. So time for us to depart and catch the plane. So this meeting is adjourned.